Welcome back to Day 2 of the SEC Speaks in 2025. A reminder that the views and comments expressed at today's program are those of the individual faculty and not those of the SEC or PLI. Now, without further ado, I'd like to welcome Sam Walden, who will be co-chairing Day 2 of the program. Sam is the acting director of the SEC's Division of Enforcement. He joined the SEC as the division's chief counsel in March 2022. He was also previously assistant chief counsel and a staff attorney in the Division of Enforcement. He has also spent time in private practice, including as a partner at Proskauer Rose and Baker Botts. He received a BA in economics from Virginia Tech and a JD from the University of Texas School of Law. It's my pleasure to turn the program over to Sam.
Thank you. Good morning. Good morning, and welcome to Day 2 of SEC Speaks. I have to start off with some housekeeping matters. First, for members of the media, if you have any questions about anything that any of us say or any of the other panelists say during the day, please reach out to our Office of Public Affairs. They can help get you the information that you need. And then also reiterate the disclaimer. I think I'm doing it for the entire day. The views expressed by me, panel here, panelists later today, they're all in our official capacity. They do not reflect the views of the commission, commissioners, or staff. So with that, let's get started. We have a very full agenda today, starting with a very full enforcement panel. Please consider the comments of these panelists. I think that's the magic language I'm supposed to say. I'll introduce our panel in just a second, but I want to start with a quick thank you to our two special guests at the very end. We are incredibly fortunate to have not just one, but two former commissioners with us as commentators for this panel, Commissioner Roisman and Commissioner Gallagher. The plan here is that we'll leave about 10 minutes at the end of our allotted time for them to pepper us with questions. Please go easy on us. And so with that, kick things off and get it started. So on this panel, we are going to try and answer the question, what should you expect from the Division of Enforcement going forward? See how we do. Maybe come back in a year and you can and grade us. So the panelists will give greater detail on what that's going to look like. I'm going to start with some high-level observations to kick things off. So first off, obviously, there are going to be some changes. There have already been some changes. We have four deputy directors instead of one. Yeah, there have been other structural changes that I'll talk about a little bit more in a few minutes. But I do want to give a word of caution. I do think that some of the expectations, predictions about enforcement going forward are probably overstated. I don't think that the changes are going to be nearly as stark and pronounced as some are predicting. We're definitely going to be making changes about how we allocate resources. Resources are always limited. There are going to be different priorities, but we are going to continue to focus on the core areas of the enforcement program. So insider trading, accounting and financial disclosure fraud, offering fraud, market manipulation, breaches of fiduciary duty by investment advisors. Those are all going to remain key areas of focus for us, as they always have been. And there probably will be, I would expect, a greater emphasis on individual liability, but that's always been a focus, so I don't see that as a huge, huge change. At the same time, I think that there are some things that are not going to change and have not changed. And one thing I want to highlight that has not changed, and that is the hard work, commitment, and dedication of our staff. You probably heard that the SEC's headcount is down about 15% since the end of the fiscal year. Enforcement, not immune to that. Our numbers are down, and we lost some really good people. Not going to deny that. But I want to say a few words about the 85% who remain. Every transition is challenging, but they have faced challenges, distractions, criticisms over the last several months. And each and every day, they just show up and do the work. They do the work of the division and of the commission, and they do it so well. We are not perfect, no one is, but it has been awesome and inspiring and incredible to watch. And I am so proud to be able to call them my colleagues. And for the former staffers, alumni in the audience, you'd be proud of them too. So before I turn it over to the panel, I just want to give a little more flavor to the organizational changes that we've gone through. We recently did a reorganization where we, in enforcement, we reduced some of the reporting lines to better create a more unified nationwide enforcement program, and also to ensure that enforcement and exam efforts are consistent, fair, and applied equally across the nation. At the same time, the Commission reaffirmed the importance and its commitment to the regional offices. That's something that I think there's been some confusion about. There should not be confusion about that. So there have been some changes. We're got it up and running. It seems to be working well so far. Enforcement staff now report up through one of 4 deputy directors. 3 are focused on geographic areas. 1 is focused on specialized units. And then finally, Chief Counsel, Chief Litigation Counsel, and the Chief Accountant all report directly to the Director of Enforcement. So with that, I will turn it over to our panel. Quick introductions. Antonia Apps is the Deputy Director Northeast, which includes Chicago, Boston, New York, and Philadelphia regional offices. Jason Burt is the Deputy Director of the Specialized Units. Sylvester Fontes is the new Enforcement Liaison. Nick Grippo is our Chief Litigation Counsel. Can't see. Nika Hackworth-Jones is Deputy Director Southeast. That includes the Home Office, as well as Miami and Atlanta. And Kate Zolads is Deputy Director West. And that includes Denver, San Francisco, LA, and Fort Worth. And I will start us off by turning it over to Sylvester to talk about his new role.
Thank you, Sam. As Sam mentioned, my new role is National Enforcement Liaison. So what exactly does that mean? It is a newly created role. It is intended to strengthen our relationships, the enforcement division's relationships with our partners at the federal, state, and local levels. Right now, one of the things I've been working on is just trying to understand how those relationships are working, and just as importantly, how they may be improved. As you know, all of you know, we work closely with U.S. attorney offices, state securities divisions, FBI, IRS, et cetera. Just how exactly are those relationships working? We have, as Sam noted, we still continue to have the regional offices and we have the units. They all interact slightly differently with all of our partners, and trying to understand how that is happening is important to learn as a division. We have variances. There are some leading practices that I think we can nationalize. Digging through the data, not a surprise, there's some partners that we do a lot of work with and some that we do less work with. And a running question in my mind is, does the data tell a story? Again, some offices, U.S. attorney offices, we do a lot of work with, others not so much. An obvious question is it a case of out of sight, out of mind? So those are some of the questions that I've been thinking about working on. We have, within the last few weeks, I have interacted with states primarily through the North American Securities Administrators Association, NASA. Plan on continuing to do that in June of 2025 in Maine, the next regional conference. we'll look to attend more of those regional conferences going forward. We also, for those of you who are not aware of it, there is this thing called the Interagency Securities Council that was created about a year ago. The division director is the chair of that council. So Sam is the current chair of it, and Adam Anisage leads those efforts on behalf of the division. It's a great forum. It meets quarterly, and it's a place where we all exchange views and data on latest frauds, what's happening out there, and best practices in terms of investigative tools. So for those of you who are not familiar with it, again, just feel free to call me up, let me know, shoot me an email. Happy to connect you with that and get you on the list. One thing that we will continue thinking about and internally is referrals. When do we make them? When do we receive them? Potential areas for improvement. The most important thing I want to convey here today is we do welcome feedback from you, members of the bar, compliance officers in some cases, about how your interactions with the staff are going, and overall, but specifically in those matters where you are interacting with multiple regulators at the same time. That's all I have, so thank you, Sam, for the chance to introduce myself and new job. Thank you.
Well, I'm up next. Good morning, everyone. It's a pleasure to be here. Thank you for joining us today. Through investigations and litigation, the Enforcement Division continues to protect investors and to safeguard fair, orderly, and efficient markets by holding bad actors accountable. We are still the cop on the beat for securities markets. Over the past few months, we have brought matters cutting across our perennial areas, and these are the areas that Sam mentioned in his introductory remarks, such as offering fraud, insider trading, accounting and financial fraud, and breaches of fiduciary duty by investment advisors. Two specific areas on which we continue to focus are fraud targeting retail investors and fraud targeting seniors. I would like to highlight one example of a recent enforcement case involving both retail investors and retirees. In January 2025, the SEC announced Settled Advisors Act charges against Transamerica Retirement Advisors for failing to disclose conflicts of interest in connection with the referral and rollover of investors' retirement assets to thousands of Transamerica advisory accounts between 2017 and 2022. According to the order, starting in June 2017, Transamerica paid incentive compensation, such as variable and flat fee payments, first to its retirement planning consultants who referred employer plan participants for rollover consideration, and second, to its investment advisor representatives whenever plan participants completed their asset rollovers into advisory accounts. Transamerica made limited conflict disclosures regarding incentives that it may provide incentives to its advisors. These disclosures were misleading in light of the incentive compensation that the firm was actually paying its retirement consultants and investment advisors for retirement asset rollovers. This conduct involved approximately 7,300 employer plan participants who rolled over approximately $1.2 billion into advisory accounts without disclosure of these conflicts of interest. Transamerica consented to a cease and desist order, a censure, and agreed to pay a $2.9 million penalty. Transamerica also agreed to distribute funds to affected investors. Now, while the division does remain steadfast in its enforcement efforts, you will see some changes in our process. Again, this is what Sam teed up at the beginning of this panel. One recent example is the formal order process. As many of you know, the Commission issues formal orders of investigation that authorize specific enforcement staff to exercise the Commission's statutory power to issue subpoenas and to take other actions in connection with investigations into potential violations of the federal securities laws. In 2009, through regulation, the Commission delegated its formal order authority to the Enforcement Division Director, and the delegation remained in effect until this year. In March 2025, the Commission amended its regulations to eliminate the delegation of formal order authority. Now, formal orders will be authorized directly by the Commission. To be clear, while this is a change in our process, we do not anticipate that this change will hinder the division's ability to carry out its work or execute the agency's mission. The last topic I will discuss is individual accountability. During our investigations into corporate misconduct, we routinely assess the roles of individuals, such as executives, in the misconduct to determine whether charges and monetary relief are appropriate. Some factors that we consider are the culpability of the individuals. For example, did that individual act with scienter? The severity of the individual's misconduct, and the degree to which an individual tolerated illegal activity or, in contrast, tried to prevent the harm from occurring. We also consider whether to seek prophylactic relief against individuals who engage in corporate misconduct. These tools help reduce the risk that misconduct will recur. For example, we look for relief such as permanent and conduct-based injunctions, officer and director and penny stock bars, associational bars, and disciplinary proceedings to suspend or disbar certain professionals, such as attorneys and accountants, from appearing or practicing before the commission. Factors that the division considers when recommending prophylactic relief will vary, but generally include the egregiousness of the defendant's actions, the isolated or recurrent nature of the infraction, the degree of scienter involved, and the likelihood that misconduct will recur. One recent example. In October 2024, the SEC announced settled charges under the anti-fraud provisions of the Securities Act and Section 304 of the Sarbanes-Oxley Act against former executive chairman and principal executive officer of the Peridium Corporation, formerly a publicly traded New York-based telecommunications company. According to the SEC's order, Peridium executives engaged in a fraudulent scheme to improperly recognize revenue, leading to Peridium overstating its revenue by 60% for fiscal year 2018 and by 91% for the first and second quarters of 2019 combined in its financial statements filed with the SEC. The principal executive officer was aware of signs that the revenue was being improperly recognized, but he did not take reasonable steps to determine if that was the case prior to signing these filings in his official capacity. Rather, he continued to pressure his management team to achieve revenue growth that exceeded analyst expectations. The SEC's order required the principal executive officer to cease and desist from further violations of the charge provisions and to pay a $75,000 penalty. The order also required, under Section 304 of Sarbanes-Oxley, that he reimburse Peridium or a successor in interest over $267,000 that he received as bonus payments. Again, companies act through individuals, and the Enforcement Division is committed to holding individuals accountable for corporate misconduct when the facts and the law support doing so. Thank you for your time today, and I will now turn the program over to my colleague, Jason Burt, to discuss the work of the Division's specialized units.
Thanks, Nika. The highlight out of the gate, I plan to keep things high level as well, and that's for a few reasons. First, in the interest of time, given how many panelists we have. Second, and more importantly, there is a breakout session later this afternoon where the unit chiefs and or deputy unit chiefs will talk about a variety of topics and get into more detail about what the specialized unit priorities are. And then last, just as a general matter, the units are more or less defined by their priorities, and while those priorities do shift, the general mandate of each from year to year stays very similar. So for those of you who don't know, what are the specialized units? The SEC staff has, within the Division of Enforcement, specialized groups that investigate and litigate cases involving particular areas of law or conduct. And these groups focus on particular areas of law and conduct for a very good reason, because it's conduct and law that we see very frequently at the SEC come across our desks. And having staff with the specialized knowledge in subject areas and or investigative techniques that are used to uncover fraud, it creates a streamlined environment for investigations and makes things more efficient and effective ultimately. So who are these groups? So at this point, it is the Asset Management Unit, the Cyber and Emerging Technologies Unit, the Complex Financial Instruments Unit, the Market Abuse Unit, the Public Finance Abuse Unit, And then under my umbrella, but not technically a unit, is the Office of the Whistleblower. And I think as many of you know, the Office of the Whistleblower plays a very important role when it comes to enforcement investigations and rooting out fraud. So I'll take each of them separately in a second, but just from a thematic standpoint, as you're thinking about what cases the units are going to be focusing on into the future, you can probably think about two things. One is, are retail investors involved? And the second is there harm to those retail investors? And then also important is whether or not there's the ability to get money back to those harmed investors to the extent they are harmed based on the conduct of a person violating the securities law. So moving on to each of them in no particular order, the asset management unit. And that is a unit that at this point is under the chief of the unit is Corey Schuster. And that unit focuses on violations of the securities law in the asset management industry, including misconduct involving investment advisors and investment companies. And from a priority perspective, you can look probably best at what is outlined in the examination priorities each year. So they come out in the fall. This last examination priorities came out in the October 2024 period. And they really create a roadmap for what the asset management unit does. And that's by design. A lot of the examination referrals end up in the asset management unit. And just as a general matter, again, when you think about the priorities for the units writ large, you can look to those examination priorities because a lot of the units derive their cases, investigations from those examination priorities. So in the context of AMU, those that you, I'm sure, will see over the next few years is a focus on misappropriation and failure to safeguard assets, misleading strategy disclosures, fraudulent valuations, undisclosed fees and expenses, and prohibited trading practices, including cherry picking and unauthorized principal transactions. And of course, all of these, in some form or fashion, relate to what Sam highlighted as the primary focus of the asset management unit, and that's an investment advisor's fiduciary duty to its clients, including both, obviously, the fiduciary duty derived from the duty of loyalty and then the duty of care. And as Nika highlighted, a recent case, Transamerica, involving the conflicts of interest that the firm failed to disclose, that duty of loyalty is clearly going to be something that the SEC is going to be thinking hard about when it comes to investigating and potentially bringing cases. Going back to the main point in terms of a thematic priority, again, even in the context of breaches of fiduciary duty, the focus from a case perspective and an investigation perspective is going to be in those situations where there is client harm. The next unit I'll mention is the Cyber and Emerging Technologies unit. Laura Delaird is the chief of the C2, as we like to call it. It was formed recently in February of this year, and it consists of many of the same attorneys that were in the crypto assets and cyber unit. This unit is going to focus on a number of things. It is in the process of creating a very good identity in the space of emerging technologies and the misuse of technology to commit fraud. And it's also going to focus on things such as the use of terminology and or excitement around new or industry-changing technology to engage in old-fashioned fraud. So take, for example, when an investment advisor is touting their use of artificial intelligence to make investment decisions, when in fact that investment advisor is not using artificial intelligence to make those investment decisions. A little bit more specific from a priority perspective, we will be in C2 focusing on blockchain and crypto asset-related fraud, combating cyber-related misconduct, including hacking to obtain material non-public information, the use of social media and dark web or false websites to perpetrate fraud, retail brokerage takeovers of their accounts, and then last, ensuring cybersecurity-related compliance by registrants, including their adherence to Reg SP, Reg SCI, and Reg SID. Again, thematically, going back to where I said we will be in the context of the units writ large, we're thinking about all of those things with respect to retail investors and investor harm in particular. The next unit I'll mention is the Complex Financial Instruments Unit. Eric Werner is the chief of that unit. I think many of you are probably familiar with that unit. It has existed for a reasonably long time here at the SEC. It is a unit that focuses on investigations related to complex financial instruments, including, for example, security-based swaps, contracts for difference, non-traded REITs, collateralized mortgage obligations, and a myriad of fixed income products. You'll hear complex, and you think sophisticated investors, but there are billions of dollars invested in complex products by retail investors. The focus for CFI, again, going back to the examination priorities that I highlighted, will include sales practice problems and abuses related to, say, suitability and churning. There will be a focus on compliance with regulation best interest. And then with respect to most of our cases, the units included, there will be a focus on misleading disclosures, particularly related to fees. And in the complex products arena, because of the layers of fees associated with a lot of those complex products, making disclosures of those fees and when and how they're assessed is extremely important. The next unit I'll mention is the Market Abuse Unit. That is helmed by Joe Sansone. And the Market Abuse Unit is the unit, I think, that is probably the most consistent year over year from a priority perspective. It investigates and litigates cases involving insider trading with a focus on serial insider trading and large trading rings. Also has focuses on market manipulation, including cherry picking and front running, on compliance by various market venues with a variety of rules. So that would include exchanges and alternative trading systems. And again, the priorities for that unit have been the priorities for that unit for quite some time, and their use of data analytics is really what drives those cases and those investigations and identifies those wrongdoers that unit focuses on. The last unit I'll mention is the Public Finance Abuse Unit, and Leanne Gaunt is the chief, Rebecca Olson is the deputy, and the unit investigates cases related to municipal bond securities. And for those of you who don't know, municipal bonds are primarily held by retail customers. Over 45% of households directly hold municipal bonds, and then over 23% is held in the context of various funds. So again, this unit focuses on investigations and litigations related to municipal securities, and they will focus primarily on offering frauds, as you can imagine, to unsophisticated retail investors. There will be also a focus on the municipal advisors and whether or not they are registered, and the duties that they have, which are very similar to the fiduciary duty that exists between an investment advisor and its client. So that will be a focus of the unit moving forward. And the last thing I'll mention is the other group that's underneath my umbrella, the Office of the Whistleblower, and the acting chief of the Whistleblower's Office is Jonathan Carr. As we move forward in time, the focus in the Whistleblower's Office is going to be on moving award and denial claims as quickly as possible, and as I'm sure some of you have seen, reducing submissions from serial frivolous submitters. So to close, just when thinking about unit priorities, going back to where I started from a thematic perspective, think about what could impact retail investors the most and what has the possibility of creating investor harm, and that's where the units will be focusing. And with that, I'll turn it over to Kate Zoas to talk about cooperation and a few other items.
Sam, do we have to wait until the end? Or can we jump in?
Should we wait to the end?
Dan wants to know.
Yeah, sorry.
I'm not
yeah.
getting crossways with enforcement.
Is that okay? Is that
tell
okay,
me.
Mr. Geller? We wait till the end?
Well, do you want us to wait if we have a specific question?
Okay.
First of all, Jason, amazing, like NPR voice there. That is so soothing. And if I shut my eyes, I was sitting in a room with Troy Paredes. And if you guys know Troy, you'd understand what I was just saying. Same exact voice. I'm just curious on the special units. We have so many now, and I remember I was the acting co-director of TM when Kuzami came in and did this, and I had a spirited debate with him on the creation of the specialty units, and I've seen the good and the bad of it, and the worry then was, oh my gosh, what are you saying to the rest of the population in enforcement, that they're not specialized, or do they get the dregs? And I know it's probably too early with Chairman Atkins in to really answer the question, but is there like a continuing process of saying, let's retire this specialty unit or bring a new one on board? Is there a formalized process, or is it just kind of sensing what the market conditions are?
Yes, so I think you're right to say it is early on in Commissioner Atkinson's tenure, so it's a little bit difficult of a question for me to answer. I mean, historically, I'm actually going to turn to Sam if he has any thoughts in terms of how things, only because I haven't been a part of the ebb and flow
Right.
of the dismantling and or institution and or rebranding of units, but I don't know, Sam, if you have anything to...
No, I think that's right. I mean, it's too early to tell, but I think that is right. I think,
Yeah, my one, when I was on the commission, my one concern with it is you get what you resource, right? And so sometimes you have, and the asset management group, you know, Julie Reevy was here, she'd throw a tomato at me. You know, you have this group and they're set off to go find stuff, and, you know, depending on what is happening in the market, there may be a high level of compliance during any given time, and you have folks who are looking for non-compliance, and it's hard to bring cases. And you know, the big fight when I was there was on 20647 and CCO liability, and I mean, there's unfortunately, I thought, bad cases brought at that time there, and I worried that it was simply because we had that specialty unit and they were, you know, trying to find things, you know, in that space that weren't sort of right over the middle, right over the plate.
Yeah, and that, I mean, obviously that's a legitimate concern. I mean, from my experience, there has been, at least during my tenure, both as a staff attorney in a specialized unit and a supervisor in a specialized unit, a relatively significant flow of potential cases, primarily driven by the exams group and the exam referrals that come through. And I'm sure, and not to my knowledge, but I'm sure there have been times when people are looking more proactively to find cases, but from my experience, it has been relatively reactive in terms of the cases that come in the door, and whether or not we are going to pursue things is driven by the priorities of that commission, and whether or not we feel at the end of the day that's something, an investigation the commission is going to be interested in supporting if we were to pursue a settlement or litigation. So understand the question and appreciate the ebb and flow, and what might result from, you know, there being more cases at one point versus another. But I guess in my experience, that's how it's played out.
And look, that's a management issue. I think that, I do think that it's something that folks are aware of in enforcement, and you have to be careful of it. The flip side is you have folks who are more expert in areas, they're focused on an area, and so to the extent there is something to see out there, we're more likely to see it. I mean, it's a balance.
Well, yeah, and they can also discern what's a big deal and what's not, right? I always push, by the way, for a broker-dealer unit. As with most things, I lost at my time on the commission on that vote, but it would have. I do think without it, it still works pretty well with you know, the specialized teams and exams, you know, the Chicago team and everything else. They're pretty sharp on those issues, and if they're pulled in, you get that same level of expertise. But yeah, having nuanced understanding of these sort of core markets and market participants, I think is it's a real plus. And it's just a matter of how do you maintain it and make sure it's tuned up. So anyway, sorry to cut in the middle, but it was
It's fine.
really interesting to hear about all the groups.
I think I'm up next. So as Sam mentioned, there are a number of things that aren't going to change, and so I'm going to talk about a couple of those. So we're going to continue to reward self-reporting, cooperation, and remediation. And we may even decide, in appropriate cases, to not bring any enforcement action at all where these steps have occurred. And I would expect that, at least in some cases, issues that are identified and fully remediated in an examination may not even result in an enforcement referral. I think we're also going to be less focused on violations that don't involve fraud, especially where the conduct's been fully remediated. I don't want to overstate this. This is not to say that we're not going to look at potentially violative, non-fraudulent conduct that's severe, long-term, or ongoing. I think this approach is actually consistent with the considerations that are set forth in the enforcement manual. Section 2 has a number of questions to use in determining whether to open an investigation. And the very first question that's posed, do the facts suggest a possible violation of the federal securities laws involving fraud or other serious misconduct? The enforcement manual goes on. If yes, is an investment of resources by the staff merited by the magnitude or nature of the violation, the size of the victim group, the amount of potential or actual losses to investors? Is the conduct ongoing or within the statute of limitations period? Is there a need for immediate action to protect investors? Does the conduct affect the fairness or liquidity of the U.S. securities markets? Does the case involve a recidivist? Has the SEC or the Enforcement Division designated the subject matter to be a priority? Does the case involve a potentially widespread industry practice that should be addressed? Is this a good opportunity to work in parallel with other civil and criminal agencies? So I think those questions that are asked in the enforcement manual are going to be the types of questions that we're going to just continue to ask ourselves when we're looking at cases. So with that, I'll turn it over to Deputy Director Antonia Apps to discuss some changes to the Wells process.
Thank you, Kate. So this commission values due process, fairness, and transparency, and a robust Wells process is central to advancing those goals. Having an open, informed, and thoughtful dialogue between the government and defense counsel produces better outcomes, particularly in complex cases. So from our perspective, from the government side, we want to make sure that we're getting it right, confirming that we've not overlooked important evidence or misunderstood the significance of the record we've developed, or proceeding on a legal theory outside the confines of our statutory authority, or simply that we should not, in the exercise of our prosecutorial discretion, proceed with an action. And I know from my experience as a defense counsel, having an opportunity to be heard after being informed of the charges against your client and the evidence that supports them is fundamental to effective advocacy and a fair process. So under current SEC leadership, we do expect to grant Wells meetings with division leadership if parties request them. And when I say division leadership, I'm talking about the director and/or one of the 4 deputies on the stage here today. But it's important to take a moment to clarify what this does not mean. It does not mean that defense counsel are suddenly entitled to multiple meetings with leadership of the division. You should not expect to be afforded a meeting with division leadership at every juncture of an investigation, such as whether staff should send out a subpoena, whether they should take testimony from witnesses, or issue a Wells notice. Now, please know that staff regularly raise up many of these requests with division leadership, and we do weigh in internally. But that's a very different situation from agreeing to meet with defense counsel multiple times throughout an investigation. So absent exceptional circumstances, division leadership does not intend to engage directly with defense counsel until the staff has completed its investigation and the issues are ripe for discussion based on a fully developed factual record. So one question that often arises is what information defense counsel should have access to in connection with the Wells process. As head of the New York office, I had always encouraged staff to provide defense counsel not just with the legal theories, but the evidence the staff believed supported those theories. Many staff prepared PowerPoint presentations, which they walked through with defense counsel. They allowed counsel to come in and review testimony transcripts or key documents in advance of preparing for a Wells meeting and in connection with preparing their Wells submission. So current division leadership supports a more open and transparent practice, such as I have just described. The purpose of the Wells meeting and the Wells process is to make sure that the Commission understands the position of the individual or entity against whom enforcement intends to recommend an action. We recognize that defense counsel will often need access to the record evidence in order to have that meaningful dialogue about the issues. Division leadership in the Commission benefits from counsel who are fully informed and can properly advocate for their clients. Now, there are, of course, times when there are constraints on what we can provide. We have statutory restrictions around whistleblower information. There may be programmatic concerns to sharing certain information, such as when we work in parallel with criminal authorities, or simply have other sensitivity issues. But in general, we will try to give us access to the record so that defense counsel can have a meaningful dialogue with division leadership in the Wells process. Now here again, based on recent requests the staff have received from all of you, or maybe not all of you, for some of you I should say, I do feel the need to explain what access to the record does not mean. It does not mean that defense counsel is entitled to regular updates from the staff as their investigation proceeds. SEC staff do not have an obligation to report to defense counsel about every investigative step they're taking. We may not share with you during an investigation the names of witnesses we're talking to or the nature of the documents we're subpoenaing. SEC staff cannot be put in the difficult position of having to update defense counsel on their investigative plan at every step or every juncture of the investigation. So with that, let me turn it back to Sam, who is going to address the topic of individual reentry.
Thanks, Antonia. Just a few words about the reentry process for individuals who are subject to associational or penny stock bars. First, we now have guidance on sec.gov about that process. The guidance lays out the criteria that the Commission will look at in considering an application, and will also lay out what the process is and how you go about applying. Second, and relatedly, just last month, the Commission granted 2 applications for reentry, one from a associational bar and the other from a penny stock bar. Both orders are on sec.gov, and hopefully all of that is helpful. The first one, Roger Denha. In 2018, Mr. Denha consented to an order that included a collateral associational bar. The Commission granted Mr. Denha's application to associate with an investment advisor that had agreed to put in place a number of supervisory controls that were reasonably designed to prevent the conduct that had given rise to the 2018 order. The Commission found that Mr. Denha's application was not inconsistent with the public interest. And then second, Manish Singh. In 2017, Mr. Singh agreed to an order that included a penny stock bar with a 5-year right to reapply. The Commission granted Mr. Singh's application to resume participation in the offer or sale of penny stocks. The Commission found that based on Mr. Singh's representations in his application was not inconsistent with the public interest, and granted his application. Again, both those orders are on sec.gov, and with that, I'll turn it back over, I guess, now to Nick.
Yes, thank you, Sam. I know we're pressed for time here, so I'll try to be brief. I'm going to borrow 1 or 2 minutes from Dan, from the time he took with the question earlier.
I see my time.
Yes, thank you, Dan. So the Enforcement Division continues to handle a robust and diverse docket of litigated actions in core areas of our program, including many of the areas we've already discussed this morning. I just want to highlight a few of the significant litigated actions we've filed in recent months, successes we've had at multiple stages of litigation, from the pleadings phase to remedies, and of course, trials. But first, just brief background. I know most of you are familiar with our structure, but as a quick refresher, the division's litigators work in the trial unit and are based in the home office and the various regional offices around the country. They work closely with investigative staff in each region, the specialized units, and the home office. As a general matter, most of our litigated actions in recent time have been filed in federal district courts across the country. And just as a couple of examples, I'll just touch on a few from the last couple of months. So in late April, we filed a litigated action against 3 Texans in connection with a $91 million Ponzi scheme involving more than 200 investors. This is SEC versus Alexander, Welsh, and Connor. According to the SEC's complaint in that action, between May of 2021 and February of 2024, defendants Alexander and Welsh operated the scheme through a trust controlled by Alexander. They falsely represented that investors would receive guaranteed monthly payments of between 3% and 6% a month, with the principal investment to be returned after 14 months. But according to the complaint, defendants Alexander and Welsh held the trust out as a highly profitable international bond trading business with billions in assets, and told investors that the monthly returns were being generated from the bond trading and related activities. But as alleged, The third defendant, Connor, funneled more than $46 million in investor money to the trust through a related investment program that he operated. Meanwhile, according to the complaint, the trust had no material sources of revenue. The purported monthly returns were actually Ponzi payments, and the defendants misappropriated investor funds for personal use. Earlier in April, we charged in a different litigated action the founder of PGI Global in connection with a $198 million crypto asset and foreign exchange trading fraud scheme. The complaint there alleged that the defendant offered and sold PGI membership packages, which he claimed guaranteed investors high returns from PGI Global's supposed crypto asset and foreign exchange trading, and offered members multi-level marketing-like referral incentives to encourage them to recruit new members. However, as alleged in the SEC's complaint, the defendant misappropriated more than $57 million in investor funds to buy Lamborghinis, items from luxury retailers, and for other personal expenses. And then back in March, we filed a litigated action against the defendant and his investment advisory firm, Upright Financial Corporation, in connection with a multi-year fraudulent scheme to operate the mutual fund Upright Growth Fund as a highly concentrated fund in violation of the fund's investment mandate and the defendant's fiduciary duties. So I encourage everyone to take a look at those complaints for more details on those actions. We've also had success in various stages of litigation once actions are brought. So just one example of a recent matter at the pleading stage is the case SEC versus Andrew Left and Citron Capital. This is a fraud case pending in the Central District of California against short publisher Andrew Left that alleges that the defendant made material misrepresentations and omissions in online research reports about his trading intentions regarding the companies he was reporting on. In late April, the district court in that case denied the defendant's motion to dismiss, finding that the SEC had adequately alleged scheme liability and false and misleading statement claims. The decision includes that the SEC had sufficiently alleged that the online reports at issue contained misleading half-truths consistent with the Supreme Court's recent Macquarie decision, and the court also agreed with the commission that the defendant's conduct was not protected by the First Amendment. Our litigators have had success in obtaining or defeating summary judgment in a broad range of cases. And of course, we have continued to try cases and have success at trial. We've conducted dozens of trials over the last few years and have obtained favorable outcomes in the majority of them. Just a few weeks ago, we secured a jury verdict in Boston Federal Court against investment advisor Jeffrey Cutter and his advisory firm Cutter Financial Group, finding that the defendants were liable for violating Section 2062 of the Investment Advisors Act of 1940, which, as many of you know, prohibits engaging in any transaction, practice, or course of business which operates as a fraud or deceit upon any client or prospective client. The jury found in defendant Cutter's favor on the SEC's Section 2061 and 2064 claims. Last, we continue to do a lot of work in the remedies phases of our actions. Our remedies include a range of statutory and equitable injunctive relief, including bars, disgorgement with prejudgment interest, and penalties. And in appropriate cases, we continue to seek and obtain asset freezes and receivers. And a lot of our litigation work happens in that remedies phase. So looking forward, we continue to have a very busy litigation docket, litigating in all areas of our cases, and we have multiple jury trials that are scheduled between now and the end of the fiscal year, so we anticipate having more trials and remaining very busy in all of our core areas. So with that said, Sam, I will turn it back to you, or I guess we're turning it to Dan and our guest speakers.
You can turn it to our guest speakers.
Okay.
Most honorable. Do you want to go first?
You're more honorable than me. I think you should go ahead.
Well, thank you all for that. I want to sort of go back to something that Sam sort of started off with, which is, I think, and I want to thank each one of you for sort of laying out what you're seeing. I particularly think it's helpful for people to hear about the Wells process, what the expectations are, what the limitations are as well. I think this is sort of guidance that helps all of us as we're advising people out there. I do think, all of you have served under multiple chairmen now, right? And I think, to Sam's point in the beginning, which is, I think the death of enforcement is always overplayed each time there's a new commission. But there is a theme that goes through every sort of one. One is that the majority of commissioners vote almost unanimously or on decisions for enforcement. There's a recent paper by a former alum that sort of talked about this. But there are areas which always are, I think, can flip or be a little different under different regimes. I know some of you have spoken this in the past, most recently, and I'm going to echo some of the verbiage, which is, there was arguably some creativity in some enforcement charges over the last several years that I think was a little bit surprising to many. But the commission voted and the staff carried out the decisions. One of the things that I think people are trying to have a better sense of is, do you expect that sort of theme to continue? And two, we talk always about individual accountability, which is something that I think there's not a single commissioner in the history of the SEC who doesn't want individual accountability, but it's just really hard sometimes for the proof. And so the next step is, how are you sort of thinking, or have you gotten any sort of guidance? I realize it's early on in Chairman Atkins' time on issues such as corporate negligence. So that's a lot, and therefore I'm going to ask Sam that question.
Well, thank you, Commissioner Roisman. Actually, really thank you. I do definitely agree. The through line point about enforcement, I think, is so true. If you look at our history, most of our enforcement matters are 5-0, 4-0, whatever the number of commissioners are, and that I don't expect that to change. There are some changes, though, on the fringes. I will first say about creativity. Let me try. that comes from me, and let me try and say it in a little bit more articulate way. I think that this commission is going to be asking us, how do we tie our recommendations back to the law, the case law, the statute, the rule, the purpose behind the statute, the rule? How does it fit with the comps? And we're going to get, I think, good questions about all of those issues. And I think if we have good answers to all of those issues, I think we are going to be able to bring our cases. On corporate negligence in particular, I think, again, I expect that there will be, as there always is, pressure for us to bring individuals in our cases. We're going to get questions about that. And I think on the question of corporate negligence, we've had a lot of really smart people look at that issue. It is something that is founded in the law. There are cases that support the concept. My interactions with the chairman up until now, he will listen. He will listen to those sorts of arguments. He will take it in. He will ask questions, and they're good questions. And how that plays out, we'll have to see. It's been, it's only been a few weeks, but I would argue that corporate negligence is not creativity, but we'll have to see.
Antonia, I love the Wells discussion. I think I told you last night over cocktails, I love a good Wells process. Been through too many on the other side for my own personal comfort, but it is a good back and forth. I think it's a great feature of the enforcement process. And but first I want to just echo something Commissioner Roisman said. I think the idea that enforcement's dead, or formal orders, hearing the discussion, we did formal orders. When I worked for Commissioner Atkins as his counsel, we did formal orders. It worked. And actually, I always made the argument, if I was on the staff, I'd want the commission to know what I was up to at an earlier stage instead of waiting right? Going through a year or 2-year process, then presenting some case where it's the first time the commission is aware of it, and then having them ask critical questions. Why are you doing this? Why are you focusing on that? You get that chance with the formal order. And you put it on the summary calendar, and you do 20 in one vote, and you get 2 questions, and it just works. So this idea that the formal order process is meant to hinder you, slow you down. I lived the other side of it. Some of you did too. I think that's it's just a lie. So I hope it works as well as it used to. I assume it will. And the idea that enforcement is going away or standing down, I think, is crazy. To Commissioner Roisman's point, I think we all know it's a central function of the agency. I will say, I've had many appointed criticism for the last regime here at the SEC on the policy side in particular. And I was even on the wrong side of enforcement there for a little while, but enforcement was fair and disinterested and tough, yes, and aggressive and more aggressive than I would have liked. But guess what? It was always fair. So, you guys are going to continue along that path. And I think it's just always been that way. It ebbs and flows a little bit on aggressiveness depending on, the composition of the commission. I mean, don't get on the other side of Mary Jo White. I've seen it up close and personal. It's not a good place to be. And Seresny and others. But again, even the last 4 years, I think under Grubier, it was, at the end of the day, fair. At least you got process. On the Wells process, I'm just going to give you a caution, because I did work for Commissioner Atkins. He would read Wells submissions in settled matters, which when we asked for those the first time, the staff was like, it was Linda, I don't know if Linda's here, like, what in the world? It's settled. Why read the Wells submission? And as his counsel, he would make us read them. And then even to the point of saying, if there's white papers or other things, let's take a look at those too. Now, clearly in a litigated, or contested matter, you would read those as a matter of course in the commissioner's office. But Paul went that extra step, and even on the settled matters, and even in sort of substantive non-Wells communications, that was part of our charge. So I can't predict where his head is at on that right now. Certainly can't speak for him. But as his counsel, it made a lot of work for us and the staff. And you would get these messages on your BlackBerry back then. You'd wake up and be like, oh God, he's a night owl too. I'm going to warn you about that. 2 a.m. What is this thing on page 17? And like, did you talk to the staff about this? And it's like, oh God. Of course, he found the one thing I did not talk to the staff about. So he's very interested in the Wells process itself, the Wells committee. He's like an historian when it comes to this stuff. So it'll be really interesting as you guys get into your groove together with him as chairman to see how this all plays out. But I personally think it's a critical piece of the enforcement process, and I think he does too. So look forward to seeing how that plays out for you.
We certainly know he deeply cares about the Wells process, and all of the commissioners are very focused on and do read the materials that are provided to them. So that's helpful to the overall process and the questions that we get from the commissioners, and how we proceed and how we decide how to proceed in particular matters.
The risk of being repetitive, I do think it's really, a lot of credit goes to the staff, because some of the things that people don't realize until you've sat in a closed commission meeting is the staff pays attention to every single thing that commissioners ask. And there's a consistency usually in questions. And I often tell people, if you want to sort of have a general idea of positions, commissioners aren't shy. They spend time writing things, and it's a good indication of how they feel about certain charges and certain things. And the staff is well aware and takes that into consideration. And I think, although you do have a new commission, which is 3 weeks old, you've sat with many of these folks for a long time and understand it. Anything else that you would sort of recommend for those in public? And I appreciate, Kate, you're talking about the enforcement manual and the adherence to that and the focus. I think that's very valuable for people to sort of know where a lot of this is grounded. Same thing with sort of like the corporate penalty statement, things that are sort of historical in nature that the commission has, taken a look at. Just generally, what are places where people can, in your opinion, sort of look to get a better sense of, where people sort of stand on these issues?
Yeah, one idea that comes to mind, that commissioners, again, are not shy about saying their positions publicly. They were here yesterday. There are dissents that are on the record and publicly available. I would be looking at those. And to your point, Commissioner Roisman, the staff does know what the commission, I mean, we you know, as chief counsel in this current role, I feel like I have two jobs. One is to understand what the client wants, and two is to do it. And really, that is my focus, and it's been my focus, you know, for most of the last 15 years. And I think that is the way we approach enforcement. And so, if you're hearing from staff, this is what the commission and what the client is asking us to do, there's a very good chance that is true, and that is a great place to really get that information. We know where they live, and we talk to them on a regular basis.
I'll just close with this. You know, I think, to Sam's point in the beginning, that the staff cares deeply about the mission and protecting investors, and that's never changed, and will never change. I do think, you know, there's always people who are frustrated by, you know, outcomes, and that makes perfect sense. But I think a tradition that will continue, especially under Chair Atkins, is just holding people accountable for wrongdoing, and the staff goes in every day to do that. It's a privilege, it's an honor, and that's what drives them. So I want to thank you and everyone for sharing sort of your insights on this, and I think the bar is generally very excited to hear more from you as sort of the new commission, you know, provides further input or insights into, you know, the focus areas.
Yeah, just impressed with all you guys. Great team, and you know, good substantive messaging on essentially short notice, because you got a new boss, you've had a reorg and all this stuff. Pretty meaty stuff still, and love the focus, and you know, go protect investors. So thanks for what you do.
Thank you, everyone. Okay. Yep. I'm going to try and read this. This will be Yes, these are not my, yeah, wrong glasses. Yeah, these are distance. Oh, damn it. Go far away, yeah. I've got the bifocal contact lens. Like losing my eyesight. Darn it. So I will muddle through this. So I think we're going to go ahead and start with the next panel. We're going to next hear from Adam Anisich, Senior Advisor and Investor Engagement Manager of the SEC's Office of Investor Advocate, which works to address the concerns of investors in rulemaking, assisting retail investors, and identifying problems with financial service providers and investment products. In his role, Adam is responsible for developing engagement activities and receiving feedback from both institutional and retail investors, and providing guidance on strategic priorities. Adam also developed and leads the Interagency Securities Council. I'm apparently the chairman of that, I found out last week, which focuses on complex financial frauds and helps to foster collaboration amongst federal law enforcement, state, and other government agencies. And it really is a great project. So I will turn it over to Adam.
So, good morning, everyone. Thank you for being here. My name is Adam Anisich, and I serve, as Sam said, as a Senior Advisor and Investor Engagement Manager for the Commission. So, my role is to focus on receiving feedback from investors, both large institutional investors and retail investors, to help better inform the Commission and ensure that the voice of investors is included in policy and practice. So on behalf of Christina Martin-Fervita, the Investor Advocate, and the entire Investor Advocate team, I just wanted to say thank you for inviting us to join you again this year. We appreciate the opportunity to share our perspective with you that's based and informed on our interactions with investors and other market participants since we last convened. So before I begin, of course, just a brief reminder that remarks today are my own. They're provided in my official capacity as a member of the SEC staff, but do not necessarily reflect the views of the Commission, the commissioners, or other members of the staff. So looking back, when we addressed you last year, the Office of the Investor Advocate was embarking on its 10th anniversary of its establishment. As we entered our second decade of service to the public, we renewed our commitment to the mission that Congress envisioned for us. Congress created the Office of the Investor Advocate, as well as its Ombuds Office, to provide a dedicated voice for investors. Investor protection, of course, has always been part of the SEC's three-part mission to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. But when Congress established our office, they gave us specific tasks to perform in service to investors and to promote investor interests inside the Commission. We are statutorily mandated to assist retail investors with significant problems they may have with the Commission or with self-regulatory organizations. Also, to identify areas in which investors would benefit from regulatory changes, to identify problems that investors have had with financial service providers or investment products, and to analyze the potential impact on investors of proposed rules and regulations. So our office focuses on three strategies to meet these objectives. First, we engage directly with investors and their representatives. We conduct investor research and testing, and we also perform legal analyses of Commission rulemakings and SRO filings to promote investor interests. To execute these strategies, we have a lean, efficient, and seasoned multidisciplinary team that remains dedicated to the mission of the office. We exist to understand what investors want, what they need, and what they do so that they may be better served by the Commission. To support these goals, we communicate what we learn frequently with division leadership, other divisions and offices, many of the leadership that you've heard from today and over the course of this conference, as well as with the chairman, the commissioners, and their staff. In addition, we're required to transmit 2 reports to Congress each year without prior review by other commission staff that detail our objectives and activities, which you can read at sec.gov/advocate. When we do our job successfully, everyone has more information about how the actions of the Commission and the SROs may benefit or neglect, or potentially even hurt investors. And in turn, that allows us to consider alternatives that may improve investor experiences and opportunities. So now let's talk about some of the highlights. I want to share what our office has been working on since we last visited with you, and finally invite you to meet with our office to share insights or information that would deepen our understanding of investor choices, outcomes, and experiences. So let's talk about complex fraud for a moment. In the past year, our office has been focused on investment fraud. Fraud is, of course, not a new phenomenon, but the explosion in investment fraud has been facilitated by advanced technology tools and frequently perpetrated by criminals. This has been breathtaking for us and heartbreaking for investors. We first highlighted this alarming acceleration in fraud complaints that were received in our office in our June 2024 congressional report. Since then, we only see the problem grow, which is sadly confirmed by distressing data published by numerous regulators and law enforcement agencies. In fact, in October of 2024, the Federal Trade Commission estimated that overall losses for fraud in 2023, adjusted for underreporting, was over $158 billion. $158 billion lost to fraud. Investment fraud is increasingly a big part of that number, surpassing business email compromise as the highest reported aggregate dollar loss to investors. Highest aggregated dollar loss to investors, according to the most recent National Money Laundering Risk Assessment report from the Treasury. A common element in these reports, including complaints to our office, is the role that advanced technologies play in facilitating complex fraud. So the good news is that it is important to acknowledge that technological advancements are opening doors for new populations of investors to participate in the markets and really build generational wealth. Additionally, innovative financial products are allowing retail investors to access complex investment strategies that were previously reserved for sophisticated institutional investors. For some individuals who wish to invest in these innovative products, the features of developing or emerging technologies may themselves be the impetus for becoming an investor the first time. So these same advancements, however, can and have enabled criminals to deepen the pool of investment fraud victims. Evolving technology has made deception more challenging for investors to recognize and more difficult for law enforcement to prosecute. Technological advances further provide criminals with the tools to communicate more effectively, scale their schemes more rapidly. I mean, we're talking industrial level scaling, and conclude their frauds more effectively through effectively unrecoverable payments. Alarmingly, investment fraud enabled by technology is accelerating at a scale and complexity not previously thought possible even a year ago. So one action you've heard about today already that the Investor Advocate's Office has taken in response to the proliferation of this fraud is to develop a forum for law enforcement and government regulators to learn more about the trends, the effective approaches, and ways to identify and deter these types of frauds. So the Interagency Securities Council, which Sylvester mentioned earlier, or the ISC, is a joint task force that invites federal, state, and local regulatory and law enforcement professionals to meet quarterly to discuss the latest in scams, trends, frauds, mitigation strategies, and provides briefings on complex and emerging topics. The ISC's objective is to strengthen the cohesion between the federal, state, and local agencies, to enhance opportunities to collaborate on cases and protect investors, provide insight into and guidance, really, across the ecosystem for investigations and prosecutions who may not frequently operate in the securities space. And finally, to create a forum for the unified government efforts in combating financial fraud. The council, as Sam mentioned, is chaired by Sam, the acting director of enforcement, and then I lead the SEC efforts on the council. The ISC is limited or restricted, if you will, to law enforcement and government regulators only, and now includes over 2,000 representatives from about 250 departments and agencies across the government. So all the federal financial and law enforcement agencies participate, all of the state's offices of attorneys general and state police, the state securities regulators, the local police departments and sheriff's offices. That's growing, because if you think about it, you've got a local police detective who's assigned to white-collar crimes. They get the phone calls. They're talking to the victims. You know, they need that support to be able to properly manage those incoming. Members participate in discussions with experts on emerging threats. They hear from investigators conducting and supervising these investigations, and they explore case study examples of agencies employing innovative approaches to combat financial fraud. The ISC also serves as an opportunity to connect and share information with the larger law enforcement community that less frequently deals with securities law violations, such as those local police and sheriff's departments or the tribal and military community law enforcement. Participation in the ISC is entirely voluntary, and the council generally does not generate policy recommendations. So last year, in fiscal year 24, the ISC conducted meetings and specialized briefings for its membership with other agencies, such as a briefing on the use of deep fakes and artificial intelligence in financial frauds with the SEC's Events and Emerging Risk Team, the FBI's Complex Financial Crimes Unit, and the Central Intelligence Agency. The ISC continues to meet quarterly in 2025, and we will hope to continue to be useful in this fight against investment fraud. So now let's pivot a little bit to our research programs. Another way that we fulfill our mission is through the Office of Investor Research, where we conduct investor research and testing programs. Our rigorous research efforts augment the work conducted by other areas of the investor advocate to identify and analyze investor experiences, opportunities, and behavior. Through this research, we can provide decision makers in the Commission and in Congress with timely insights regarding investor preferences, capabilities, and trends that can inform policymaking. 2024 was actually our research group's most productive year in terms of data collection. We completed 21 distinct survey projects and 3 qualitative studies. Adding this work to our past efforts, the Office of the Investor Advocate has conducted 71 surveys or experiments, 18 qualitative studies, and several analyses of market data over its lifetime. That's since about June 2017. Multiple rulemaking documents cite our research, thereby impacting the investing public. Additionally, we engage in thought leadership to policy and academic communities, encouraging others to serve investor interests through advocacy, research, or direct outreach. Some highlights from the 2024 research period include the establishment of the nationally representative Thrive survey panel to help the Office of Investor Research, or what we call OIR, the research arm of our office, to contact investors in a timely and cost-efficient manner. So the first quarter, we launched the nationally representative Thoughtful Households Relating Investing Experiences, or Thrive panel, to facilitate frequent, direct survey engagement with the public. Thrive is a platform to conduct 2 primary activities: surveys that provide timely empirical data on investment-related topics, and investor testing projects to inform SEC rulemaking and long-run research priorities. As part of Thrive quarterly surveys, the same 7,500 or so people are invited to answer recurring questions on investment decisions and household events, as well as novel questions examining contemporaneous areas of interest. For investor testing, Thrive respondents, or sometimes subsamples of them, participate in custom projects designed by OIR to address rulemaking proposals and other key SEC policy needs. I mean, the flexibility in this is really just incredible. Thrive is representative of the overall U.S. population. We also conducted a rigorous research project on registered investment company fee meters. So in conjunction with the SEC's Division of Investment Management, who's speaking immediately after the networking break, we conducted research examining the graphical displays of mutual fund expense ratios known as fee meters. This project built on our previously published research discussed in our 2022 report to Congress, demonstrating that prototype fee meters can help investors viewing a set of index funds allocate a higher proportion of their hypothetical investment balance to lower cost funds, thereby avoiding unnecessary fees. In the current work, we examine the effects of the fee meter when investors view a single fund, measuring potential impacts on knowledge of relative costs, evaluations of the fund, and interest in seeing an alternative mutual fund really brought a lot of these insights to light. This project highlights the value of long-run, longitudinal, iterative investor testing projects with the aim of having our research lead to better informed potential rulemaking activities. A novel research project on the measurement of investor time horizons to understand factors driving those reported time horizons. So the financial time horizons are a key component of financial advice that investors receive from financial advisors and brokers. Financial advisors and brokers are, often collect this investor profile to determine the best investment strategy. And according to the regulatory interpretation by the SEC, the investor profile should include questions to understand the client's time horizons. We show that seemingly minor variations in the response options shown on time horizon questions can dramatically affect investors' answers, changing the proportion who appear to have a long-run perspective versus a short-run perspective for the time horizons related to their financial goals. This project expands on OIR's research on financial advice and raises questions about the consistency of existing time horizon elicitations, with likely downstream consequences for the quality of advice investors receive. So as I close our update today on how we've been satisfying our statutory mandates, supporting the Commission, and serving the public, I want to extend an invitation on behalf of the Investor Advocate's Office to meet with us so that we can listen and learn from your insights about investors. We strive to hear from as many investor viewpoints and stakeholders as we can, and we welcome you to share with us information or analysis that you may have or that you think would deepen our understanding of investor choices, outcomes, and experiences. So feel free to reach out to me directly. My last name is here. You know the nomenclature for the email addresses, or via ISC, Interagency Securities Council, isc@sec.gov. Thank you for the opportunity to share our mission with you today, and best wishes for the remainder of the conference. Thank you.
So we'll take a short break. We'll resume at 10:20 with the Division of Investment Management. Thanks all.
Welcome back, everyone. Natasha Greiner, the Director of the Division of Investment Management, will now lead a panel of senior staff from the Division of IM. Natasha was named the Director of IM in 2024. Before that, she was Deputy Director of the Division of Examinations and the National Associate Director of the Investment Advisor Investment Company Examination Program. She began her career at the SEC in the Division of Examinations as a broker-dealer examiner and has served in a variety of roles across the agency for more than 20 years, including as acting chief counsel in the Division of Trading and Markets, and somewhere in there was enforcement as well, but it's not in her bio that I've got. Please consider the comments of these panelists.
Thanks so much, Sam, and thank you to all of you that are here in person today and those that are watching virtually. My name is Natasha Greiner. I'm the Director of the Division of Investment Management. As you can have, I think if you've been watching for a day and a half, as you come to expect, I have to give our standard disclaimer. My remarks today and those of my colleagues on this panel are provided in our official capacity, but do not necessarily reflect the views of the Commission, the Commissioners, or the members of the staff. I'm thrilled to be here today. It's my second time at SE Speaks as the Director of Investment Management. With me today, joining is Tim Husson, the Associate Director in our Analytics Group, Andrew McGovern, Assistant Director in our Disclosure Review and Accounting Office, Holly Hunter-Cece, our newly named Chief Counsel, and Sarah Tensidoff, Associate Director in our Rulemaking Office. And joining with us today, Commissioner Gallagher, who I'm sure will entertain us during our panel and keep us on task. Before we dive into the substance of this morning's discussion, I want to spend a minute talking a little about the division and the tremendous work that the division does on a daily basis. The division is comprised of attorneys, accountants, financial analysts, and other staff who regulate the asset management industry under the Investment Company Act of 1940 and Investment Advisors Act of 1940. A little tidbit for you, this year commemorates 85 years of the enactment of both the acts. We oversee an industry with more than 140 trillion in assets, which is ever growing, includes more than 12,000 mutual funds and ETF, and the division oversees more than 15,500 registered investment advisors who collectively provide advice to more than 50 million separately managed accounts. And many of these investment advisors are also advisors to private funds, hedge funds, venture capital, private equity. IM staff engage with industry participants on countless and challenging legal questions, provide recommendations to the Commission for proposed rulemaking and adopting rulemakings, review thousands of fund registration statements and other disclosure documents each year, and monitor industry trends and operations to provide critical insight to not only division staff, but staff throughout the agency and even to our fellow domestic and international regulators. While the division continues its day-to-day work, we are also adapting to an ever-changing industry. As Chairman Atkins mentioned in his remarks yesterday, for example, the staff, as of yesterday, will no longer provide comments limiting the ability of retail investors to invest in registered closed-end funds that invest in private funds. This decision was made based on the ever-evolving industry, and we hope that this shift will provide investors with new investment opportunities to the extent they align with their risk tolerance and investment objectives. As our staff begin to review these filings, we encourage filers to engage with our staff throughout the division. As you'll hear today, many of the topics that we're talking about don't lie within just one office within division, but it's very much a collaborative approach. We'll be working with filers on disclosure issues that may arise now that these products become available to retail investors. And in reviewing these filings, our staff, as always, will continue to consider disclosure issues relating to conflicts of interest, liquidity, and fees. I think it's important also to note that we are not merit regulators. We are reviewing these filings for potential federal securities violations, but also to ensure proper disclosures. Another topic that we've been actively engaging on is crypto. And again, all staff within division have been engaging on this topic as it is a priority of the new administration, but also our new chairman. Over the past 2 years, the number of ETFs holding cash and derivative crypto assets, which have increased fourfold, to a total net assets in these ETFs increasing from $2 to $12 billion. Our staff reviews those filings and engages with filers on these filings as over the years, and we've seen an increase in novel and complexity in these types of filings more recently. In addition to reviewing filings submitted by registered funds seeking to provide investors to exposure to crypto assets, we are also working with the Commission's Crypto Task Force to find ways to clarify how the Investment Company Act and the Investment Advisors Act apply to crypto assets, whether or not they are security or otherwise. For example, staff in the division are assessing issues that registered fund and advisors may face in meeting their custodial obligations with respect to crypto assets. We are coordinating very closely with the other policy divisions within the space, as each of the policy divisions are working with the Crypto Task Force and the chairman and the commission to address these issues. I'm excited, and we all collectively are working on moving the division forward and engaging with many of you as we do so. With that said, let me invite my colleagues to join in on the conversation to get into the weeds of what we're doing within the division. First, I'll hand it off to Tim Husson, head of our analytics office.
Thanks, Natasha. I'm going to begin by a premise that I think we can all agree on, which is that the asset management industry is just tremendously, and as Natasha said, increasingly important to capital markets in many, many different ways. Besides the just astronomical growth in recent years, but really over a long period of time, we also see tremendous innovation in this space with new investment strategies, even investment vehicles, and new operational procedures at firms. It's really a very exciting time to be thinking about policy in the IM space, but it does make this policy making just so important for capital markets and, in turn, the American economy. The goal of the Analytics Office in that grand project is to help put an empirical basis to that policy. And that means a lot of different things. A couple of the big ways are, one, as Natasha suggested, we do an incredible amount of outreach and engagement to registrants and the whole fund ecosystem to try to understand those new investment strategies, those new investment vehicles, those new operational procedures, any emerging trends or any kinds of new development that the division ought to be aware of. We also hire industry specialists of a variety of kind to have that expertise in-house. So adding that sort of usually non-attorney, non-accountant perspective to what we do is also just incredibly important to keep our ear to the ground on those developments. And then another big component of that is analyzing the data that comes to us from commercial sources, from the markets, but very importantly from registrants. We, of course, get a lot of questions about that data, appropriately so, including from the financial press, our SEC colleagues and commissioners, other regulators, people who are participating in the public dialogue about the important policy decisions that we have in front of us. And we do our best to answer those questions, of course, but better than that would be a more comprehensive collection of standardized statistics tracked over time that we can draw from when thinking about these issues. So an important part of what the Analytics Office does is we try to publish, when we can, aggregate statistics about this ever-changing, ever-growing, increasingly complex industry to sort of level set the basic facts that we can work from when discussing these important topics. And we've been doing this for about a decade now. One of the first public reports we did used then new Form NMFP data from money market funds. We've, over the years, added to our public statistics data from Form PF, data from Form NPORT, et cetera, expanding out the sort of publicly available, sort of rigorous methodology, standardized methodology, statistics that let everyone see things from that point of view. And recently, just this year, we have updated that money market fund report, greatly expanding the number of statistics we have, also providing a time course all the way back to the inception of the form to show all of the trends that have happened in that absolutely critical part of the asset management industry. We've also added a new report using my favorite, Form NSEN data. This is an annual filing with us that provides, as the name suggests, sort of census information about the asset management industry, but it really provides a lot of data that's not available anywhere else, especially about, say, service providers, pricing services, custodians, et cetera, but then also certain activities by funds that you don't get from any other data source, like securities lending, the authorized participants in ETFs, et cetera. And so we feel that this really deeply informs, especially 21st century regulation of the fund industry, which is not just focused on the fund itself necessarily, but all the interconnections to the whole ecosystem surrounding funds. These reports reflect the questions that we've gotten over the years. So they are questions that have come to us from the press or from commissioners or things that have come up over time. They benefit from our extensive experience using the data for regulatory purposes, which I think my colleagues can attest to is now quite extensive. It also reflects the outreach we've done to filers to understand what that information is, to correct errors, and to invest in our data set. It provides a full-time series, like I said, going back as far as we can, which in NSEN's case is 2019 and in NMFP's case is 2010, in a machine-readable format, so you can all graph it the way you want it, you can use it the way you want it. And it sets out, just a basic methodology for looking at really somewhat nuanced data sets. And I think, again, the goal of that is to provide sort of a baseline when we're talking about changes in the asset management industry that we can all sort of see together and talk about together. If you're interested in any of the details of these reports, you can find them on the SEC's website, search for investment management data. I also encourage you to attend the breakout session where one of our senior analysts, Trevor Tatum, will talk about some of the specifics of what we've changed about the money market fund report and what we've put out in the NSEN report. Don't miss it. And we sincerely hope that this work adds to the public dialogue on registered funds. It's kind of funny for an industry as large and as important as the asset management industry. There really hasn't been a comprehensive data set until recently, and we think it is just very valuable for the investing public to have that resource, and certainly important in the public policy discussions that happen. We're also very happy to hear any feedback anyone has on those reports, and we certainly invite people to dig into the underlying data on any of these things and engage. But one office that knows a great deal about how the industry is evolving is disclosure. So with that, I'll turn it over to my colleague, Andrea.
Before we turn it over, I just want to say something about the analytics office. Tim underestimates the value that this office provides, not only to the division, but the agency. And as he states, the public, it is a quiet powerhouse within our division. Many staff within the agency call upon the analytics office to help them, whether there's been a market event and we're doing a review as to what happened with the impact on the asset management industry, but also what they do by way of outreach, as he mentioned. Sometimes we get outliers in our filings. There's a lot of data that comes in. I will say he's proven that we do use it, and we use it quite often. But there can be outliers, and there's questions as to why are those outliers. Sometimes it could just be a filer error, and this team will reach out to the individual filer and have a dialogue about the filing to ensure and then promote compliance with the filing requirements. Sometimes there are issues that we will then look into, and we will sometimes work with exams if we think there's a problem that needs to be looked into. Sometimes we do the examination ourselves. And very rarely, but on occasion, there could be something that would rise to an enforcement investigation. But again, one of the biggest things I heard coming into this job a year ago is we get a lot of data, what do we do with it? And what I've learned over the last 15 months is we do a lot with it, and I think it's quite impressive. So Tim is not one to toot his own horn, but I'm happy to do it on his behalf. So
thanks for that.
Hand it over to Andrea to talk about the Disclosure and Review and Accounting Office.
Hi, everyone. My name is Andrea Adamanelli-McGovern, and as Natasha said earlier, I'm an assistant director in our Disclosure Review and Accounting Office, which we lovingly call DREO. I'm excited to tell you a little bit about our office, how it's structured, the work we do, and some of the issues that we're considering these days. So first, I wanted to mention that we have 3 legal offices in DREO, as well as our chief accountant's office. And our office is tasked with reviewing all registered fund registration statements, certain proxy statements, and financial statements. To give you a sense of the volume of that work, I thought I'd go over our 2024 fiscal year numbers. So last year, we reviewed more than 1,600 new funds and 150 new insurance products, close to 2,100 amendments for existing funds and 175 for existing insurance products, almost 160 filings on Form N14 for business transactions, and that includes more than 400 target funds and 30 mutual funds that converted to ETFs. We also reviewed nearly 230 proxy statements and more than 4,400 sets of financial statements. And on that last point, I want to make sure that I highlight the great work of our Chief Accountant's Office. Not everyone knows this about the work that we do, but pursuant to the Sarbanes-Oxley Act of 2002, we have a mandate to review the financial statements of every registered investment company and business development company every 3 years. There are about 14,000 of those. So if you do the math, that's 4,000 to 5,000 financial statement reviews a year. That's no small feat for our small team of accountants, so I really do want to make sure I call out all the great work that they're doing. They also help us with our registration statement reviews and our proxy statement reviews. And they're involved in actively monitoring the industry for key issues with our registrants as well. So they keep an eye out for restatements, material weaknesses, and when they see those issues pop up, they evaluate the disclosure, and they may also reach out to registrants based on what they're seeing. Now I'll talk a little bit more about the filing process in our office. As I mentioned, we review all registered fund registration statements, and so one of the points we really want to highlight for folks is to engage with us early and often on those registration statements, particularly if you want to do something novel or complex. A lot of you may know that the way our rules work for open-end funds, ETFs, they allow for automatic effectiveness in a certain period of time. So 75 days for new funds, 60 days for material changes, and that clock can start to tick pretty quickly when you're dealing with novel and complex issues. So we really do encourage folks to connect with us in advance of filing a registration statement. It allows for the process to run more smoothly. We can tee up issues for you that we may see with a particular issue that you're thinking about, or new asset class or strategy, and then we can have a dialogue even before you file the registration statement, allowing that thinking process to begin before the 75-day or 60-day clock really is helpful. If you do file for a new fund or a material amendment and we are unable to resolve comments within that automatic effectiveness timeline, the staff may ask you to delay effectiveness of the registration statement, which our rules do allow for. We typically expect to resolve comments with registrants before they go effective. I also wanted to mention that with novel and complex strategies, we work quite a bit with others in the building, particularly in our division. We're constantly working with the folks in Tim's office and Holly's office on issues that we see coming in the door, and with others around the building. So that is part of the reason why we often need a little bit more time to run issues to ground. On the engagement point, I did just want to make a pitch for the fact that our doors are open. We're always willing and ready to have conversations with folks about the issues that you're thinking about. So if you have questions, if there's areas that you think are a little murky or gray and you'd like clarification, or you just want to kick something around with us, we really are happy to have those discussions and we welcome them. You can reach out to your reviewer on staff if you know who they are. Really, anyone on staff would be happy to take your call, answer your questions, or at least point you in the right direction of somebody that might be able to help you. Next, I wanted to mention some trends in the filings that we're seeing, and this, I think, flows pretty well from my point on engaging early and often, and that is that we're not really seeing a lot of what we would call plain vanilla filings these days. We typically think plain vanilla would be like a large cap equity fund. We don't see too many of those coming through our doors these days. Now it's new asset classes, new technologies, complex derivative strategies. The types of filings that I think we're seeing a lot of these days are probably not surprising to you: digital asset filings, filings for funds that want to use the blockchain in their operations. We also see a number of filings for single stock funds, and these are funds that use derivatives to provide leveraged and inverse exposure to a particular issuer. And we continue to see filings for defined outcome and covered call strategy funds. These are funds that typically seek to mitigate or offset the risk of loss of a fund's investments. On the topic of those funds, I wanted to mention, though I think this probably is applicable for any fund filing, just to be mindful of the disclosure included in your filing. I think a lot of times what folks will do, particularly if they have a set of funds, and we see this a lot in the digital asset, defined outcome, and single stock space, where much of the disclosure can be carried over from one fund to another. Maybe there are portions that are applicable to all, but where you have a different underlying issuer or asset or defined outcome period or downside protection level, the disclosure may need to be tailored to the particular structure of that fund. I think this is particularly true with risk disclosure. So that's just something to be mindful of when you are working on these fund filings. Even if some of that boilerplate or typical disclosure can be used, maybe take a look at it with a fresh eye to make sure it's covering the particulars of the specific fund that you're working on. Finally, I wanted to highlight some of the other work that we do beyond our bread and butter review work in the disclosure office. One area is just with respect to what I was talking about before, and engagement and guidance and having conversations. Doing the review work we do gives us a lens as to what's going on in the industry, where people are focused, where there may be pain points. And so one of the things that we have done in recent years is publish something called an Accounting and Disclosure Information Statement. We call them ADIs. And these documents really reflect our observations about what we're seeing in our reviews, or even sometimes as the result of a targeted review. If we see issues going on in the markets or in the industry, we might do a sample review of some filings just to see what's going on and to learn more about the area. So these ADIs will reflect our observations, and they often just remind folks of their obligations under the federal securities laws. In the last year and a half or so, we've published 3 ADIs. One has dealt with short form eligibility for Form N2 filers, so those are closed-end funds and some BDCs. The other deals with the implementation of tailored shareholder reports and some common issues we were seeing there. And finally, in January, we published an ADI that related to website posting, particularly with respect to summary prospectus obligations for open-end funds and variable insurance products, as well as web posting requirements for ETFs and money market funds that operate pursuant to rules specific to those fund types, and those rules do include certain web posting requirements. So those ADIs are available on our website. You could take a look at them, and if you have any questions, as always, you can reach out to the staff. And then finally, I wanted to highlight our involvement in the rulemaking process and the implementation of new rules and amended rules and forms. In recent years, we really have, I think, gotten involved in the rulemakings that are related to disclosure issues, things like the amended names rule, tailored shareholder reports. Most recently, we worked with our rule writers on amendments to Form N4 to allow a product called registered index-linked annuities to register on that form as well. And what's really wonderful about it is we have folks in our team that work with the rule writers throughout the rulemaking process. And then when we get to the adoption, those folks can help lead the implementation of the amended rules or new rules in our office. And the implementation really is a bit of an undertaking, but I feel like this process of being involved in the rulemaking and then transitioning to implementation does really help with the efficiency of that process. We have 1 to 2 folks who are subject matter experts on a particular rulemaking or amendment, and they help lead this implementation. We develop training materials, guides, FAQs, we have in-person trainings for our staff, and then throughout the implementation, we have regular meetings and points of contact for issues as folks are seeing them live. It really is our goal to make sure that our staff feels confident and well prepared to be able to tackle these new amendments and forms, and to make sure that we're being as consistent as possible in our comments. Lastly, I just wanted to note that when we are working on the implementation of a new rule, we have some things that we do as an office to help our registrants and also help our workload with respect to the filings that are coming in. So one thing we use is selective review, which means that a registrant can ask us to review solely the new disclosure in a filing. Additionally, we have a process called template relief, where essentially a registrant can file one reviewable registration statement with the new disclosure. The staff will review it, provide comments, we will resolve those comments, and then instead of having to file multiple reviewable filings, you file just that one, and we give you permission to file the other filings with that added disclosure and the benefit of our comments in non-reviewable filing format. So that's just one way that we help deal with both the workload on your plate and ours. And I think the best example of this recently is, as I was mentioning before, are the amendments to Form N4 and the addition of RILAs on those forms. We just completed the first year of implementation for those products onto N4, and we've gotten great feedback both inside and outside of the building on the implementation process. And I just wanted to take a moment to give our staff kudos on all the work that they did in that process. It really has gone well, and I'm thankful for all the hard work they did there. And lastly, I'll just make a plug as well for the later breakout session. One of our branch chiefs, Asen Pereshkov, will be speaking on that panel. He'll talk a little bit more about the work that we're doing in our office. And as one of our branch chiefs, he really is on the front line and sees what's coming in on every day on a day-to-day basis. So I encourage you to attend that. And now I will kick it over to Holly. Thank you.
Thank you, Andrea. So I rejoined the division as chief counsel last month, and it's been very exciting, kind of seeing familiar faces and getting to know new ones. And I'm very pleased today to highlight some of the work of the office. The chief counsel's office serves as a resource within the division and the commission, including providing guidance to exams and enforcement, as well as other divisions and offices. So today I will highlight 3 items: ETF share class exemptive relief, streamlined co-investment relief, and the new marketing rule FAQs that were issued in March. So turning to ETF share class relief. So first, for some context, ETF share class relief would permit an ETF to offer a class of mutual funds and a mutual fund to offer one class of ETFs. And the idea is that an investor would be able to select an investment strategy that is appropriate to them, and then they could choose whether an ETF or a mutual fund makes sense. It might also open up new distribution channels for funds. In addition to the investor experience, which I just discussed, the industry has identified other potential benefits, such as economies of scale with respect to service providers, lower portfolio transaction costs, and possible efficiencies in portfolio management. A key regulatory consideration for the multi-class structure, which the Commission articulated when it adopted Rule 18F3, which is the rule that permits mutual funds to offer multiple shares of mutual fund classes, is whether one class could subsidize another. The ETF share class structure raises really interesting questions about cross-subsidization due to the different structure of mutual funds and ETFs. So for example, mutual fund shareholders buy shares with cash and receive redemption proceeds in cash, whereas ETFs transact in kind with authorized participants, and investors buy and sell shares on exchange. The differences in these structures could potentially lead to cash drag or other issues that might lead to cross-subsidization, and which is one of the items that the staff is considering when reviewing. I think we now have about 50 applications. And in addition to reviewing these applications as part of this process, we're thinking through appropriate conditions for advisors to monitor and report to the board on the multi-class structure and on the potential for cross-subsidization. And in doing so, we're trying to kind of strike the appropriate balance. We don't want to be overly prescriptive and granular, but we also don't want to be too high level such that it's unclear for advisors what might be appropriate. We're also thinking through the board approval and general oversight, really focusing on the board's role as general oversight, not in the weeds of the fund, day-to-day fund management. And we want boards to have decision-useful information to help them fulfill that oversight role. So where are we now? So like I mentioned, the staff is reviewing applications and providing comments, and with a view to providing a recommendation to the commission in the future. So the second topic is streamlined co-investment relief. And again, for some context, there are several benefits to closed-end funds and/or business development companies co-investing with private funds managed by affiliated investment advisors and other affiliates. And these could include, for example, greater deal flow, the opportunity to participate in a wider range of investment opportunities, as well as more favorable deal terms. And co-investment programs are particularly important to closed-end funds and business development companies that seek to provide access or exposure to private credit and direct lending. However, there are investor protection concerns, such as overreaching, the potential for overreaching, and the potential for self-dealing, as implicated by sections 17D and 57A4. So to participate in co-investment programs, which are considered to be joint transactions under the 40 Act, closed-end funds and BDCs, which I'll term regulated funds, as that's the term that's used in the applications, must file an application for exemptive relief. And over the years, the staff has issued countless notices and orders under delegated authority, and these applications have grown to be overly long and complicated and just a burden for applicants to file and for staff to process. So staff took a holistic review of the applications and the conditions and worked with industry to significantly streamline the applications and the conditions to make them more workable, yet still retain key investment protections. And these include the requirement that all participants co-invest under the same terms and at the same time, and 2, that the fund's investment advisor or its affiliates cannot receive transaction fees or other remuneration in connection with a co-investment. So I'll highlight some of the changes in the new streamlined application. For example, we've refocused the responsibilities of the board to approve participation of the regulated funds in the program and the related policies and procedures, not approval of each co-investment transaction on a transaction-by-transaction basis. We've also expanded the types of affiliated entities that can participate in co-investments to, for example, employ securities companies and advisory prop accounts. And under the streamlined relief, regulated funds may co-invest in an issuer in which an affiliated entity other than a regulated fund already holds a position, subject to board approval. And this approach permits follow-on co-investments where no significant overreach risk exists. For example, the scenario in which a regulated fund that just simply didn't exist at the time of the original investment and would like to participate in a follow-on. We've also are requiring co-investment participants to adopt policies and procedures that provide for the allocation of opportunities that is fair and equitable to all regulated funds, which is a standard, well-known standard in the Advisors Act. So where are we now? The staff is processing these new streamlined applications and issuing notices and orders under delegated authority as expeditious as we can. So finally, I'll discuss marketing rule FAQs. These were issued in March, and they replace FAQs that were issued in 2023 on a similar topic. And they are the result of extensive engagement with industry, and we were really trying to identify pain points and issue helpful and useful guidance. You know, industry outreach is something that you've heard today at the panel, and it's definitely been one of Natasha's priorities as the director. And I think you can really see the benefit of industry engagement in each of the items that I've mentioned today. So the marketing rule FAQs, again, issued in March, clarify the marketing rules requirement for investment advisors that both gross and net performance must be shown in advertisements. As the FAQs explain, advisors can show just gross figures in 2 scenarios: extracted performance, which is the performance of one investment or a group of investments, and the use of portfolio and investment characteristics, such as, for example, a yield or a Sharpe ratio. And as the FAQs explain, there is little risk that prospective clients and investors will be misled about the impact of fees and expenses on their returns, where the advisor discloses extracted performance or investment characteristics on a gross basis, provided that a clear presentation of both gross and net performance of the total portfolio is also included. So the FAQ set forth a number of conditions. I'm not going to read them through now, but I encourage you to do so. And I will say, like I mentioned, the FAQs are the result of extensive engagement with industry. We understand that there are a lot of questions about the marketing rule remains. We are working through some of those issues with a view to perhaps issuing guidance in the future. And if you have questions about the marketing rule that you think that might be helpful to explore in a future FAQ, please reach out. And I will also put in a plug for the breakout session. Chris Carlson, who's in the Chief Counsel's office, will be there, and he will be discussing more work with the office. So it should be a good discussion. Thanks.
All right, so I think I'm up last before Dan gets to have full reign across the entire panel and question all of us and hold our feet to the fire. So I'm going to touch on rulemaking and what we've been focused on lately. And I think I'm going to talk about two primary areas that we're focused on, and then maybe, since this is a transition period, we're sort of shifting off of one set of rulemakings and looking forward to the new agenda under our new chairman. I'll talk a little bit about process, because I do oftentimes get questions about, how does a rulemaking agenda form? How do we work with some of the other offices across the agency and within the division? So in terms of transitioning out, we have a number of rules that were adopted where we're in the implementation period, where we haven't reached the compliance date. And in that period, we try and make sure that we can do things to make sure that implementation goes smoothly. So in a number of cases, we've granted more time. The Commission has granted more time for implementation when people came to us and said that this is certain contingencies, interactions with service providers, questions that need more time to work through and operationalize, and they would benefit from more time. So examples of that is Form PF changes. We've extended the compliance date to actually June for the names rule. That also, we extended the compliance date for an additional 6 months, as well as aligning it so that people could do updates as part of their annual update cycle to their disclosure forms. So both more time and to be able to do it more efficiently. We also have extended the compliance date for Form NPORT changes. That one we've extended both because I think people were looking for time, but also in particular under recent executive orders so that we could give a fresh look to questions of law, fact, and policy under that rulemaking. Another big thing we do during those implementation periods are issue frequently asked questions. So we're looking for questions that come up as people really roll up their sleeves and start implementing so that they can do so more efficiently. So we've issued frequently asked questions both for Form PF and for the names rule amendments that were adopted. And on all of those, I'll just put in a plug, we try and push out FAQs as questions come in and not wait till the end so people can have real-time information to use. So if there are additional questions that come up on any rulemakings that are in their implementation period, please reach out. We are working to engage with people and conduct outreach to try and make that implementation as smooth as possible. So that's sort of winding out things in their compliance period. Another focus for the rulemaking staff is on the new agenda for our new incoming Chairman Atkins. So I think a question we often get is, where does rulemaking's agenda come from? And certainly a key part of that is the chairman who comes in, and we work with the chairman to understand priorities and as well as work across the commission to set that agenda into place. So that's one way we get rulemaking ideas, and so we're certainly in that stage. We also sometimes get directives from Congress for rulemakings. That's another common way we get rulemaking ideas, and we'll certainly keep a close eye out as bills move through Congress that may give us things to do. Increasingly, those come with timelines attached to them, so often those have a particular time period we're trying to work within. And then a third way we often get rulemakings is we do try and keep track of things that happen over time, changes in the industry, rules that become outdated, or Holly mentioned exemptive applications. Sometimes there will be innovation that happens through exemptive applications that becomes ripe to be put into a rule so that everybody doesn't have to go through Holly's office to be able to do something. So an example of that is the ETF rule that we shifted from everyone needs to come into an order, get an order to launch an ETF to there's just a rule and everybody can go to market much quicker. So that's another area we try and monitor when things that have developed through an exemptive process could be made more efficient by adopting a rule so that people can just go straight ahead and rely on that type of relief. And often when we do that, as Holly said, over time, conditions can change. I think the discussion on co-investment was a good example of that. So one thing, when we do that, we try and take a fresh look, hopefully have learned from all the years, and think of, are there ways we can streamline and change conditions so that we reflect all the learning that happened over that time period. So those are various sources we can have for rulemaking to come through the office. Another thing that's really important part of that process, though, is dialogue and outreach with folks on the outside. And that's for all of those forms of rulemaking. So if it's something that's coming from the chairman's agenda, he will often have outreach. You may see us in some of those meetings so that we're getting the benefit of your thoughts in those conversations. You are always welcome, and the staff encourages you also to come and meet directly with us. We want to hear your thoughts, your experiences in a particular area to make sure that we're understanding how situations are on the ground and people's experiences and have that inform the rulemaking. That can happen at a variety of points in that process. You will see we publish twice a year a Regulatory Flexibility Act agenda. That is the Commission's way of telling the public about our active rulemaking agenda. So if you see something is on that agenda and you have thoughts to share, please engage with the staff. So even before we propose something, that's a way to engage. In some cases, there may be a roundtable, a concept release, a request for information. That's another way before a rulemaking proposal is put out for people to share thoughts and engage. You're seeing that actually, I would say right now with the crypto task force. We're definitely tracking everything that they are doing and what they're hearing, all the submissions, the roundtables that they've had. We've been monitoring all of that. Some of that has led to us seeking to do outreach directly to sort of dig in further so that I think, as the chairman has said, his hope is ultimately we have a rules-based system that sets forth a clear regulatory framework. So that's another example of how we try and interact to gather information before there's any types of rulemaking proposals to make sure it's informed. Then once there's a proposal, of course, there's a notice and comment period. We take very seriously all the comment letters that get submitted and read every one of them. And then also that's another period where engagement is often helpful. If we have follow-up questions or things you want to highlight from those comment letters, it's another great time to engage. And then, as I mentioned in the beginning, there's an implementation period. And in my mind, you know, our involvement goes all the way through that period. We want to make sure sometimes people learn things after the rule is adopted and they go to actually implementing it. And we want to make sure that we're hearing about those things as well as they come up and addressing them. I guess two other things I want to note. So outreach, really important. Please come engage, both as we're talking about implementation of any of those rules, but also as we start working on the new agenda. It's really important that what we do is grounded in what people are saying. As part of that, I think just wanted to talk a little bit about how we connect to some of the other offices within the agency to additionally ground that. So we work heavily with Tim's office in analytics. We do want to make sure everything we do is grounded in empirics and data. You'll see a lot of that cited in our rulemaking releases, but a lot of that also can lead to outreach to better understand, is there an area that the data says we don't need to touch on, or that maybe we need to look at a little differently. That's an area where the data analytics can really be important. And I'll just give one example of that. We did several years ago a rule on derivatives, and that was where we had data that 10 years ago we didn't have on the nature of derivatives use by different types of registered funds. And one thing the data showed is that there were certain funds who very heavily used derivatives, and then really most of the industry who very lightly used derivatives. So that allowed us to do a rulemaking approach where we have limited derivatives users, and they have just a few things that they need to do, and then we have a rest of a rule that only applies to those more extensive users. So that's just an example of where having the empirical data can really help us better think through and tailor a rulemaking, and a great example of how we use Tim's office to we do lots of, please, Tim, can you get us data on X, Y, and Z? And they do a wonderful job of it. So another way, Andrea mentioned on disclosure rulemakings, which really are a bread and butter of the office, I think. I can tell you every term for a chairman, I feel like there are always at least one disclosure rulemaking in that. And we work heavily with the folks in our disclosure review office. As Andrea said, they are actively on the rulemaking team so that they can bring to bear their experience in reviewing those types of disclosures, so that we're thinking of things that we might not otherwise, have you addressed this? If you don't answer that, people are not going to know how to apply that. So they bring really good practical knowledge to that. And then, as Andrea said, it also helps then when it turns to implementation that they're very familiar with that, and I think makes it smoother to roll that out. And then lastly, with our chief counsel's office, I think they're heavily involved in a couple of ways. One, they are the group that gets the questions over the years. They have the phone lines. When you guys bring in calls, they are the ones who answer it. So they're a great resource for understanding, where are there questions that need responding, where are there fuzzy areas that we could clear up if a rulemaking we're doing touches on it. So and they have a lot of very specialized knowledge and expertise in certain areas. So we bring all that to bear when we work on a rulemaking. Another area I mentioned are exemptive orders. There are times, as I mentioned, where it's ripe to turn those into a rule. The people who've worked on those orders for years are going to be a part of that rulemaking team so that we're not losing all of that knowledge. And then a third area where we work extensively with the chief counsel's office is we have a process of basically handing the rules off. So once we get through to that compliance date, I guess from when the rule is adopted, someone from Holly's office will be on the team through that implementation period, so they hear the questions that are coming in, how those are getting resolved. And then once we reach the compliance date, in the rulemaking's office, our job now goes to Holly's office. Now it's just interpretive questions that may come in as people are involved and have questions. So it sort of shifts from the rulemaking office, and we want to make sure that that's a smooth transition. So that's sort of our process. The rulemaking during the transition period, we're both on the team looking at that, and then we have the handoff. So that's generally our approach. We're looking forward to the new agenda. And I think hopefully next time we'll have a little bit more to talk to you about concrete as some of our rulemaking proposals start coming out in the year to come. And I guess I'd be remiss, since everyone else gave a shout out to the workshop. We also have Brad Gooden, an assistant director in our office, who will be on the workshop. So encourage folks to attend and learn more.
I've worried we've given you too much time.
I saw you trying to run down the clock.
I don't mean anyone else could filibuster.
You kept saying one more thing, right? You were looking at Natasha blinking at you. Yeah. Well, that's pretty awesome. I've been generally impressed. It's my fourth panel, by the way, because we're in short supply, us old timers. And I've been really impressed just generally across the board that I know you're in a transitional phase here. It's hard to speak with, in an affirmative way about what you're going to do or not, because, Chairman Atkins is trying to figure out what he wants to do and not. So I don't mean to box you in on anything with any of my questions, but I do feel like you're delivering to this audience a lot of substance in lieu of, having clarity on the roadmap. So kudos to that. Natasha, last time I saw you, poor Natasha, I think I was giving a speech full of piss and vinegar about the PDA rule, and poor Natasha was sitting there looking at me. God, what an awful rule proposal that was. Anyway, but this is a little more fun. We can sit and have some more fun. So top of mind for me, first of all, we just registered an advisor at Robinson, so we're a registrant. First time in my life being an IM registrant, and process was great, efficient, transparent. I mean, it was really terrific. So kudos to the staff on that. And I mean it. Like compared to some other registration processes I've been involved in, absolutely the most straightforward and efficient. So thank you for that.
Yeah, a lot of that happens. We partner with the Division of Examination. They have a registration office, and so it kind of goes through them, whether you're BD or IA or other registrant who's SEC registered. And so that process goes through them, but we provide them substantive expertise and coordinate really strongly with them on any issues or concerns or questions they have with new applicants. But I'm glad to hear that the process went well.
Honestly,
Welcome.
it's just a standout registration process in the securities world. So no games, no gimmicks, no gotcha, and realistic expectations on timelines and the like. So really appreciate that. So now that we're registered, right, for me, top of mind is AI. And again, I get it, you're going to develop your agenda there. When I did the examinations panel yesterday, we were talking about AI, with Vanessa and saying, to me, it really screams for principles-based regulation. There's going to have to be some type of regulation, obviously. But like trying to regulate it in a prescriptive way when it's going to be developing at such a rapid pace, I think is just a fool's errand in so many ways. So you need to create something that can grow, with the technology. And to me, it's sort of like boiled down to, the rule set today contemplates humans doing things. AI will be doing some of the things that those humans do. In the context of regulated entities, to me, then it's like what human is supervising what to make sure it's actually happening. And when I hearken back to the old days when there was OC, not the Department of Exams, and high-frequency trading after the flash crash was the big deal. You guys remember that. The big thing was like, ooh, what are we going to do with these algos? And the initial response, which was logical, was let's hire a bunch of engineers and demand access to code and figure out the code. And that again, was a fool's errand, right? It was just like you never keep up with that. And so then it changed into more of a principles based. Tell us what you do in plain English, in your policies and procedures, prove it does it, and that somebody's supervising it, and that's probably the proper role of government. So as I think about it, that's the way I think it in broad brush, needs to work. But have you guys been giving it thought? Are there major issues presented to you right now, or is it still just in the early stages?
So, I mean, obviously, as you had said earlier, the chairman is only 3-4 weeks into his tenure. So, but, there is a robust comment file on the proposed rulemaking as it related to predictive data analytics. I mean, we do work, there are fundamental concerns, which I know the examination staff talked about when advisors are touting the use of AI and they're not actually, in fact, using it. So, where there really is a problem of, you're not doing what you're saying that you're doing. And we monitor that. We're continuing to have concerns. But I think there's foundationally a regulatory regime to address that issue. That is not something I think we need to address. The core principles of the fiduciary duty in 206
right.
would cover that misconduct in my eyes. But no, it is something that we're continuing to monitor. As I think whatever rule set without predetermining what the chairman may or may not want to do in this space does need to be evergreen. I don't think we can regulate products or technology because at some point we're always going to be behind. The rulemaking process takes us quite a long time, especially with the new OIRA review. By the time we proposed and adopted, to the extent that we want it to be prescriptive, I think maybe the technology might have gone far beyond that. So I think it's something we talk about all the time. That's why the engagement is so important, because I think we want to continually understand where the technology is going, where the industry is going, and how we can evolve. This is a perfect time for us to look at our rule set and at the foundations of what our rule set looks like. Many of the rules have not been updated in quite a long time and need to be modernized. And I think that, this is a perfect time to engage with us. I've promoted engagement since the day I took this job over a year ago now. I will say that there's been much more engagement more recently, especially because I think much of the industry and the lobbying groups understand that this is a time that we're thinking, as Sarah said, about what we want to focus on, especially with our limited resources going forward. And technology is one of them. It's a good time for me to pitch. We have our Emerging Trends Conference on June 5th. One of the topics will be digital assets and tokenization. It's really a focus on the tokenization aspect of the topic, because I think again, technology is evolving. It's changing the industry in a way that I think, we talked about it. I remember when email came on board, and how is the books and records rule going to, in the TM space, going to address how record keeping is happening? And it was so novel and new, and you know what, we figured it out, and the rule didn't have to change that much. The industry just had to think about the technology of how they were going to maintain the records. And so those are the types of things that we're thinking about as technology increases. But again, the dialogue is huge, and it's something that we're very interested in hearing the chairman's perspective on it and the rest of the commission.
That's great. And Holly, it was great to hear about the marketing rule too. I know there's lots of questions, so I assume you'll be getting input from the industry on that. One anecdote I heard is advisors being frustrated or questioning whether they can respond to criticisms on social media. You're being attacked on social media. How do you defend yourself? And how does that accord with the rules? So I don't know if that's been presented to you yet, but
Yeah, I don't think we've heard that question yet, but it's a really interesting one, and
Yeah.
we wouldn't want to stifle, free speech. So
yeah, and it's having at least on the Robinhood side, having you get this criticism on social media, and sometimes it just builds, and if it's based on a falsehood, you're like, oh Lord, this is not good for anybody, the public company shareholders, the customers, and but you have to be very careful that once you start speaking, obviously you got to be on your game. So anyway, it'll be interesting to see how that evolves, and that you guys are all over that. And I have 2 minutes left, Natasha, so I'll have one more question. Another easy one. So it's funny, when I was on the commission, you remember Dodd-Frank made us do the review of the accredited investor thing.
Every 5 years.
Is it every 5 years?
It's every 5 years.
Oh, Lord. Yeah, so it must have been 2015. We did the first one. I remember sitting in the auditorium, and it was like a half day on the accredited. I was like, oh my, what a waste of time. We're sitting here talking about the millionaires rule. We have all these other things to do. And at the time, I famously noted I was not an accredited investor. I am now. I've reached the status. And it's just amazing to me, like the availability on the private fund side in particular. It's astonishing to me. There's just, it keeps growing. And so how do you guys keep up with that? Like, how do you monitor the new products, the new funds, because it's becoming the new retail, and I know, I'm guessing that there's going to be some look at accredited investors, so you're going to see a further potential widening of that availability. So how do you guys stay current with that?
I think the short answer is the engagement that we're having in the industry, but also we have a lot more data today. I mean, Tim could probably speak to it than we did before. I talked about it. We're not merit regulators, so to the extent that new funds or innovation is occurring, we're kind of, and with the news that the chairman announced, and I reiterated today, of the idea that retail investors will now have more access through a registered fund to private funds. And I think for us, it's really about monitoring, using the data that we have, and that not only has the market evolved, but our sophistication on being able to kind of look through and determine the impact and really keep the core principles of investor protection underlying on how we move forward. I defer to Tim if he has some insight, but today's data is much different, and how we use that data and how we're looking at the industry is very different.
I'll also just add collaboration. To the extent that exams is seeing something new and novel, they get that information to us. If we're seeing something in our data, we get that information to them. Those sort of information barriers have never been weaker than they are now. And I think in a time of limited resources, in a time of just rapidly evolving markets, that collaboration just becomes this force multiplier. If Drayo's seeing something new and novel, maybe it's something that emerged from the private fund space, connecting all those dots is just absolutely critical. And so I would say that, you know, the data is very foundational because it sets sort of boundaries to a certain kind of discussion, but then bring everyone's expertise to bear on that is just a really important part of that.
Yeah, I guess that's one thing we haven't really talked a lot about today is our interaction with the divisions of examinations and in division of enforcement. I mention enforcement not only because they left it out of my bio, and I am, you know, truly an enforcement attorney at heart after my long tenure there, but also I do think it's very important that we have a seat at the table on those the enforcement recommendations because it does have policy implications. And so, you know, we review recommendations through our chief counsel's office to the extent there are issues that are that are being spotted through our review of enforcement recommendations. We bring in other staff in the division, so it's pretty robust. And we, you know, with limited resources, try to be pretty impactful because ultimately, like I said, the enforcement cases that are brought, whether litigated or settled, can have policy implications that we, you know, want to make sure is in line with the regulatory framework and on our policy perspective. Also from an examinations perspective, I mean, I come from an examinations background. I think it's so important what they see in their examinations that inform policy. But, you know, so we have significant input into the examination priorities, their risk alerts, risk alert ideas. So I think all of that's quite important. I think one cannot happen with the other. One of the things that I really promoted while I was in examinations is for us, and we can't do it all the time, but if a new rule like the marketing rule is adopted and post-compliance state, that we are engaged on those type of examinations, what the actual deficiencies are saying, because sometimes we're not able to speak, but those exam letter deficiencies speak for themselves, and the industry can take from it what they want, but we want to make sure the message is in line with the rules that the commission ultimately adopted. And so trying to really partner with exams in that from that perspective. We can't do it all the time. We do not look at every deficiency letter, I can make that clear. But we do try to consult where there are concerns or issues and work very closely with the examinations chief counsel's office and examiners in the field to the extent there are one-off questions.
And I can just add, I think we often do hear about some of those. We're monitoring those developments because they do often have a policy angle that comes up. So we regulate private fund advisors. And even though we're not directly regulating the private funds, a lot of times as they shift strategies, questions come up. How does this rule apply to that? You know, I'm doing this, is that covered? So we'll certainly engage from that perspective. Sometimes they'll say, you know, now that we've shifted in a certain way, it's not quite working. And so that may be a conversation. And then, honestly, I think over time, a lot of the things that start in a private fund strategy, ultimately some flavor of that is looked for in a registered fund space, sometimes with adaptations, sometimes they're more interested in purely. So I think we often will look at that as a pipeline of things that may come. And so that, you know, there are BDCs, there are interval funds, a lot of those do more strategies you typically would see in the private market space. And then last, as you were mentioning, there definitely has been tremendous growth in the private markets. And I think sort of you know, how much of the space is pure private markets versus public markets? Is there starting to be an interim space of interaction? I think that's something we're constantly looking at. So I think we're also looking at it from a policy angle as to, you know, as these developments happen in the market, where there are friction spots, where are there spots where we need to look at how our regulatory regime, how is it working with that? And so I think we're always monitoring on both sides, because I often think we have a whole regime around regulating the regulated market, and then we have a whole regime about not regulating, and a lot of the questions come around, well, when do we move over? How is it looked at from the private fund advisor, but not from the private fund, so we try and make sure that all that works smoothly.
Yeah, makes sense. Good luck with it all.
I appreciate it. And so I wanted to thank you, Commissioner Gallagher, for sitting in our panel. I know you participated in a lot of panels in the last 2 days, so appreciate and all your very good questions, which we will keep that in mind as we move forward. And thank you to the panelists. Please do join the workshop later this afternoon at 4:20. I know we will kind of take a deeper dive into some of the topics and issues that we discussed today. And also, I'd be remiss if I didn't once again pitch the IM Emerging Trends Conference, which is on June 4th, with an eye towards various issues, including commemorating the 85th anniversary of the enactment of both acts. We have a former directors panel with 7 former IM directors talking about their perspective going back into the 60s. So I think it'll be really insightful. And then 3 specific panels, much of which what we talked about today: fund innovation, use of tokenization of digital assets, and the regionalization of the private markets, 3 specific panels that we plan to hold. So it should be really engaging. I think we'll have a virtual component, but also feel free to attend in person. So thank you, and thank you to my panelists and for all of you for listening in.
Our next speaker is Stacy Bowers, Director of the SEC's Office of the Advocate for Small Business Capital Formation, which works to advance the interests of small businesses and their investors in the capital formation process. Stacy began her legal career as a staff attorney in the SEC's Division of Corporation Finance before entering private practice. Since 2018, Stacy has served as Director of the Corporate and Commercial Law Program at the University of Denver's Stern College of Law, where she has also taught a number of classes on corporate and securities law since joining the faculty in 2007.
Good morning. Thank you to PLI for once again hosting this event, and to the studio audience, both live and virtual, who has joined us today. In preparing these remarks and knowing I was lucky enough to take the stage between all of you and your lunch break, I thought, how do I pack in all the ways our office seeks to support small businesses in a few short minutes before that mental lunch bell rings? And just like that, I found myself in my head somewhere between Final Jeopardy countdown music and those shopping shows where contestants race around with a grocery cart. Embracing that theme, welcome to my trip down game show memory lane to revisit some famous and possibly not so famous game shows. Our journey will highlight some of what our office does and what is happening with capital formation in the small business ecosystem. However, before I test your game show acumen, I need to remind all of you that I am speaking in my official capacity as the Director of the Small Business Advocacy Office, and my remarks do not necessarily reflect the views of the Commission, the Commissioners, or other staff. For those of you who were here last year, you might remember I had only been the host, the Director of the Small Business Advocacy Office for 79 days. Today, while my duration as Director has lengthened in tenure to 16 months, one thing from those initial days holds absolutely true. This office is made up of an incredible bunch of dedicated individuals who are passionate about improving small business capital formation and serving as a voice for small businesses and their investors. While we may barely have enough folks to field a couple of Family Feud teams, this small team continues to amaze me on a daily basis with their accomplishments and commitments to the office's mission. Just looking at the current fiscal year, since October 2024, the office has engaged in 34 outreach events and dozens of policy meetings, produced the 2024 annual report, created new educational resources and content, reviewed dozens of proposed bills and amendments related to small business capital formation, and organized and hosted the 44th Annual SEC Small Business Forum. And that's on top of our daily collaboration with our SEC colleagues on matters of importance to small businesses and their investors. I am proud to be a part of this hardworking team and for the opportunity to serve alongside them as we seek ways to continue to support and advocate for the small business community. And now, I'm pleased to present the Small Business Advocacy Office. First up, let's play a little Jeopardy! Actually, let's jump straight to some double Jeopardy questions so I don't spill all the way into the lunch break. I'll start with little-known gems at the SEC for 1200. Congress created this office with the longest name in the agency to advance the interests of small businesses and their investors at the Commission and in the capital markets. You got it. What is the Office of the Advocate for Small Business Capital Formation? Many of the folks that our office advocates for may not have gotten that one, and we are on a mission to change that by getting the word out about who we are and what we do for small businesses and their investors. Small businesses cut a wide swath for this office, from a startup to a small public company. We are tasked with assisting in resolving problems, identifying areas where small businesses and their investors would benefit from changes in regulations, identifying problems that small businesses encounter with securing capital, analyzing the impact of proposed rules and legislation, and engaging in outreach on capital formation issues. How do we go about fulfilling these vital functions? We engage with the community. We meet, talk, and listen to small business founders, investors, and those parties that support them. And what do we do with all of that feedback that we learn and gather? It informs our advocacy on behalf of small businesses and their investors so we can amplify their voices. The questions that we get from the small business community often serve as indicators of areas where that community could benefit from additional clarity and where we can assist by working with our colleagues to help bring about solutions and by creating educational resources on those topics. In addition, we rely on what we hear from our stakeholders when we make the policy recommendations that we include in our annual report. The annual report is a culminating event for our office. We spend the year reviewing data and studies to report on what's happening with small business capital formation and to ensure that the policy recommendations are data-driven. Let's continue with little-known gems at the SEC for 1600. This is where you can find a wealth of educational resources for small businesses and their investors. Tough one, huh? Let's go with what is sec.gov, and that would be correct. You can locate our educational tools, resources, videos, and more from any page on the SEC's website by clicking on the Small Businesses link in the upper right-hand corner. We hope you will take the time or suggest that your clients take the time to explore the capital-raising building blocks, one-pagers that cover many of the fundamentals of raising capital. Take a gander at the glossary, which cuts through the legal and market-driven jargon used when small businesses raise capital. Or tune in to the Let's Talk Small Business video series to hear insights from experts and thought leaders in the field. Plus, don't forget to pop over to our office's homepage at sec.gov/OASB to dig into our colorful annual report, which showcases the state of small business capital formation. Watch the recent SEC Small Business Forum recordings, they're pretty good, or sign up for our email alerts to learn about upcoming events and new resources. The resources, videos, and annual report contain a wealth of useful information for anyone involved in small business capital formation. Plus, what better way to prepare for your upcoming appearance on It's Academic? I can see some of you remember that game show, where your knowledge of small business capital raising will be put to the test. Hey, does anyone know which states had the second greatest number of regulation crowdfunding or Regulation D offerings over the 12-month period ending June 30th, 2024? The answer to that question might score your team the top prize. Even though I'm inclined to send you to our capital trends maps to find the answer, I'll be kind and tell you the correct responses are Pennsylvania and New York, respectively. Next up, let's revisit another old game show favorite, the $100,000 pyramid. Small businesses need capital to open their doors, start operations, and grow. While some businesses hope to grow and scale their funding beyond $100,000, many are often seeking smaller amounts to get started. Recently, 58% of new businesses began operations with less than $25,000, and 41% sought less than $50,000 in external financing or credit sources. What are the primary ways that small businesses use that capital? To meet operating expenses, expand the business, or maintain available credit. Even though 40% of small businesses seek external financing, only 2% receive an equity investment, with those equity investments predominantly coming from the business founders or friends and family. Once again, echoing the importance of networks and support, including from other entrepreneurs, professional networking groups, and college alumni networks. Through our office's own outreach and engagement efforts, we have discovered time and again that even in many big cities, the local small business community gives small-town vibes with the networks of entrepreneurs, investors, and support organizations connecting by a few degrees of separation. Every year, our office has the privilege of speaking with a wide range of small business founders and investors from across the United States, as well as those who provide assistance, advice, and guidance to them. This gets me thinking about the game show Match Game. Does anyone remember that fill-in-the-blank show from the 60s and 70s? Here's an example. What would be a fill-in-the-blank response to this statement? Small and emerging businesses seek blank through an accelerator or incubator. The game-winning response would be support, but other matching answers might include network development, access to potential investors, mentorship from business experts, and business skills development. To cite a few more nuggets from the research reflected in our annual report, did you know that small businesses that participate in an accelerator program generate more revenue and hire more full-time employees? How about that angel investors play a key role in mentoring founders? Or that venture capital firms do the same by interacting with their portfolio companies at least once per week? These matches between small businesses and those who support them are an essential part of the ecosystem that helps to develop and foster founders on their capital-raising journeys. Many areas of the country have a vibrant ecosystem of startups and support organizations. I saw it firsthand last year in Kansas City, where a number of those support organizations can be accessed using the city's free streetcar system. Yet small businesses in many areas outside of the traditional capital-raising hubs still struggle to secure the necessary support and capital that they need. Talking to founders about how they seek investment capital brings to mind yet another game show, Let's Make a Deal, where an audience member might be selected based on their outrageous costume to make a deal with the host of the show. Now, founders may not resort to quite so much drama to get the attention of potential investors, at least I hope they don't, but they do often find themselves searching out the best deal. So, how do those potential deals pan out? Pre-seed and seed funding accounted for $6 billion of investments during the first half of 2024, with a median seed round of $3.1 million. Venture capital firms invested $86 billion during that same time frame, with a median round of $6 billion for Series A and B and $7 billion for Series C and D. Initial public offerings raised $19 billion during the first half of 24, with the technology industry leading the pack. No surprise there. While some companies are making deals, exit values generated across acquisitions, buyouts, and public listings have been on the decline. And the struggle to make a deal is further exasperated for those small businesses located outside of the traditional capital raising hubs. My time as your game show host is quickly coming to an end, and I certainly don't want to press my luck and have one of those whammies from that show pop up on the screens behind me. So instead, I will bring my remarks to a close and leave each of you with some parting words. Do not forget to spread the word about the Small Business Advocacy Office with your colleagues, clients, and those who support the small business capital formation ecosystem. This office exists to advocate and be a voice for small businesses and their investors. We continue to be committed to helping them find the support, guidance, and resources that they need to succeed on their journeys. One of the ways in which we can fulfill our vital role is to hear from founders and investors, as well as those who advise and champion them, like all of you. You can always reach us at smallbusiness@sec.gov with questions and ideas. And don't forget to visit our resources by clicking on that Small Businesses link on any sec.gov webpage, or relish the in-depth analysis provided in our annual report. I appreciate you being an engaged studio audience today, and don't blame me when you find yourself tuning into the Game Show Network tonight and yelling, "No whammies, no whammies." Enjoy the remainder of this wonderful conference, and the survey says, thank you.
So we are on a lunch break until 12:40 when we will resume with the accounting panel. Thank you.
Welcome back, everyone. Hope everyone had a good lunch. To keep the post-lunch energy up, I am pleased to announce our next panel, including staff from our Office of Chief Accountant. The panel will be moderated by Ryan Wolf. Ryan is the acting Chief Accountant and also, more near and dear to my heart, he is the Chief Accountant of the Division of Enforcement. He has over a decade of experience at the SEC in roles related to the Commission's oversight of the Public Company Accounting Oversight Board. Please consider the comments of these panelists. Ryan?
Thanks very much, Sam. Good afternoon, everyone. Thanks for being here today and joining the accounting panel. I'm Ryan. Again, I'm the acting Chief Accountant of the Commission's Office of the Chief Accountant and the Chief Accountant of the Division of Enforcement. I have a distinguished panel with me up here today. My colleagues, Heather Rosenberger, the Chief Accountant of the Division of Corporation Finance, and Anita Doubt, who's in the Acting Deputy Chief Accountant role for the Professional Practice Group in the Office of the Chief Accountant. Jensen Wayne couldn't be here today. He's the Chief Accountant of the Division of Investment Management, but we miss him, and we'd be remiss if we didn't acknowledge his and his group's expertise that really brings to the staff on 1940 Act issues. Before we get started, I know you're going to have to hear it again. I'm going to remind you that the views we're expressing today are our own in our official capacities and don't necessarily reflect the views of the Commission, commissioners, or other members of the staff. And to the extent that I discuss any enforcement matters, that would be as it was described in the Commission's order or complaint. We're going to do a brief overview of the various offices because it is confusing and discuss some of our priorities. But really, everything that we do is collectively anchored in the Commission's three-part mission, which is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. You've obviously heard that before. You're probably going to hear it a few more times. But what that means from OCA's perspective is that it means we're focused on promoting high-quality financial reporting information, and an important analog to that is also promoting audit quality, which adds to the credibility of that financial reporting information. I like to think about our work in OCA in four areas. First, OCA supports the Commission's oversight of the FASB and the PCAOB. Second, we engage with registrants or preparers, their auditors, and other stakeholders. And we're most often doing that through our consultation process, primarily related to accounting or independence matters. Third, we'll touch on this a little bit later, but we also engage with international standard setters, both with respect to providing perspectives on technical issues, through our participation in the Committee on International Organization of Securities Commissions, or IOSCO, and also with respect to the governance structures over those international accounting and auditing standard setting functions. And then the last thing in the terms of a bucket for what OCA supports is other Commission activities broadly. That includes the rulemaking agenda and enforcement activities, really wherever those activities involve accounting, auditing, or accountants. Before I pass it to Anita and Heather, I'm just going to preview that later I'm going to speak from my role as Chief Accountant of the Division of Enforcement, which, as you've heard from my colleagues this morning, conducts investigations into potential violations of the federal securities laws. And if necessary, it litigates those cases in civil enforcement proceedings. The division's mission is to enforce the securities laws, and that's a broad mission. But in my role, I'm most involved in the matters that involve application of GAAP and matters involving audits of financial statements. So that's from me. I'm going to send it over to Anita.
Thanks, Ryan. I also wanted to touch a little more on how the Office of the Chief Accountant supports the Commission's oversight of the PCAOB. So we assist with appointments to the board, efforts to consider new PCAOB auditing standards and rules, annual review and approval of the PCAOB's budget, and maybe another part of our oversight program is related to the inspections program. And so Section 104H of SOX basically gives firms the right to request an interim commission review with respect to PCAOB inspection report findings. So basically a firm has 30 days to submit its request once it receives its final inspection report or final determination notice related to a Part 2 quality control finding. So when we receive those requests, the SEC's regulation Reg P, Rule 140, kind of governs that whole process and kind of walks through the steps that a firm would go through in order to submit a interim commission review to us. It's pretty important to follow those steps, so if you ever do want to provide us with one of those interim commission reviews, highly recommend going and just looking at the Rule 140 to make sure that you can comply with those requirements. Based on the information that's then in the interim commission review, the commission, as facilitated by the Office of the Chief Accountant, we review the information that's provided in order to make a determination as to whether or not the PCOB acted in a manner that's considered arbitrary and capricious or otherwise inconsistent with the act. So with that, Heather, I'll turn it over to you for CorpFin.
Great, thank you. So as you've heard from a lot of the panels over the past couple of days, the overall mission of the Division of Corporation Finance is really to see that investors are getting provided with the material information that they need to be making informed decisions, whether that's in their initial filing or whether that's as they continue to provide filings and information to the market. The division also provides guidance to companies on SEC rules and forms and proposes new and revised rules to the commission. I've heard a lot about that yesterday and today as well. Specific to the CorpFin's Office of Chief Accountant, often referred to as CFOCA, we serve as the accounting and financial reporting experts for the division. So we'll support the staff in CorpFin through their various work streams. This could include consulting with the accountants in the disclosure review program to the extent that they've got questions on complex accounting and financial reporting matters. We also respond to requests from registrants or their advisors with if they have questions about substituting or waiving particular financial statement requirements in the filings that they're responsible for. We also provide technical assistance for rulemaking projects. And then just more broadly, we serve as the liaison on financial reporting matters to all other support offices within CorpFin, as well as many other divisions and offices in the SEC. So that includes working closely with Ryan and Anita and the other folks that are in OCA. I would say that, while our mission in CFO-OC has not changed, some of our people have. So maybe I'll just take a quick minute if I can, that in addition to myself being new to the role since this conference last year, we're also lucky to have Melissa Ramanpour from OCA serving as our acting Deputy Chief Accountant, along with Sarah Lowe, who remains in the other deputy position. And you had a chance to hear from Sarah yesterday if you participated in the CorpFin workshop.
So thanks. To you both. With that context, I want to dive just a little bit deeper into some of the oversight and monitoring activities that OCA has been involved with. I'm going to start with the FASB. The board has a new agenda consultation that's still in the comment period, so you can still provide your feedback. And for those less familiar with the board, this is a process where it solicits feedback on standard setting agenda. And I really want to emphasize that this solicitation is intended for all the stakeholders in the financial reporting process. That's the preparers, investors, auditors, academics, really anyone. And this is an opportunity to provide feedback to the FASB. And I acknowledge, having seen it and having us process it, how much work it is to actually be involved in that process. But it's incredibly valuable input. And the time spent informing that standard setting process really does result in higher quality financial reporting. So I thank those that are participating in that process, and I would encourage people to do it in addition. I think that evidence of the efficiency of the FASB's standard setting process is the fact that if you look at their recent agenda, a lot of the projects that they've recently completed have come from the previous agenda consultation where the stakeholder input really was critical. So Heather, I know that our respective offices have spent quite a bit of time over the last year speaking about implementation considerations related to one of the more recently completed projects, specifically ASU 2023-07, which were updates to the ASC 280 for segment reporting. OCA hasn't yet received any consultations in this area, but I'm curious what you're seeing from filing reviews for those that have filed.
Great. So as you may know, ASU 2023-07 was effective for registrants with fiscal years beginning after December 15th of 2023. So to that end, our calendar year-end registrants that were reporting under GAAP were required to reflect this adoption when they filed their 2024 annual reports earlier this year. So in places where the ASU adoption was required, the Division of Corporation Finance is evaluating those filings for compliance with ASC 280's amended disclosure requirements. It's probably a bit too early to talk about trends per se, but I can share a few data points that sort of relate to what the staff is accounting as they go through those reviews. So as expected, we're seeing single reportable segment entities providing those segment disclosures now is now required under 280. Also as expected, given the significant expense principles information that gets provided to the CODM, we're seeing a range of significant expenses being disclosed. So some entities, for example, are reporting several significant segment expenses, whereas some are just reporting one. We're also seeing some that are reporting no significant segment expenses, and instead they're disclosing an amount of other segment items and the nature of those expense information that the CODM is using to manage operations, and that's required by paragraphs 5026C and 5515G of 280. In addition to the, we're also seeing, in addition to that single required measure of segment profit or loss that's required, you may be interested to hear that we are indeed seeing some registrants that are reporting additional measures of segment profit or loss that's now provided for under the amended ASU. There have been some cases where those additional measures are being calculated in accordance with GAAP. We've also seen a few registrants that have reported additional measures that are not calculated in accordance with GAAP. So just as a reminder, those additional measures of segment of profit or loss are not required to be disclosed in accordance with 280. So to the extent that an issuer is reporting those additional measures that are not being calculated in accordance with GAAP, that's a non-GAAP measure, and that should be identified as such and comply with the SEC's rules and guidance around non-GAAP measures. Another reminder, and this is stemming from paragraph 5028C of ASC 280, is that particular requirement indicates that certain disclosure requirements are applicable to each reported measure. So that's, for example, the significant segment expenses I just spoke about a second ago, as well as the reconciliation requirements. So the point being here is that those additional disclosure requirements apply regardless of whether your additional measure of segment profit or loss is reported with GAAP, in accordance with GAAP or not. So these are just a few of the things we're seeing. It's definitely still early days. We have issued and we will continue to issue comments where we have questions or need to better understand how the registrant is applying particular aspects of the amended standard in their particular facts and circumstances, and we certainly look forward to sharing more as we continue to review those disclosures.
Thanks, Heather. So that's the GAAP side of the house. Anita, highlights from the PCAOB oversight.
Sure. So I mentioned earlier a bunch of the functions that we serve in the Office of the Chief Accountant to support the Commission's oversight. And one of those most important functions is our assisting the Commission in its review and approval of PCAOB auditing standards. I think from our perspective, my perspective as a regulator, we're really focused on high-quality audit standards. It's kind of the cornerstone of the whole process because it's what the inspectors inspect against and it's what the enforcers enforce against. So if you don't have robust standards, the two prongs for inspections and enforcement, they're going to have a challenge and have limited effectiveness. And the whole point of that is to drive accountability in the profession. And so effective standards are going to drive the behaviors that are going to be most critical to supporting audit quality. So it's going to be like professional skepticism, acting with due care, making sure that you're focusing on your priorities as a gatekeeper for investor protection and furthering the public interest and ultimately producing the opinion, which is to support of the financial statements and the accuracy of the financial statements. So on a related point, developments in today's environment, economic changes, technological changes, those have impacted the way audits are conducted. And so it's going to be really critical in order to update and modernize the standards to make sure that they're clear in today's environment. So maybe taking a step back and talking about maybe one of the most consequential updates to the PCAOB auditing standards since, I guess in my view, maybe the internal control standards, is that I thought maybe I could touch on QC 1000. So the existing PCAOB quality control standards were developed almost 30 years ago by the AICPA. That's in the pre-SOX time. And effective QC systems are going to be critical to investor protection. QC is going to be critical in any industry. So QC 1000 establishes basically a risk-based, principle-based quality control standard that requires that all the registered firms of the PCAOB design a QC system. One step further, for firms that are actually performing engagements under the PCAOB standards, they're also required to implement and operate that QC system. So the new quality control standard focuses on accountability and continuous improvement on a firm's audit practice. So one thing it requires, a new requirement, is an annual evaluation of the firm's QC system that's going to be reported on a confidential report to the PCAOB called Form QC. So this form is going to detail the firm's conclusion about the effectiveness of its QC system and any related details when the conclusion is anything other but effective with no unremediated deficiencies. And then it's also going to be certified by the firm's principal executive. So the firm's principal executive or CEO has to certify and take full responsibility for the QC system as a whole. And then there are individuals with assigned operational responsibility related to the QC system as a whole, ethics and independence, and then monitoring and remediation. And these are all folks that are named in Form QC. And if you would like to learn more about some of the requirements about Form QC and the certification requirements, you can please attend our breakout session this afternoon. So in addition to that, firms that annually issue audit reports for 100 issuers or more, they have additional specified requirements. One of those being related to an external quality control function. That's going to be one or more people who can exercise independent judgment regarding the firm's system of QC. And then there's also other requirements, maybe one that is automated monitoring of a firm personnel's investments regarding investments that could impair the firm's independence. So maybe as firms embark on implementing this standard, we want to kind of focus on the importance of getting it right. Quality control is going to be very critical to making sure we ensure high audit quality. But transitions are hard. This is a big standard. I think issues are going to come up, and the process is likely going to be iterative. So collaboration between the profession, the regulators, PCAOB, SEC, it shouldn't stop at adoption. So I think candid dialogue from those that are implementing with the regulators is going to be really critical in us all having a successful implementation effort. And we all want to also work with a mindset of good faith. We're all doing this with the pursuit of audit quality and trying to get it right, and that's going to be the best path forward for everyone involved. So maybe one last little closing remark with respect to QC 1000. We encourage consultation with us. Understanding implementation challenges as they're happening is going to be critical to us being able to help with implementation efforts. And so we encourage folks to come and talk to us, and we appreciate those who have come and talked to us. So Ryan, we talked a little bit about U.S. standard setting. How about regarding how the Commission engages on international standard setting?
Sure. Let's shift over to the international side and can give a brief overview of how OCA assists the Commission with its interaction with international standard setting. The Commission doesn't have the same oversight responsibility with respect to the FASB and the PCAOB in the international setting, but the staff is interested nonetheless in the work of the International Accounting Standards Board, which sets international financial reporting standards, and the International Auditing and Assurance Standards Board. And we're engaging with the IASB given the significant amount of U.S. investment in foreign companies, and since foreign private issuers are permitted to apply IFRS accounting standards without reconciliation to U.S. GAAP. And a lot of that engagement is really facilitated through our participation as a member of IOSCO's Committee 1, which it's called Committee 1, but it's actually the Committee on Issuer Accounting, Audit, and Disclosure. And that's the process where we're engaging with other securities regulators and the standard setting boards around the world on those technical topics. But there's also the governance perspective for those issues. So we're engaged with the monitoring board, which is the body that is the oversight of the IFRS Foundation, and then the monitoring group, which plays a role similar to the monitoring board, but with respect to global audit and ethics standard setting. So these are really important activities of our office, and they allow us to contribute to the global financial reporting process. But it also provides us an important window into the global business environment. And so that kind of leads me to wanting to step back and speak a little bit more broadly about the business environment in times of uncertainty and volatility. Uncertainty and volatility can be driven from multiple factors: economic policy, geopolitical developments, regulatory changes, technological innovation, shifting consumer sentiment. Those are just a few of the many things that can affect the process. And the presence of this change or uncertainty is not at all unusual. And I want to say clearly that I recognize that the difficulty that those types of circumstances present when you're attempting to provide investors with high quality information really does exist. But I do think that during these periods, the importance of diligence in the financial reporting process and effective communication really becomes even more apparent. When I say diligence in the financial reporting process, one of the things that I'm thinking about is the preparer's responsibility to consider all of the many ways that that uncertainty might affect the financial statements. And when I say effective communication, I'm not just talking about what's in the notes to the audited financial statements, but all of the other parts of the filing and the communications that paint the total picture for investors. And I am sure that there are probably some issuers out there for which market volatility and potential changes to the structural global flow of goods and services hasn't impacted their historical financial statements. But it's likely to affect future operations, your customers, and potentially your sources of liquidity. This is not necessarily a negative message. I think there's some good news here, which is that our capital markets are resilient. There are innumerable instances in our recent history where, despite facing uncertainty, preparers and auditors work through these issues in challenging environments and provided investors with the high-quality information necessary to make their investment decisions. So I do want to step back and mention that with respect to any financial reporting area, companies should be ensuring that their significant judgments and estimates are disclosed in a manner that is both understandable and useful for investors, and that the resulting financial reporting is consistent with the company's specific facts and circumstances. For example, with respect to fair value measurements and valuation methodologies, these should be updated and reassessed each period with current data and assumptions, even if the market data might be unlimited. Now it's the time where I do the customary plug for advertising the breakout panels. I'm in hot water here because they scheduled both the enforcement panel and the OCA panel at the same time. So I am going to split this baby clean in half and encourage all of you in the room to attend the OCA panel. And if you're watching at home or from the office, you should attend the enforcement panel. But why should you attend the OCA panel? I want you to attend the OCA panel later this afternoon because they're going to dive into more specific details and fact patterns. Accountants love details and fact patterns. And what are they going to talk about? Fair value measurements, impairment considerations, and estimating expected credit losses. And those are some of the areas that we expect to be affected. But there are certainly more places where uncertainty affects financial reporting, so diligence and effective communication remains to be important. And again, I'm not discounting the difficulty of incorporating that uncertainty into these accounting estimates, but preparers know their businesses better than anyone, and I'm confident that they're equipped to incorporate all of the necessary factors to make those reliable estimates. And then with respect to the auditor, I'm confident in the audit profession that it has the skills and expertise to really engage with that uncertainty with their clients. And I do believe that engagement will add to the credibility of financial reporting overall. So Heather, I talked about some stuff that was in the financial statements and some stuff that's outside the financial statements. But can you share some thoughts about how you think about the impact of things that are being communicated to investors outside the financial statements?
Yeah, so I'll start with MD&A disclosures, right? As a reminder, the MD&A rules in item 303 of SK, those require disclosure if a known uncertainty would be reasonably likely to have a material effect on future results or financial condition. I know that's a mouthful, but I was emphasizing those words on purpose as I went through. So I do think folks have an appreciation for this requirement, right, in terms of meeting the objective of management's discussion at the end of the day, which is to provide material information that's relevant to the assessment of financial condition and results of operation of the registrant. But however, when we think about, the known uncertainties, some of the things that Ryan was mentioning, right, there's often a challenge in assessing the likelihood of the known uncertainty. So, right, going back to the requirement, known uncertainty if it's reasonably likely. And so you might have trouble estimating that known uncertainty, whether it's actually going to come to fruition at the end of the day. And so even taking it to the extreme, what if that likelihood cannot even be assessed? And so in some cases, MD&A disclosure could still be required. And so to the extent that the likelihood of a known uncertainty is either not remote, so other than remote, or where management is in a position where they cannot make the assessment as to the likelihood, and the known uncertainty would be reasonably likely to have a material effect if it were to come to fruition, then disclosure is made if a reasonable investor would think about the omission of that information as significantly altering the mix of information that's otherwise available in the registrant's disclosures. So I know that was a little bit of a mouthful, but to be clear, immaterial or remote future events do not require disclosure. That's not the intention of the rule. So registrants should have in place disclosure controls and procedures to make sure that they're identifying these known uncertainties, whether that be an enactment of tax law changes, impact of rising prices, changes to tariff rates, maybe there's loss of customer contracts, right? Whatever the multitude of those uncertainties are that we've talked about throughout here are impacting your business, you should have those controls and procedures in place to be evaluating those. And so we would just comment that, to the extent maybe you haven't looked at the sort of the breadth of your disclosure and control procedures in a while, maybe now's a good time to revisit and make sure that sort of what was originally designed sort of is fit for purpose, right, in terms of the nature and some of the uncertainties we've been talking about. Also, as we think about the impact of some of these uncertainties on items just more broadly outside the financial statements, I'd provide two additional reminders I'll mention. First, when you're preparing to file your Form 10-Qs, just a quick reminder, right, you should be considering whether there's any material changes to risk factors or critical accounting estimates that were disclosed in the 10-K that need to be updated. And then second, with respect to disclosures being made in your periodic filings, and this would include your MD&A, just to make sure that those disclosures are aligned with the messaging that's coming through from an earnings release perspective, your published press releases on your calls or any of the other public statements that are being made by the company, just to make sure that there's consistency from that perspective.
Thanks, Heather. One more wonky accounting subject to get in, which is something that we've been encountering a little bit more frequently lately, which is distinguishing between business combinations and asset acquisitions. There are some transactions that have elements that would normally be present with business combinations, but should otherwise be classified as an asset acquisition. When a company acquires assets for which there is no specific asset acquisition accounting guidance, we've observed instances where companies have analogized to the business company guidance. So again, another plug for the OCA panel later this afternoon. OCA are going to walk through a few fact patterns where an asset acquisition had certain features more typical to business combinations. And I hope that those attending that session will come out with a better sense of the issue from a technical perspective. But I think my overall message to those of us who are not in the weeds on this issue is that when these situations arise, we would encourage preparers to work closely with their teams and with their auditors on these issues, and that we're always welcome to bring your issues to the staff for consultation in those instances. So I want to keep it on the topic of acquisitions, but really put it back in your world, Heather, which is specifically related to commission rules that would require issuers to include financial statements of businesses acquired pursuant to Rule 305 of SX, and the broader request for relief under Rule 313. So maybe talk to us a little bit about what you're seeing in this area.
So we do receive 313 waiver requests as well as interpretive letters on a variety of topics. But Ryan, as you just alluded to, the bulk of where we see that continues to be on the acquisition front. And that's primarily related to two areas when we boil it down to what we see on the acquisition front. The first being the Rule 305 requirements. And again, multitude of areas here, but again, if we had to boil it down to one, that's the most popular topic. It's typically when a registrant's running the 3 significance tests, maybe one of them is triggered and they believe the results of that particular test are anomalous and don't indicate materiality. The other area that we get a lot of waiver requests on, or interpretive requests as well, is the application of Rule 1101D with respect to the definition of a business. So in terms of volume, I think we've said this before, right? We saw a decline in the 313 waivers once the 2020 amendments to Rule 305 came out. I would say since then, we've seen a fairly steady volume of waiver requests. There's been peaks and valleys, right? And those tend to align with, increases and decreases in market activity, right? M&A transactions, IPOs, and so forth. The letters that we do receive, they're generally very complex. They're very fact-specific. So rather than going through anything in particular, I just will share a couple observations related to the requests that we've seen over the past year or so that might be relevant. So first, I just want to highlight that when you're seeking a waiver for some or maybe even all of the financial statement requirements of a particular acquisition that's met the 305 significance tests, but you believe that one of those tests has produced an anomalous result. Again, as I mentioned, this is a very popular area. And this is a situation where the staff then grants that particular waiver that you've come in with. What I want to be clear on is that the staff has not waived the applicability of the particular test in question. We have not accepted a substituted test or even concluded that that particular acquisition is not significant. Rather, the staff has acted within its delegated authority to waive certain financial statement requirements that have been triggered by the existing rules based on all of the facts and circumstances presented. I recognize that the end result may be the same, but we do feel this is an important point to highlight as you think about future fact patterns. Regarding the determination of whether the acquisition of net assets that do not comprise a whole entity meets the definition in accordance with 1101D, which again is another topic we receive a lot of interpretive requests on, companies are required as part of that assessment to consider the nature of the revenue-producing activity of the component being acquired and whether that will remain generally the same before and after the transaction. This particular criteria is the primary focus of the staff's analysis, and so we want to remind registrants that when you consider this criteria, you need to consider it in its entirety when you're completing your analysis, meaning that the continuity assessment that you're going through is of the nature of the revenue-producing activity. So registrants need to be considering whether the assets being acquired will be used for the same general activities after the acquisition occurs. And this is a qualitative concept, and it's fairly broad. So we thought it was important to mention that. I'll also highlight that this particular consideration does not indicate that the revenue needs to be exactly the same, right? It uses this concept of general. And so, also, I guess, to stick in here, as we've mentioned in the past, there's not a requirement for there to be revenues in the first place to meet the definition of a business, so that's not necessarily an out under the test. We do understand that often when there's a buyer of acquired business, they're going to do things differently. In many cases, that does not mean that the definition of a business under 1101D is not being met. So you may have new carrying values of the assets that are acquired. There could be changes in financing. There might be changes in processes, changes in management, or any other aspects of the business. And that's not unusual, right, to the extent that you would see that following a business acquisition. But the point that I want to make is these activities alone do not necessarily indicate that there's a change in the nature of activities, and they're not necessarily also eliminating the relevance of historical financial statements in the particular scenario. That said, we do recognize that every analysis is heavily dependent on the specific facts and circumstances. Maybe before I leave this topic, I will offer up some reminders on the process itself, and this would go to any 313 waiver requests or interpretive requests, not just those related to acquisitions. I share these as I think that anything that will support making the process more efficient for anyone involved is welcomed. We often are asked to make some of these turnarounds very quickly, and I think it sort of just helps to the extent we're sort of all playing by the same rule book. I would remind folks to take care, and I think we heard this a little bit yesterday on one of the CorpFin panels, that when you're reaching out or writing into the SEC, just to make sure that you're following the proper channels so that the inquiry that you're making or maybe the official submission that you're making gets to the right division or office. Not that we won't make sure that it gets there at the end of the day, but for example, if you've got a consultation related to a GAAP or an IFRS accounting matter, an independence matter, those are going to go to my OCA colleagues. To the extent that you've got a request on assistance for relief from the form and content of financial statements under SX or other financial information, that's going to come through CFO OCA, which is my office. Don't need to have all that memorized. The website does a great job of aligning and outlining where questions should go to, who they should go to, and how they should get there, including there's an online on CorpFin's page, there's a submission for 313 requests. In terms of submissions itself, and I think this holds true, whether this is something that's coming to CFOCA or to OCA, an accounting matter, I cannot stress enough the importance of the transparency and providing all of the sufficient details in your initial submission or the letter that you're providing. Lastly, I'll make my plug here for making sure that the right individuals are involved from the start of the process. So for example, I would encourage a company's auditors to be involved in the drafting of the letter to the extent relevant. And I'd encourage companies to consider who their primary point or points of contact for the discussions that are inevitably going to be held with the staff on the matter at hand. We often find that it's most helpful and efficient if that primary point of contact is someone, is an accountant, And it can certainly be more effective to the extent that that individual not only understands the rules and regulations of the SEC that are being applied, but they also are very familiar with the facts and circumstances of the transaction that's at hand. So again, this message here is just that choosing the right point or points of contact can save a lot of time and make the process more efficient.
So thanks, Heather. Interesting, and I would really relay the important point of involving your auditor in the consultation, if that's with OCA as well, and always interested in the facts of the views of the audit committee also. Anita, lots of accounting firm transactions and interesting new ways of structuring. Talk a little bit about that.
Sure. So pivoting more from the technical discussion, maybe something we have spent some time considering are trends related to accounting firm structures. So maybe at a macro level, we're seeing, globally, mergers and consolidation, non-CPA moving into the accounting space, generational shifts in how employees view being part of the profession, and firms trying to pivot to that in order to figure out how to give, for lack of a better word, kind of skin in the game in the firm earlier. And also, thinking about how accounting firms are diversifying their businesses beyond traditional consulting services, either through acquisition or just growing consulting practices. I think the punchline here is that the pace of change is increasing. And drilling down maybe on some of those, we're seeing continued private equity investment in accounting firms, and this is globally. And a lot of people predict that this trend is going to continue, and because PE investors continue to be attracted essentially to the steady and recurring revenue streams, recession-resilient businesses, and growth opportunities that are driven by the services provided by the consulting firm. And even more recently, we've seen venture capital firms investing in U.S. accounting firms. And I think something with venture that you kind of think about is that a lot of times they're looking to disrupt industry. So that's something that's very new, but something that we're watching. I think these transactions often require altering an accounting firm structure to comply with the state laws and regs that require an attest practice, so those providing any type of attestation service, to be wholly or majority owned by CPAs. But we're also noting other novel structures related to ownership structure. So in 2023, a large accounting firm in the US created an employee stock ownership plan. And so it transitioned from a partnership structure to more of a corporate structure. So this wasn't a PE deal, but it was partially funded with credit from private equity. And so we continue to be interested in what's motivating these behaviors. We've heard risk mitigation strategies, capital raising, among others. And we're also really keenly aware and interested on the impact of these trends and what risks and opportunities that they're bringing to the accounting firms and how it potentially could impact audit quality and investor protection. So let's start with the opportunities. For example, PE and venture capital firms are going to offer a multitude of benefits. Let's get capital, IT, expertise, process improvements, among other things. And then we also have to note the inherent risk that these type of arrangements present to audit quality. So PE and venture capital firms, they're not going to be subject to the same regs as a public accounting firm. And so their governance practices aren't going to be accustomed to one that is a public interest type profession. So this tension that's going to be here, if it's not managed properly, these arrangements could detract from regulatory compliance, accounting firm culture, audit quality, and essentially the public interest. So I think something to think about is that during and beyond the initial deal stage, firms should ensure that the audit quality is an organizational priority, and that audit and non-audit firms, when they negotiate these contracts to make budget and operational decisions, so basically when they're negotiating the deal with the PE firm, the budget is an extremely powerful tool. And a power imbalance between the PE firm and the audit firm, it's with respect to how funds are allocated to the different business lines, can really have a meaningful impact on audit quality. So something to remind auditors of is that the brand recognition and attractiveness of the non-audit firm to the PE investors, that's really going to be built upon the reputation that's coming from the audit firm and that business model of stable and recurring revenue. So really encouraging audit firms to consider structures with governance that make sure that the audit firm can prioritize long-term and meaningful investments in audit quality. So in addition to the audit quality concerns that can arise because of these structures, if not managed appropriately, I think it's critical to think about how restructuring, diversification of business, acquisition can have on an auditor and audit firm's ability to comply with the auditor independence requirements, so including the general standard. So, I don't have split allegiances. I'm only on Team OCA, so I'm plugging for the OCA afternoon panel. So if you want to hear more about some of these independence and monitoring considerations for these firms, please attend our OCA breakout session this afternoon. So it's just a final point. I think in a rapidly ever-changing economic landscape, there's going to be a lot of driving factors for accounting firms to consider as they're trying to promote growth, whether it's from consolidation or capital or other types of growth strategies. Irrespective of the structure, I think audit quality, compliance with the independence requirements needs to be at the forefront for audit firms in order to continue their critical gatekeeper function.
Yeah, I think those are important points and certainly something that the office and OCA is very focused on. So thanks, Anita. Let's switch gears a bit to talk about a popular and important topic. Heather, you want to take us through what's new or worth reminding this audience about with respect to non-GAAP measures?
Happily. So thanks for bearing with us as we jump around from a bunch of topics and try to get it all in today. I don't think we had a smooth transition from one to the other there, but again, non-GAAP is always something that we do like to make sure we get in when we're covering at conferences. So I think, as a lot of folks know, right, non-GAAP is really it's a popular topic. It's a popular topic with our comment letters too. It tends to be the number one comic theme, particularly when we talk about the concepts of prominence and labeling. So quick reminders there. As you think about prominence and labeling in the non-GAAP rules, I would just really stick to what I think are the fundamental premise of each of those concepts. And so with prominence, it's just, hey, present the most directly comparable GAAP measure and do so with equal or greater prominence. And that premise, just as a reminder, holds true whether or not it's the headline or whether it is the presentation of a non-GAAP measure that's showing up in a chart or a ratio or a table. With respect to labeling, there I would say the fundamental premise is really just for preparers to make sure that disclosures are sufficient so that investors understand the nature of each of those non-GAAP measures and the adjustments that are being made to the GAAP measure. So, we get often, we have comments, and so when folks are addressing these comments that they might have gotten on a labeling matter, I guess I would note that relabeling that measure may not necessarily, in all cases, be sufficient to sort of resolve that comment. And there might be further analysis based on understanding what's behind that particular adjustment that might come through that causes the review team to submit, a follow-up comment so that they can complete their analysis about whether that non-GAAP measure is potentially misleading. In addition to the less subjective label and prominence comments, we also continue to issue comments in the more judgmental areas. These are primarily two areas that we've spoken about before. These are adjustments that have the effect of excluding normal recurring operating expenses or adjustments that have the effect of changing the GAAP recognition and measurement principles. Those are what we refer to as tailored accounting. There, again, just a quick reminder. You can take a look at CNDI 100.01, but that's sort of the premise on the normal recurring cash operating expense guidance. And so in terms of thinking about whether or not that measure is ultimately could be misleading, I just want to highlight that the expense or the adjustment that's in that particular measure doesn't have to include all three of those factors to necessarily render its exclusion to be misleading. But again, as the staff takes a look at each of those measures and each of those adjustments, they're doing so in consideration of the particular non-GAAP adjustment and how it relates to that company and their specific set of facts and circumstances, what their revenue generating activities are, what their business strategy is, what industry they're representing. So with those general observations, I do want to shift a little bit and staying on non-GAAP, but shift a little bit and talk about two specific types of non-GAAP measures. The first is contribution margin measures. So in past public remarks, we've discussed our observations around these particular contribution margin measures. We've said that companies may present these measures as long as the measure has an appropriate label or name that represents what it actually is. In addition, we've said that these types of non-GAAP measures should be reconciled to a fully loaded gross margin, as that would be the most directly comparable GAAP measure. Recently, We've seen a few instances where fintech companies disclose non-GAAP measures that are very similar in nature to the contribution margin measures that we've seen in the past from other companies and other industries. Like contribution margin measures, we did not find those measures being disclosed by the fintech companies to be misleading. A key difference, though, is that we did accept a reconciliation of these non-GAAP measures from GAAP operating income rather than GAAP gross margin. The reason being is that GAAP gross margin was not meaningful in the context of the fintech company's operations, and there was no existing methodology for those companies to allocate costs in a manner that would even allow them to calculate a fully loaded gross margin. So I share this recent example to highlight that there may be instances where the most directly comparable GAAP measure is something other than a fully loaded gross margin. I'm not sharing to indicate that reconciling non-GAAP contribution margins from operating income is necessarily appropriate in all industries or all cases. And further, and to be clear, I'm not suggesting that companies should be changing their existing reconciliations. On another measure, a specific non-GAAP measure that I'll mention briefly are on debt covenants, related to debt covenants, which is non-GAAP C&DI 102.09. To the extent that an entity is disclosing a measure that's calculated in accordance with a debt covenant, and they're doing so in their liquidity and capital resources section of MD&A, and they're doing so because they believe that that disclosure is required to comply with item 303, the staff's not going to object to that presentation. Again, if the measure is required to be disclosed in MD&A by the Commission's rules, it's ultimately excluded from the definition per 10E5 of Regulation SX in terms of it being a non-GAAP measure. Where you do see the staff objecting on occasion is that if that non-GAAP measure that's being calculated in accordance with the debt covenant, it's being disclosed as a measure of performance, and then there's a particular adjustment in there that makes the measure potentially misleading, right? Maybe you're changing the recognition of the revenue patterns of GAAP. That's where you would see the staff object. So I just want to make that distinction. As I wrap up the non-GAAP thoughts here, I just want to expand on this concept of individual facts and circumstances that we often reference, but do so in the context of non-GAAP. So as you are taking a look, or registrants or issuers or even their advisors are taking a look at what non-GAAP measures are permissible to disclose, we understand that they may be looking to competitors or even registrants in other industries to understand what types of non-GAAP measures folks are using and disclosing and being presented, as well as the types of adjustments that are being calculated in those measures. If a registrant observes the presentation of a measure that seems comparable to a measure that they intend to use, you still need to make sure that you're making your own evaluation as to whether that measure is appropriate and provides useful information to your investors. As part of this process, you should be ensuring that the adjustments that you're making are not resulting in the disclosure of a misleading non-GAAP measure. Because the evaluation of whether a non-GAAP measure is misleading requires a careful consideration of the specific facts and circumstances, one registrant's fact pattern might not necessarily apply to the others, even if it seems to do so on the surface. So it's useful to understand those different types of non-GAAP measures. Registrants need to make sure that their own disclosures are appropriate in consideration of their own operations, right? The comparable amounts that they're being presented are doing so in accordance with GAAP, and they're having the right disclosures on the nature and effect of the individual non-GAAP adjustments.
Great. So I'm going to talk about enforcement a little bit in the home stretch here. And when you're doing two roles, as I've been doing, people like to talk about what type of hat you're wearing. But then accountants are nerds, and we like to talk about what type of green eye shade are you wearing. For those of you who don't live in the 1920s and don't know what a green eye shade is, it's a visor that old-timey accountants would wear to make sure that their eyes wouldn't get strained. I actually brought a prop. I think this is the first time in SEC Speaks that there's a prop. This is a green eye shade. And if you actually look under your seat, there's a PLI-branded green eye shade that you can take home. That's a joke, but I did get some of you in the audience. And if you take nothing away from this conference, take away that bit was not my own making. That was from one of the chairman's counsels who suggested that. So if nothing else, you should expect comedy gold from the Atkins Commission going forward. Back to enforcement. I think obviously enforcement is really important, and when I'm thinking about the hats and the different roles that I'm changing, I don't think that it's really that drastic of a shift. We've been talking this panel about all of the things that we do as a collective ecosystem to really make sure that we have high-quality financial reporting and we promote audit quality. And we're working really hard to make sure that that happens. But the high-quality standards, those are indispensable, but they're not in and of themselves sufficient because they're not self-executing. Absent a diligent enforcement angle, even the most robust regulatory framework will fail to produce that high-quality financial reporting. And so that's why this dual approach really works well. Establish the clear standards and enforce them in predictable ways. That's the essential piece of protecting investors, maintaining market integrity, and encouraging capital formation. And so you heard this morning from the enforcement panel about the breadth of our remit. You're going to probably hear more for those of you not attending the OCA panel. And I don't want to repeat that, but I would like to highlight the work of some of the 90 or so talented accountants across the home office and in the regions and the key role that they play. Investigating potential violations of securities laws, making recommendations to the Commission to take enforcement action when appropriate, and supporting teams in litigation. I said when appropriate, and I think that I want to spend a little bit more time on that because it really is vital. Our accountants, in cooperation with the division's attorneys and others on the agency, really do rely on their expertise and experience to distinguish when a violation discovered through an investigation warrants an enforcement recommendation versus no enforcement action, or perhaps some other type of remedy, like a referral to one of the other important programs at the Commission, the Disclosure Review Program in Corp Fin, if it's in the investment advisor and the broker-dealer space, referrals to the National Exam Program and our colleagues from the Division of Examinations. So, as I've noted, enforcement might identify a violation, but based on that entity or individual's timely self-reporting, cooperation, and remediation, the division may elect not to recommend the Commission bring an enforcement action. And there are many times when investigations do identify violations related to financial reporting or internal accounting control deficiencies. But our assessment of those factors, again, I'm going to say them again, timely self-reporting, cooperation, remediation, leads us to close that matter without recommending enforcement action. And sometimes it is very clear that an enforcement action is warranted. And in that case, I expect the Commission to continue to act. I think that's consistent with what you heard this morning. Obviously, if you haven't noticed by now, we do have a new chairman. And those who closely watch the SEC, including the Enforcement Division's activities, will likely anticipate changes to that program. And obviously, I think that's a fair assumption, but I do want to highlight a few cases that the Commission brought over the past year and tell some stories that I think, while certain of the charges that were included or the remedies that were obtained in those cases might be different if those cases were considered today, nonetheless, they still involve clear violations of GAAP and violate the larger principle, which is just to tell investors the full truth. The first case I'm going to talk about is UPS. That's a name we all know. We all get packages. The Commission brought a settled action against the company in November of last year. And the issue at UPS involved its freight segment, which was a business unit that transported, the less than truckload shipments. And at first glance, the issue in the UPS case, it really does look technical because it's about insufficient support for the value of reported goodwill in that particular segment. But I think that this is another instance where management is viewing its business in a way that was really at odds with the story that it told investors through its financial reporting. And that's because the freight segment wasn't performing well. And management was looking at its strategic options, and it estimated that it would only be able to sell that business for between $350 and $650 million. That was despite a carrying value of $1.4 billion. Now, as a general matter, GAAP would tell you when indications of impairment exist, you need to do more to support the value of the asset recorded on your balance sheet. But when UPS performed impairment testing for the freight unit, it didn't consider those indications of value that reflected the poor performance of the business. Rather, it provided its valuation specialists with assumptions that would not be consistent with market participant views. And according to the order, That valuation specialist used those assumptions to support a carrying value in excess of $2 billion and avoid recognizing any impairment. And I know like the fellow GAAP nerds out there in the audience would love for me to keep going down the rabbit hole, but I don't want to lose the forest for the trees, and I really do want to simplify what was going on here, because this is something that we see often in the enforcement context, which is that management at a company was actually pretty good at making reliable estimates about its economic situation internally. But then when it was time to inform investors, the company prepared financial reporting that told a very different story. And what were the consequences of those different stories? From the accounting standards perspective, there was delayed recognition of impairment losses, inflated assets, and overstated earnings for multiple periods. And those are how the elements of the financial statements were affected. But those misstatements really did tell a story to investors that was different from the reality that this business was struggling. So that's a case about inappropriate assumptions and delayed impairment. But there's another case I want to talk about with the same underlying principle, which was the commission brought a settled action against Becton Dickinson and Company in December of last year. And this was about one of their very important products that was a medical device that made up about 10% of its profits during that period. And so over several years, the company had identified that there were flaws with that product and identified a risk that the FDA would limit the company's ability to continue selling that device. And according to the commission's order, the company ultimately revealed those software flaws to the FDA, but didn't disclose those discussions as that case unfolded. Becton continued to sell the device while misleading investors about its regulatory compliance, and they didn't inform investors of the material risks that the FDA would prohibit Becton from selling that device. So that was a disclosure piece. But there was also an accounting issue, because the company also understated a liability and overstated its operating income by failing to accrue the expenses to actually fix that software flaw that it knew was probable. Again, a situation where a company is assessing its business one way, but painting a different picture for investors. I want to talk about AI a little bit, not in the enforcement context, so I'm going to cut one of the cases, which is the Lovesac case, but check it out, it's not Love Shack, it's Lovesac. They make furniture, but an interesting case about accounting misstatements. I am not allowed to talk about AI because every time I do, I just spend the whole time trying to make a Terminator or Skynet joke. So I'm putting you all in better hands and letting Anita and Heather take it. So, Anita?
Great segue, thank you. So Heather noted we were a little choppy in our transitions today, but we had a lot of interesting content to talk about today. I think responsibly integrating AI into financial reporting, one thing that we've been thinking about a lot in OCA is kind of how you go about doing that, and I think we've been trying to think about it in the stages. And I think step one is going to be to appropriately incorporate it into financial reporting you're going to have to start with your risk assessment and make sure that your risk assessment is sound in order to be able to identify the risks and then appropriately identify the processes downstream. I think AI is going to introduce new risks, and therefore they're going to require different responses than maybe legacy technology, but the foundations of risk assessment are going to remain the same. The considerations that I'm going to talk about today are equally applicable to auditors and management as they evaluate and design their responses. And I think one area with significant impact on risk assessment from AI is going to be the entity's governance. And so kind of starting that with a picture, you're going to start with governance when you're thinking about from your entire ICFR framework, and then you'll move into the more detailed risks related to AI use in financial reporting. And so I'd like to highlight a couple of those related to explainability, just the iterative nature that's inherent in AI, and then the extent of human involvement. So maybe we can just take those one by one and then turn it over to Heather to talk to you guys about some disclosure matters with respect to that. With respect to explainability, I think of that as maybe the audit trail. So this is going to refer to the ability to understand how the AI models are arriving at their conclusion. So this is going to be critical in determining whether the output from your AI is reliable. And this is going to be especially relevant for ICFR because there's this required level of rigor around the documentation of the processes and controls for ICFR controls. So there are times where the design of the model can assist in the explainability. So think about it like you ask Google a question, right? And the AI generates a response, and then on the side you can see that there's the links to wherever where the AI got its information from. That trail on the side is essentially its explainability, and I will say that I have definitely gotten answers from AI before where I was like, that doesn't feel right, and you start clicking through the links, kind of going through the audit trail of where it got its information, and you're like, wow, it's because it's not right, because it started providing false information. So that explainability is going to begin with the model design. So you're going to have clear documentation on the model's purpose, the data it's using, the assumptions it's using, and regardless of whether the model is developed in-house or from a third party, it's going to be essential to have the documentation at a level appropriate so that it can be reviewed by stakeholders at the entity and by the auditor. So in many instances, explainability and sophistication are going to be trade-offs, right? Because the more sophisticated the model becomes, the harder it may be to explain how it got to its answer. So when you're thinking about selecting an AI model, it could be beneficial to consider whether a simpler model could get the job done. So like a decision tree or a regression model, maybe that can get you where you're going with less sophistication, and then you have less risk because it's more transparent as to how the AI got to the answer. As soon as you introduce complexity into the model, your level of work to gain an appropriate understanding of how it got to its answer is going to increase. Maybe another risk is related to this constantly iterative nature of AI. And how the changes to the AI model are monitored. So in a traditional testing approach, right, for technology that's used in FRP, you're going to see the logic is tested, it's approved, and then it's locked, with changes going through certain change management controls, and those changes are driven by internal things that are happening at the company. And then you're going to have this periodic assessment about whether the model continues to be fit for purpose. So in the traditional IT model, once the code's locked, you have comfort that the output's going to be consistent. And so monitoring for the changes, like I said, is going to be in management's control. The same's not going to be the case for AI. An output with the same inputs over time could change as the model gets smarter. So while the testing and approvals and the setup of the model is going to be important prior to deployment, for AI models, it's not going to provide the same level of ongoing reliability that a static model is going to provide you. And so when considering program change IT general controls, there's this concept of something called model drift. So there's a decline in the performance of the model over time due to changes in the environment, which could include factors that are both internal and external, so out of management's control. So with an AI model, there's going to need to be more proactive and frequent monitoring to assess when these changes happen. And so now you've added subjectivity that doesn't exist with a static model regarding when the changes are occurring that trigger the change management process. So then that's going to make the importance of the monitoring and the determination of when there's a critical change more important. I think use of critical too many times in that sentence, to assessing whether the model's working effectively and as you plan for it to work. And the last concept maybe I'll cover today quickly is this concept of human in the loop, and it's fancy words for how many times is the human involved in the AI step, and how many points of human intervention are there. And so, appropriately designing human intervention at those critical points is going to be important in helping deploy these AI models. So responsible AI integration is going to be really important to incorporating it into financial reporting, and the importance of risk assessment and identifying the risks so that you can appropriately design your controls. And Heather, I'll turn it over to you for some financial reporting.
Yes, I guess I'll just leave you with a really quick reminder on AI, right? As the use and the development and the regulation continues to evolve around AI, we just want to encourage public companies to take time to take a close look at the disclosures. Again, it would always encourage you to make sure that you have very tailored disclosures and try to avoid those boilerplate disclosures that we know are not as informative to investors.
Great. Thank you both. We have 1 minute left, so I think that brings us to the end of the panel, but thank you, Heather, Anita, and the opportunity to talk to you all about financial reporting and auditing issues. And again, just a last minute plug for both the OCA panel that will be this afternoon and the enforcement panel that will also be this afternoon at the same time, but also available on YouTube, so you can watch them both. Thanks, everybody.
Not at the same time, though.
Okay, welcome back again. Next up, we're going to hear from senior staff from the Office of General Counsel to discuss judicial and legislative developments. The panel will be led by Jeffrey Fennell, the SEC's acting General Counsel. Jeff has been serving in that role since January of 2025. He has more than 20 years of experience at the Commission, having served in various leadership roles as an Assistant Director in Enforcement, as Chief Counsel in the Office of Information Technology, and as Deputy General Counsel in the Office of General Counsel. Please consider the comments of these panelists. Jeff?
Okay. Thanks, Sam. Thanks for the kind introduction. I'm honored to be up here together with some of my terrific colleagues from the Office of General Counsel, and I'm thrilled to be back in OGC as we continue to work hard to provide the best advice we can to the chairman, the commission, the commissioners, the divisions and offices, and the crypto task force in order to implement Chairman Atkins' agenda. Before I give a brief overview of our office and introduce the panelists, I will provide our standard disclaimer, as you would expect from GC, that our remarks are given in our official capacity but do not necessarily reflect the views of the commission, the commissioners, or any other staff member. One of the best parts of my job in being back in OGC is that our portfolio touches every aspect of the work of the agency. Our administrative law and legal review group advises on SEC rulemaking. Our GC enforcement and whistleblower review group, as the name indicates, advises on enforcement and whistleblower matters. Our general law group represents the agency in matters ranging from employment and labor relations issues to leasing and attorney disciplinary actions. The latter subject will be part of a panel discussion later this afternoon that I hope you pay attention to. Come and join. And also there's OGC's adjudication group, which assists in preparing commission orders and opinions in litigated administrative proceedings and appeals from SRO disciplinary actions. And I do have to keep leaning forward, I'm hearing. The members of our panel this afternoon are part of the remaining branch of OGC, our appellate group. As many of you know, the appellate group represents the commission in appeals from district court enforcement actions in challenges to commission adjudicatory opinions and rules, and where the commission appears in non-SEC cases as an amicus curiae. The appellate group also works with the Office of the Solicitor General in securities matters in the Supreme Court. And now I'm pleased to introduce the members of the appellate group who make up our panel. I will want to note that anybody who said the appellate group doesn't have a sense of humor, you're wrong. I got a nice script of the introductions by their title and the order in which I would introduce them, and they have proceeded to shuffle themselves pretty well. So I will do my best not being able to see down the panel. So hopefully I'll get it right. But so Tracy Harden is our solicitor. And next to her on the left is Dan Starosowski and Jeff Berger, both assistant general counsels. I'm looking, next to them is senior appellate counsel Rachel McKenzie, and senior appellate counsels Emily Parisi, Ted Wyman, and Paul Alvarez, Dan Matro, and and then following is appellate counsel Archith Ramkumar, and last but not least is special senior counsel Sam Goldstein. They're all members of an exceptionally talented group of lawyers who have worked incredibly hard to achieve great results for the agency and to the investors and markets we protect. Now we'll turn to Tracy to lead off our discussion on some of the interesting legal issues we've been dealing with.
Thanks, Jeff. We're going to start our discussion today at the Supreme Court. So since the last SEC Speaks, the Supreme Court issued a decision in Macquarie Infrastructure Corporation versus Moab Partners. That case addressed the question of whether failing to disclose information required by a commission regulation can give rise to liability under Section 10b and Rule 10b-5. Rachel, if I can see you down there, do you want to tell us a bit about the history of the case?
Sure. The court granted cert to decide the same question back in 2017 in Leidos versus Indiana Public Retirement System, but that case settled before oral argument, and it took several years for the issue to make its way back to the court.
Did Leidos and Macquarie involve the same regulatory disclosure requirement?
Yes. Item 303 of Regulation SK, which lays out what issuers have to disclose in the management's discussion and analysis of financial condition and results of operations, or MD&A, in a 10K or 10Q. More specifically, item 303 requires issuers to describe any known trends or uncertainties that have had or that are reasonably likely to have a material impact on sales, revenues, or income. The MD&A in item 303 provides a narrative context from management's perspective of the financial reporting, which helps investors judge past performance and what the future holds.
How did the requirement come up in Macquarie?
So plaintiffs claimed that Macquarie artificially inflated its stock price by filing 10Ks and 10Qs that disclosed some known trends and uncertainties, but didn't disclose an additional known uncertainty that item 303 called for, which was that forthcoming international regulations, which would largely eliminate a certain type of fuel oil, could adversely affect the fuel storage business of one of Macquarie's subsidiaries. Plaintiffs claimed that the omission violated Section 10B because that information was material, and Macquarie had acted with scienter in omitting it.
So, unlike the Commission, private plaintiffs cannot bring actions for violations of 303 itself, but they can bring 10B claims, and in that context, there has to be a duty to speak for an omission to be actionable. So a duty to speak can arise in a few different ways, such as when there's a legal requirement to speak, when an issuer has spoken in a half-truth, in which case it must then disclose information that would make what it said not misleading, and or a duty based on a common law relationship of trust and confidence, particularly in the insider trading context. And that leads us to this case. Jeff, do you want to talk a little bit about why you believe the Supreme Court granted cert on this issue twice?
Sure. Because of a perceived circuit split. The Second Circuit, in cases like Macquarie and Leidos and previously, had held that an omission of information required by item 303 can give rise to liability under Section 10B when all the other elements for a private right of action, including materiality and scienter, are satisfied. The Third Circuit had also addressed this issue in an opinion by then Judge Alito in a case called Oran. And Oran said that item 303 requires the disclosure of information that would not necessarily be material for purposes of Section 10B. So the court concluded that a violation of item 303 does not automatically give rise to a material omission under Rule 10b-5. But the court did not foreclose the possibility that a violation of item 303 could give rise to a material omission under Rule 10b-5. The Fifth and the 11th Circuits had reached similar conclusions based on Oran, but the Ninth Circuit read Oran as foreclosing the possibility that item 303 creates an actionable disclosure duty, and it held that an omission is only actionable under Section 10b if it fits into the half-truth rubric, the idea that the omission makes something that was disclosed misleading.
So the government filed an amicus brief in support of the plaintiffs at the merit stage in both Macquarie and Leidos. What was the government's argument?
So consistent with the Commission and the government's longstanding position, the government took the position that the disclosure of some, but not all of the information required by item 303 fits comfortably into this half-truth rubric. It argued that an issuer is always speaking in a 10K, and a reasonable investor would expect the MD&A section of that 10K to disclose all the required information. So if an issuer omits what item 303 requires, there's a misleading statement that may be actionable, again, if the other required elements can be established. So if an SEC rule requires an issuer to identify, for instance, every pending lawsuit against the issuer that seeks more than $10 billion in damages, and the issuer lists 10 such suits, a reasonable investor would read the filing as a representation that the list was exhaustive. The failure to disclose an 11th suit, however, seeking $20 million, would be misleading.
Rachel, do you want to tell us a little bit about the court's ruling?
Sure. The court issued a unanimous and narrow ruling. The court construed the case as turning solely on Rule 10b-5b and whether its prohibition on misleading statements bars only half-truths or also extends to pure omissions, which it understood to mean a situation in which a person or entity has said nothing at all. The example it gave is when a company fails entirely to file an MD&A, in which case an omission has no significance because no information is disclosed. Using an analogy, the court wrote that, quote, the difference between a pure omission and a half omission is the difference between a child not telling his parents he ate a whole cake and telling them he had dessert.
So what did the court say about liability for what it construed as pure omissions?
So the court said that Rule 10b-5b does not bar pure omissions. It focused heavily on the text of that rule, stating that logically and by its plain text, the rule requires affirmative assertions, statements made before a determination can be made whether more information is needed to make those statements not misleading. The court also looked to statutory context, citing the differences between the rule and the text of Section 11A of the Securities Act, which does create liability for pure omissions. That is a failure to speak at all. The court added that even a duty to disclose, such as a legal duty, does not automatically render silence misleading under Rule 10b-5b, and thus the failure to disclose information required by Item 303 will support a claim under Rule 10b-5b only if the omission renders affirmative statements misleading.
But the court also created some significant caveats, right? Can you tell us a little about those?
Yeah, that's correct. First, the court highlighted that the commission has the authority to enforce statutes and rules requiring the filing of reports and failures to comply with regulations, such as Item 303. Second, and most significantly, in an important footnote, the court stated that it was only addressing the lower court's pure omission analysis and not its half-truth analysis. So the court did not opine on whether plaintiffs had sufficiently articulated a half-truth claim or whether the other parts of Rule 10b, subparts A and C, could support liability for pure omissions.
So the court vacated the lower court's judgment and remanded. What happened on remand, and what's happened more generally in terms of the judiciary's reaction to an application of the decision?
So on remand, the Second Circuit affirmed the district court's dismissal of the plaintiff's Rule 10b-5b claims that rested on a pure omission theory, but vacated the district court's dismissal of plaintiff's Rule 10b-5b claims premised on a half-truth theory. Other courts have proceeded similarly, reading Macquarie as a narrow decision that forecloses only Rule 10b-5b claims premised on pure omissions.
Thanks, Rachel. We're now going to turn to Paul Alvarez to discuss SEC versus Navalier. It's a recent First Circuit decision that addresses liability and remedies under the Investment Advisors Act. Paul, do you want to give us some background on the case?
Sure. Thanks, Tracy. Louis Navalier is the founder and CEO of a registered investment advisory firm, Navalier & Associates, which I will refer to here as NAI. In 2009, Navalier and NAI licensed certain investment strategies from another investment advisor, F Squared, and then they recommended those strategies to clients, touting F Squared data ostensibly showing that the strategies had helped other investors avoid the previous two bear markets between 2001 and 2008, including the then recent Great Recession. But Navalier and NAI understood that the data did not reflect actual historical trades. The data instead showed, with the benefit of hindsight, how hypothetical investors would have performed between 2001 and 2008 had they used the strategies. Indeed, Navalier acknowledged in internal emails that the strategy's past performance claims were, quote, just made up and pure fraud, end quote, and were based on, quote, a bogus spreadsheet, end quote, that the strategies, quote, smelled like pure fraud, and that, quote, when the lies become evident, Navalier and NAI would be put out of business. In 2013, Navalier and NAI sold the strategies and associated client accounts back to F Squared. Navalier told NAI employees that the sale was intended, quote, to clean up the mess from the, quote, obvious fraud. But Navalier and NAI did not inform their clients that Navalier and his firm's representations about the strategy's past performance did not reflect actual trades, nor did Navalier and NAI tell those clients that he and NAI were selling the business to a buyer that they believed had committed fraud, F squared.
Thanks. Do you want to maybe tell us a bit about the enforcement action that the commission brought against Navalier and NAI?
Sure. The commission sued Navalier and NAI in federal district court, alleging that they violated Section 206 of the Investment Advisors Act of 1940. That provision establishes federal fiduciary standards for investment advisors and prohibits advisors from defrauding their clients. The court granted the commission's motion for summary judgment and ordered remedies, including disgorgement.
So there was then an appeal, right? So can you tell us what happened on appeal?
Yes, the First Circuit affirmed. With respect to liability, the First Circuit held that there were no genuine factual disputes about whether Navalier's and NAI's misrepresentations were material. The court explained that a reasonable investor would find it important that the investment strategy's performance figures were hypothetical and were not based on actual trades. The court noted that the SEC had previously alerted Navalier's firm to the necessity of disclosing whether past performance figures were based on actual trades, and that, quote, Navalier himself acknowledged the importance of this disclosure in the firm's internal emails.
How did the First Circuit approach the disgorgement issue?
The court affirmed the disgorgement award as well. Navalier and NAI argued that the SEC could not obtain disgorgement because their clients did not suffer pecuniary harm. But the court rejected that argument, explaining that the Supreme Court's decision in Liu v. SEC does not require investors to suffer pecuniary harm as a precondition to a disgorgement award. The court also determined that, in any event, Navalier's clients were harmed because the misrepresentations had induced the clients into paying advisory fees.
So Navalier and NAI then petitioned the Supreme Court to review the First Circuit's disgorgement and liability rulings. How did the government respond?
The Office of the Solicitor General, which represents the commission before the Supreme Court, filed a brief in opposition arguing that the cert petition should be denied. The brief argues that the First Circuit correctly determined that an award of disgorgement does not require a showing that investors suffered pecuniary harm. As background, Congress has authorized the SEC to seek and district courts to grant, quote, any equitable relief that may be appropriate or necessary for the benefit of investors. In Liu v. SEC, the Supreme Court held that this provision authorizes disgorgement, that is, an order requiring a wrongdoer to surrender profits gained through violations of the securities laws. After Liu, Congress enacted an amendment that specifically authorizes the Commission to seek in district courts to grant disgorgement of any unjust enrichment received as the result of a violation. The SG's brief explains that disgorgement is a profits-focused remedy that rests on the principle that a wrongdoer should not make a profit out of his own wrong. While damages compensate a victim for a loss, disgorgement deprives a wrongdoer of ill-gotten profits. The availability of disgorgement therefore turns on whether the violator has made a profit, not on whether the victim has suffered a loss. And petitioner's contrary argument is especially inapt here because this case arises out of petitioner's violation of fiduciary duties.
So as I understand it, the petitioner's argument is that Liu permits a court to award disgorgement only to victims and that an investor who suffered no pecuniary harm can't be a victim. How did the government respond to that argument?
Liu interpreted the phrase in Exchange Act Section 21D5 that equitable relief must be appropriate or necessary for the benefit of investors to mean that where feasible, proceeds recovered through disgorgement generally must be, quote, dispersed to known victims, unquote, rather than deposited in the Treasury. The disgorgement award in this case complies with that rule. The district court found expressly that, quote, the commission intends to distribute to petitioners' clients any disgorgement awarded. The brief argues that petitioner's argument also fails on its own terms because their clients did suffer pecuniary harm. The district court found that petitioners' victim clients had suffered harm because petitioners had fraudulently induced them to become clients and to pay investment advisory fees totaling $22,775,867. The Court of Appeals, too, determined that petitioners' clients had suffered harm because they were induced into paying advisory fees and that the disgorgement award will remedy a direct harm to petitioners' clients.
So the petitioners also argue that the First Circuit's decision conflicts with the decision from the Second Circuit in SEC versus Govil. Can you tell us about the Govil case and the government's response?
Sure. The defendant in Govil engaged in fraud when selling shares in his company to potential investors. The Second Circuit determined that the SEC could recover disgorgement only if, quote, the investors suffered pecuniary harm as a result of the fraud, unquote. The Govil court accordingly remanded to allow the district court to determine whether the defrauded investors in that case had suffered pecuniary harm, in light of the conflicting evidence that the parties had presented on that issue. The SG's brief argues that although the First Circuit's decision in Navalira is in tension with the Second Circuit's decision in Govil, the two decisions do not squarely conflict. Navalira involves a registered investment advisor who defrauded their clients, while Govil involved a seller who defrauded potential buyers when offering securities. The Second Circuit in Govil believed that permitting the SEC to seek disgorgement without showing that investors suffered pecuniary loss would improperly allow the SEC to circumvent the limitations on private claims. The SG's brief argues that this concern is misplaced because limitations that Congress placed upon private actions to recover damages do not apply in SEC actions. And the securities law provisions that authorize disgorgement of unjust enrichment and equitable relief in commission enforcement actions do not require proof of pecuniary harm.
The petitioners also highlight a Second Circuit conflict about the effect of the amendments to the Exchange Act that Congress enacted in 2021 after Liu. I think you mentioned these amendments before. What did the government say in response to those arguments?
Sure. The Fifth Circuit has held that by specifically authorizing disgorgement, the post-Liu amendment creates a distinct legal remedy that is not constrained by the equitable limits identified in Liu. But by contrast, the Second Circuit has concluded that the amendment authorizes an equitable remedy that incorporates the equitable limits recognized in Liu. The SG's brief explains that the First Circuit in Navalira did not address that issue. The court instead assumed that Liu's standards applied and held that the disgorgement award in this case satisfies them.
Thanks. Can you tell me briefly about how the government responds to the second question presented in the cert petition, which challenges how the First Circuit analyzed materiality in this?
Sure. Under the Supreme Court's case law in fraud suits brought by the SEC, the question of materiality is an objective one, involving the significance of an omitted or misrepresented fact to a reasonable investor. Under that standard, the Commission, unlike private parties, need not show reliance in its enforcement actions. The Commission instead must show a substantial likelihood that a reasonable shareholder would consider the omitted or misrepresented fact important. The SG's brief argues that the First Circuit properly applied that test in this case.
Thanks, Paul. We'll look forward to seeing what happens next in that case. And we'd like to move on now to discuss a challenge to a recent Commission rulemaking. I'll say the full title of the rulemaking: Regulation NMS, Minimum Pricing Increments, Access Fees, and Transparency of Better Priced Orders. That rule was adopted in October of 2024 and concerns trading on the national market system. The challenge we're going to discuss is currently pending in the DC Circuit. Dan Matro, can you start by giving us a bit of background on the rulemaking?
Sure. As you mentioned, this rulemaking concerns the national market system for trading in securities that Congress in 1975 directed the SEC to establish and oversee. In 2005, the Commission adopted Regulation NMS, which comprised a suite of initiatives designed to modernize and strengthen the national market system, or NMS. 3 of those in particular are relevant here. First, Regulation NMS established a minimum pricing increment, or tick size, for quotes and orders in NMS stocks. At the time, it was set to 1 cent. Second, Regulation NMS adopted the Order Protection Rule. That rule is designed to stop brokers from executing trades at prices worse than the best protected quotation that can be found at any trading center. In other words, every order displaying the best price at whichever trading center has to be taken before a broker can fill an order at a worse price. And third, Regulation NMS instituted a cap on the fees trading centers can charge to access their protected quotations. This rule followed from the order protection rule, preventing a trading center from charging exorbitant fees to those who have to access a quote it displays. At the time, it set the cap at 1/3 of a cent per share, or 30 mils. Nearly 20 years after Reg NMS, in the rulemaking at issue here, the Commission decided to amend several of these rules in light of market developments.
What exactly did the Commission do in this rulemaking?
So first, in response to widespread calls from market participants, the Commission decided to reduce the tick size from 1 cent to half a cent for certain stocks with a narrow bid-ask spread. Second, as a result of the reduction in tick size, the Commission reduced the cap on access fees from 30 mils to 10 mils. As the Commission explained, if the tick size were lowered, but the fee cap were not, fees could exceed more than 1/2 of the tick, which could cause market distortions and undermine price coherence. The Commission accordingly decided to reduce the cap to 10 mils, concluding that that level would reduce distortions and lower transaction costs while permitting exchanges to retain their current business models. The Commission also adopted amendments related to the transparency of exchange fees and to the Commission's prior market data infrastructure rule. Last December, the Commission agreed to stay the tick size reduction and the access fee cap reduction pending judicial review.
So who challenged the rules and what did they argue?
The petitioners are a number of exchanges from the NASDAQ and CBOE exchange groups, and they essentially challenged just the reduction in the access fee cap. In doing so, they make 3 key arguments. First, they argue that the Commission lacked authority to amend the access fee cap under the statutory provisions relied upon by the Commission, Sections 11 Cap A and 23A1 of the Exchange Act, because those provisions do not include the term fee. Instead, they assert that the Commission must regulate exchange fees on an individualized basis under a different statutory provision, Section 19 of the Exchange Act, which governs the Commission's oversight of self-regulatory organizations. Second, they argue that the Commission acted arbitrarily and capriciously by failing to explain the Commission's supposed change in position from a prior rulemaking, the transaction fee pilot, that was struck down circuit. Finally, they raised several other APA challenges, criticizing the Commission's analysis of the rule's economic impact and its selection of 10 mils as the appropriate cap. They asked the court to vacate both the access fee cap reduction and the tick size reduction, which, as the Commission found, cannot operate independently of the fee cap reduction.
What were the Commission's arguments in response?
So on statutory authority, we argued that multiple provisions of the Exchange Act authorize the rule. First, access fee caps fall within the Commission's general rulemaking authority under Section 23A1 because they are necessary or appropriate to implement a number of Section 11 Cap A's directives, including that the Commission assure transmission of orders in a manner consistent with the NMS and use its authority under the Act to promote the efficient execution of securities transactions and the ability for orders to be executed in the best market. Among other things, both the order protection rule and the tick size rule are critical to carrying out those directives, but neither could function properly without access fee caps. And second, we argue that access fee caps fall within the Commission's authority under Section 11 Cap A C1B to adopt rules to assure the fairness and usefulness of quotation information. Access fee caps serve that purpose by limiting the disparity between displayed prices and the actual prices investors will incur net of fees. We also dispute that Section 19 implicitly limits the scope of these provisions. Section 19B requires the Commission to determine whether exchange-initiated rules, including fee rules, are consistent with certain baseline statutory requirements. But that is not the extent of the Commission's authority to regulate exchange fees. Section 19C broadly empowers the Commission to abrogate or modify exchange rules on its own initiative, and states explicitly that it should not be construed to limit the Commission's authority to regulate exchanges under other provisions of the Act.
How did the Commission respond to the petitioner's APA arguments?
We explained that the transaction fee pilot had little bearing on this rule because the transaction fee pilot merely proposed to implement a data gathering pilot and took no position as to the appropriate level of access fees. There was no position for the Commission to change in the rule at issue here. We also detailed how the Commission reasonably determined that the rule would benefit investors and why it represented a reasonable balancing of different policy objectives in this complex area.
Where does the case stand now?
The case is fully briefed, and we had oral argument before the DC Circuit just last week.
Any quick impressions from the argument?
So the argument focused primarily on petitioner's statutory authority and change in position arguments. Among other things, the court probed the practical consequences of requiring the Commission to impose access fee caps on an individual exchange-by-exchange basis rather than through a market-wide rule. It also pressed on whether there had been a policy change of the kind requiring acknowledgement and explanation, given that the Commission here had both additional information and a specific regulatory impetus that it did not have in the transaction fee pilot. And the court asked the Commission to address differences in its conclusions about the market effects of the fee cap reduction here and the transaction fee pilot. We anticipate a ruling from the court this summer or fall.
Thanks very much, Dan. We'll stay tuned to see what the court says on these issues. We're now going to turn back to the Supreme Court. Last June, the court issued a decision in SEC versus Jarkissi, which is a case about the constitutionality of the Commission's in-house administrative proceedings. Sam, do you want to give us a bit of background on the case?
Sure. So this case involves George Jarkissi and his advisory firm, Patriot 28, which controlled 2 hedge funds. At the end of an administrative proceeding, or AP, the Commission found that Jarkissi violated the securities laws by misrepresenting several material aspects of his firm's supervision of those funds. The Commission ordered Jarkissi and his firm to pay civil penalties and disgorge their ill-gotten gains, and also bar Jarkissi from participating in the securities industry.
What happened next?
So Jarkissi appealed to the Fifth Circuit, raising several constitutional challenges to the Commission's AP. A split Fifth Circuit panel ruled in Jarkissi's favor on 3 constitutional questions. First, the Fifth Circuit held that Jarkissi was deprived of the Seventh Amendment right to a jury trial when the Commission imposed civil penalties in an AP without a jury. Second, the court held that Congress had unconstitutionally delegated legislative power to the Commission by giving it the choice to bring enforcement actions in either administrative proceedings or in district court. And third, the court held that the statutory restrictions on removal of Commission's administrative law judges, or ALJs, violated Article 2 of the Constitution.
Did the government seek cert on all 3 rulings?
Yes, it did, and the court granted cert on all 3 questions presented. But the court's ruling ended up addressing only the jury trial issue, agreeing with the Fifth Circuit that Jarkissi was entitled to a jury trial when the Commission brings securities fraud claims and seeks civil penalties.
Can you walk us through the court's reasoning?
Sure. So the court's analysis proceeded in 2 steps. First, the court held that the Seventh Amendment applies when the Commission seeks civil penalties for securities fraud. Because the Seventh Amendment guarantees a jury trial in, quote, suits at common law, it applies to claims that are legal in nature, as opposed to, say, suits in equity or admiralty. The court explained that, while monetary relief can be either legal or equitable, the Commission's civil penalties were legal in nature because they're designed to punish rather than restore the status quo. And the close relationship between common law fraud and securities fraud, quote, confirmed the court's conclusion. According to the court, both target the same basic conduct, misrepresenting or concealing material facts. Both use the same terms of art, and both operate under similar legal principles. Second, the court held that the public rights exception to adjudication in an Article III court with a jury didn't apply. Under that exception, Congress can assign matters involving public rights, but not private rights, to non-Article III adjudicators, like agencies. The court surveyed its previous public rights cases and observed that the exception had been applied in cases involving customs, tariffs, relations with Indian tribes, and granting of public benefits like patents and payments to veterans. By contrast, the court explained, suits in the nature of actions at common law generally concern private rights and require adjudication by an Article III court. The court held that the Commission's action seeking civil penalties for securities fraud was akin to a suit at common law and thus involved private rights, not public rights.
So it's now been almost a year since the court issued its decision. Have there been any other cases raising similar challenges?
Yes, there have. In the wake of Jarkissi, plaintiffs have raised similar constitutional challenges to other kinds of Commission APs and APs before other agencies. So starting with the Commission, there are several pending district court lawsuits raising Seventh Amendment challenges to the Commission's follow-on APs. The Commission generally institutes these proceedings after a previous judicial proceeding, for instance, after the respondent has been convicted of a securities-related crime or enjoined by a court from engaging in certain securities-related activity. These follow-on proceedings are remedial in nature and can only be brought administratively. The available remedies include, for example, a suspension or industry bar, not the monetary penalties at issue in Jarkissi. None of these cases has been decided yet. And we're also seeing lawsuits alleging that sanctions imposed in FINRA disciplinary proceedings and reviewed by the Commission violate respondents' right to a jury trial under Jarkissi. So far, these cases have been resolved on jurisdictional and procedural grounds, and courts have yet to reach the merits of whether and how Jarkissi applies to these proceedings.
What about challenges to other agencies?
Yeah, so the Commission is not the only agency facing post-Jarkissi challenges to their APs. As just one example, last month in AT&T versus FCC, the Fifth Circuit held that an FCC proceeding unconstitutionally denied the respondent a jury trial and an Article III decision-maker. The statute at issue there required telecommunications carriers to protect the confidentiality of customer information and authorized the FCC to bring administrative proceedings to impose penalties for violations. The Fifth Circuit held that, just like the Commission's civil penalties in Jarkissi, the FCC's civil penalties were legal, not equitable, because they're designed to punish or deter violators, not to restore the status quo. And according to the Fifth Circuit, the FCC suit was analogous to common law negligence because it turned on whether or not the respondent had acted unreasonably when it failed to protect customer data. And finally, as in Jarkissi, the Fifth Circuit held that the public rights exception didn't apply, rejecting the agency's argument that the suit involved public rights because Congress and agencies have long regulated common carriers. So the Second Circuit and the DC Circuit recently held oral argument on other FCC cases raising similar issues. If either of those courts disagrees with the Fifth Circuit's holding and holds that the FCC proceedings don't implicate the jury trial right, that may create a circuit split and give the Supreme Court an opportunity to further clarify Jarkissi's reach.
Thank you, Sam. And now back to the Courts of Appeals. Jeff, do you want to kick us off in talking about no admit, no deny?
Sure. In the last few years, there's been an increased interest in the way the Commission settles cases through consent judgments. In particular, courts have been asked to assess the Commission's policy of requiring defendants to agree not to deny the allegations against them when they settle cases without admissions. This policy is often referred to as the no admit, no deny policy, and Archith will discuss recent litigation concerning the policy. Archith, tell us a little bit about the origin of the policy.
Thanks, Jeff. The Commission adopted the policy in 1972, around the same time that it adopted the rules setting out the Wells process. In many instances, defendants will not admit to factual allegations or wrongdoing, and the Commission will agree to settlements without admissions. However, in such a no-admit context, the Commission will not agree to a settlement imposing a sanction unless the defendant agrees not to deny the allegations in the complaint. So while a defendant need not admit, the defendant also cannot deny. The policy only applies when a defendant chooses to settle. It does not require settlements.
So what is the purpose of the policy?
It avoids situations where the Commission gives up its day in court, its ability to present evidence and obtain findings of fact, only to have the defendant publicly deny the allegations without any ability for the Commission to get back into court. The objective of the policy is tied to the only relief available if a defendant breaches the agreement. The Commission can ask a court to rip up the settlement and give the Commission its day in court. Whether or not a court grants that relief returns the case to its active docket, turns on multiple factors and is left to the district court's discretion.
So for most of its existence, the no admit, no deny policy generated no controversy. That changed in 2016 when a defendant attempted to revive a very old case in the Southern District of New York. What happened there?
You're referring to the Commission's action against Barry Romero, who was the CFO of Xerox in the 1990s. The Commission filed an action against Romero in 2003 in connection with accounting fraud at Xerox. Romero settled in 2003, signing a consent in which he voluntarily agreed to a no-deny provision that reflected his agreement not to deny the allegations in the complaint. In 2019, 16 years later, Romero sought to alter the deal and abrogate the no-deny provision while keeping all of the other aspects of the settlement.
What did Romero argue in asking for an exception to the general rule of finality and requesting that the district court alter a consent he signed 16 years earlier?
Romero invoked Federal Rule of Civil Procedure 60b-4, which authorizes relief from void judgments. His argument was that the no-deny provision in his consent made the judgment partially void because it violated his First Amendment rights by precluding him from denying the allegations in the complaint.
And what was the Commission's response to that argument?
The Commission contended that the motion should be denied for two reasons, one procedural and one constitutional. First, the procedural. Under binding precedent, a judgment may be void under Rule 60b-4 for only two possible reasons: a lack of subject matter or personal jurisdiction, and a particular due process defect, namely a lack of notice and opportunity to be heard. Romero didn't argue that the district court lacked jurisdiction. He admitted jurisdiction. Moreover, because Romero had notice and opportunity to be heard back in 2003, there were no grounds on which to deem the 16-year-old judgment void.
So what was the substantive reason you mentioned?
The Commission explained that First Amendment rights, like most constitutional rights, can be waived as part of a settlement. Defendants waive their rights all the time when resolving litigation. Think of plea bargaining. There is no per se rule against knowing, intentional, and voluntary waivers of constitutional rights as part of a settlement. Rather, waivers are permissible, and if the government later seeks to enforce the waiver, courts may engage in a balancing of interests to determine whether to enforce the waiver. In this instance, Romero, who was represented by counsel, made a rational decision to resolve the enforcement action against him via a settlement.
And how did the court rule?
The district court agreed with the Commission and denied the Rule 60b-4 motion. Romero appealed to the Second Circuit, which affirmed. The Second Circuit held that Romero could not use a Rule 60b-4 motion because he did not identify any jurisdictional or due process defect that would render the consent judgment void. The Second Circuit also held that there was no constitutional issue in any event because Romero waived his First Amendment rights when he voluntarily agreed to the no-deny provision. After the Second Circuit denied Romero's petition for rehearing, he sought Supreme Court review. The Supreme Court denied cert.
So Romero wasn't the only instance of someone challenging the use of no-deny provisions in Commission settlements on First Amendment grounds. What were the other cases?
The same attorneys who represented Romero sought to revive a 5-year-old case in the Northern District of Texas. In SEC versus Novinger, the defendant, who settled in 2016, filed a similar motion that made the same First Amendment arguments as in Romero. Citing the same Supreme Court precedent about Rule 60b-4 as the Second Circuit, the district court denied the Rule 60b-4 motion without reaching the constitutional issues.
The defendant, Novinger, appealed and the Fifth Circuit affirmed. What did the Fifth Circuit say?
The Fifth Circuit unanimously held that Novinger had not presented any grounds for Rule 60b-4 relief. Similar to the Second Circuit, the Fifth Circuit ruled that the defendant had not identified any jurisdictional defects, particularly since he admitted jurisdiction and appeared in the action litigating the case for a year before choosing to settle. Moreover, the panel held there was no due process issue because Novinger received notice and the opportunity to be heard, and he voluntarily consented to the no-deny provision. Two of the judges on the panel signed a concurrence, agreeing with the Rule 60b-4 ruling, but noting that the Commission's use of the no-deny provision would likely face scrutiny in the future.
So I imagine, likely spurred on by that concurrence, Novinger went back to the district court and filed a motion for declaratory relief that essentially repeated his request for Rule 60 relief, but under a different banner. What happened in that second go-around?
The district court denied Novinger's motion, holding that Novinger could not use a motion in an existing case to obtain a declaratory judgment about an existing judgment. Novinger appealed, and the Fifth Circuit rejected his arguments again. The court held that it lacked jurisdiction to hear his appeal, and that even if it had jurisdiction, Novinger could not seek declaratory relief by filing a motion in an action that ended years earlier.
What's the current status of the policy?
The Commission recently denied a petition for rulemaking that sought the elimination of the policy, filed by the attorneys who represented Romero and Novinger. In its letter, the Commission explained that the policy remains in effect and that the Commission will not agree to a no-admit settlement unless it contains a no-deny provision. No defendant is required to settle with the Commission, but if they settle, the Commission may seek a voluntary waiver of rights as part of the deal. For this waiver, there is a tailored form of contractual relief. If a defendant breaches, all the Commission can do is ask the district court to rip up the deal and return the parties to where they were before settlement. If a defendant wants to deny after settling, the Commission wants the opportunity to test those denials in court, subject to the rules of evidence and civil procedure. A group of petitioners represented by the attorneys who brought challenges on behalf of Romero and Novinger challenged the rulemaking petition denial in the Ninth Circuit. An oral argument was held on February 13th of this year. At oral argument, the Ninth Circuit panel was focused on the Commission's rationales for the policy and how often, as a practical matter, the Commission avails itself of the contractual remedy afforded to it under the no-admit, no-deny policy. The appeal remains pending.
Thanks, Harjith. We're now going to turn to Dan and Rachel, who are going to be discussing Alpine versus FINRA. It's a DC Circuit decision for which there's a pending cert petition. Dan?
Thank you, Tracy. Last November, the DC Circuit decided Alpine Securities Corporation against FINRA, which involves constitutional challenges to the system of private self-regulation under the Exchange Act. Rachel, could you tell us about the history of that system?
Sure. From the founding to the Great Depression, the securities industry was entirely self-regulated by private associations, such as the New York Stock and Exchange Board, now the New York Stock Exchange, and similar associations in Boston and Philadelphia. In the 1930s, Congress authorized the SEC to regulate securities brokers through a model of cooperative regulation, in which the SEC would assume a supervisory role over the existing system of private regulation. Under that cooperative approach, self-regulatory organizations composed of brokers and dealers, called registered securities associations, must register with the SEC and adopt rules for their members to follow. They must submit rule changes to the SEC, which are subject to SEC review, and they must provide a fair procedure for disciplining members. An association's disciplinary decisions are also subject to SEC review. Joining an association is mandatory for virtually all securities traders, although the SEC retains the authority to exempt individual traders. Today, FINRA is the only registered securities association in the United States. FINRA is a private Delaware nonprofit corporation operated by private individuals and funded solely by private members.
And so what is the background of Alpine's dispute with FINRA?
So Alpine's a broker-dealer and FINRA member. In 2019, FINRA investigated complaints from Alpine's customers about excessive fees and misappropriated property. FINRA began a disciplinary proceeding to determine whether Alpine had violated internal FINRA rules. A FINRA hearing panel found that Alpine had engaged in intentional and egregious misconduct and imposed various sanctions, including a cease and desist order and an order expelling Alpine from FINRA membership. The expulsion order was stayed pending Alpine's appeal within FINRA, but Alpine did not appeal from the cease and desist order, which became final. FINRA later received reports that Alpine was continuing to engage in the prohibited misconduct, so FINRA opened a second investigation and initiated an expedited disciplinary proceeding, asserting that Alpine had violated the cease and desist order more than 35,000 times and seeking Alpine's immediate expulsion from FINRA.
How did the case end up in court?
So after the first disciplinary proceeding, Alpine filed suit in federal district court to challenge FINRA's constitutionality under the private non-delegation doctrine, the Appointments Clause, and the First, Fifth, and Seventh Amendments, When FINRA initiated the second expedited disciplinary proceeding, Alpine moved for a preliminary injunction against that expedited proceeding.
So did Alpine sue FINRA, the government, or both?
Alpine sued FINRA. The United States intervened to defend the constitutionality of the statutory scheme.
And what happened in district court?
The district court denied preliminary injunctive relief, holding that Alpine was unlikely to succeed on its constitutional claims. Alpine appealed the denial of that relief to the D.C. Circuit, challenging only the district court's conclusions that Alpine was unlikely to succeed on its private non-delegation and appointments clause claims. A motions panel enjoined FINRA's expedited disciplinary proceeding pending a decision by a merits panel of the D.C. Circuit.
So the private non-delegation doctrine governs the role that a private entity can play in helping to administer a federal regulatory scheme. In a 1940 decision called Sunshine Anthracite Coal Company against Atkins, the Supreme Court held that a private entity may play an important role in a federal statutory scheme if the private entity acts only as an aid to an accountable government agency that retains the ultimate authority to approve, disapprove, or modify the private entity's actions and decisions on delegated matters. How did the merits panel of the D.C. Circuit address that question in the context of Alpine's preliminary injunction appeal?
In an opinion by Judge Millett, joined by Chief Judge Srinivasan, the D.C. Circuit allowed FINRA's disciplinary proceeding to go forward, but the court said that any FINRA expulsion order could not go into effect until either the SEC reviewed the expulsion on the merits or the time for Alpine to seek review lapsed. The court concluded that Alpine was likely to succeed on the merits of its private non-delegation claim to the extent that FINRA can unilaterally expel a member without governmental superintendence or control. The court observed that, quote, typically, SEC oversight of FINRA disciplinary actions involves the SEC's conducting its own review of any final decision or sanction, including an independent review of the record and approving, disapproving, or modifying FINRA's decision. But the court found that expulsions imposed through FINRA's expedited proceedings are different because under FINRA's rules, such expulsion orders are not automatically stayed on appeal, but instead by default take effect immediately before the SEC can review them. As I mentioned earlier, federal law generally requires an entity to be a member of a registered securities association, and as the court noted, FINRA is the only such association. So the court concluded that expulsion from FINRA effectively amounts to expulsion from the securities industry, which means many expelled FINRA members could be forced out of business before they can obtain SEC review of the merits of FINRA's decision. The court found that Alpine faced irreparable harm for similar reasons because expulsion from FINRA will effectively force it to shutter its operations immediately. The court summed up its decision this way, quote, all we hold today is that it appears on this record that SEC review is not available as a practical matter in expedited expulsion proceedings prior to businesses being forced to close, and that gap likely runs afoul of the private non-delegation doctrine.
Thanks, Rachel. And what did the D.C. Circuit say about Alpine's appointments clause claim?
So the court declined to address the merits, but concluded that Alpine had failed to establish irreparable harm for purposes of that claim, and therefore declined to enjoin the ongoing disciplinary proceeding. The court said that circuit precedent foreclosed Alpine's argument that being forced to litigate before an allegedly unconstitutionally appointed FINRA officer was a per se irreparable harm. The court explained that its analysis was consistent with the Supreme Court's decision in Axon Enterprise versus FTC. The court said that Axon held that as a matter of statutory jurisdiction, a federal court challenge to an unconstitutional appointment can begin before the agency acts. But Axon does not say that every agency proceeding already underway must immediately be halted because of an asserted constitutional flaw. The court also emphasized that FINRA is not a government agency like those at issue in Axon, and that nothing in Axon addressed an asserted injury from a member of a private organization and having to go through a hearing process before such an entity.
Thanks, Rachel.
Thanks. Unfortunately, we are out of time, so we're going to have to.
5 more minutes. You have 5 more minutes.
5?
Excellent.
Excellent. Well, then let's talk about the cert petition.
Sure. So Alpine filed a cert petition arguing that the Supreme Court should review whether participation in allegedly unconstitutional proceedings standing alone constitutes irreparable harm for purposes of the preliminary injunction analysis, and whether FINRA's officers must be appointed consistent with the Appointments Clause. Could you tell us about the government's position on the cert petition?
Sure. So the Solicitor General, on behalf of the government, opposed cert. The government argued that the DC Circuit is right, that Axon is about subject matter jurisdiction and did not speak to what constitutes irreparable harm for purposes of the extraordinary remedy of a preliminary injunction. The government also argued that there is no circuit split on that question. As to the merits of the Appointments Clause argument, the government argued that the Supreme Court should not take that issue up because the DC Circuit did not address it.
Great. Thanks, Dan and Rachel. And for our last very quick decision, we are going to briefly touch on two private cases that the Supreme Court took up recently. The Solicitor General's office filed amicus briefs on behalf of the Commission in both cases, Facebook versus Amalgamated Bank and NVIDIA Corporation versus eOmen. Both cases were dismissed by the Supreme Court after oral argument as improvidently granted. So Emily, can you maybe give us the 2-minute version of the Facebook case?
Sure. That case was a private securities fraud class action that raised questions about when a risk disclosure made pursuant to Item 105 of Regulation SK is false and misleading. A group of investors had sued Facebook and others for securities fraud, and the investors' theory was that Facebook made false or misleading risk disclosures because it presented as hypothetical a risk from data breaches, when in fact that risk had already materialized in connection with the events surrounding Cambridge Analytica. And the district court dismissed the investors' complaint, but the Ninth Circuit reversed over a dissent, the majority holding that the plaintiffs had sufficiently alleged falsity, where they alleged that Facebook's filings warned that risks hypothetically could occur without disclosing that those risks had already materialized.
So Facebook sought cert at the Supreme Court. What did it argue?
Facebook's petition asked the court to decide the question of whether risk disclosures are false or misleading when they don't disclose that a risk has materialized in the past, even if that past event presents no known risk of ongoing or future business harm. But at merits briefing and at argument, Facebook seemed to pivot from its narrower question presented and asked for a broader ruling from the court that statements made pursuant to Item 105 regarding hypothetical future risk are inherently forward-looking and thus can never be rendered false or misleading by failing to disclose the materialization of a past event.
So the SG with the Commission filed an amicus brief supporting the plaintiffs. What was the focus of the brief?
The government's amicus brief contended that under traditional common law fraud principles regarding half-truths, it can be misleading to state a risk disclosure in hypothetical terms when that risk has in fact materialized.
And so what happened at argument?
The justices seem to struggle with where or how to draw the line in a case like this. They posed numerous hypotheticals asking about situations where disclosure would or would not be required, including a hypothetical from Justice Alito about space junk falling from the sky. And they seem to have a hard time pinning down the precise contours of the parties' positions and what the Ninth Circuit actually held. Perhaps reflecting those struggles, the court dismissed the case as improvidently granted.
Thank you so much. And I do think we now will have to leave it there. I want to thank all of our panelists for this interesting discussion, and we will look forward to updates on these issues and other matters next year. Thank you so much.
Thank you.
right, our final panel will be led by Tracy Sasser. Tracy is Associate General Counsel for Litigation and Administrative Practice in the Office of General Counsel and will moderate today's discussion of ethical issues for securities lawyers. Richard Humes will act as commentator for this panel. Tracy leads a team that represents and advises the agency on a wide range of matters involving operations and management, defense of third-party litigation, and allegations of attorney misconduct. Prior to joining the SEC, Tracy served as the Assistant General Counsel for the Division of Business and Administrative Law at the U.S. Department of Education. Richard was the Associate General Counsel for Litigation and Administrative Practice for the SEC from 1991 until his retirement from the Commission in November of 2021. Please consider the comments of these panelists. Tracy?
Thank you so much for that introduction. Since you've already introduced Richard, I will go ahead and introduce the rest of our panelists for today. We have Tom Carr. Tom has worked in the Office of General Counsel since 1998 and has been an Assistant General Counsel since 2006. He helped draft the Part 205 attorney conduct rules and is involved in investigating possible attorney misconduct and bringing administrative proceedings against attorneys pursuant to SEC Rule of Practice 102E. Tom was also involved in drafting the anti-retaliation and other provisions of the Commission's rules implementing its Dodd-Frank whistleblower program and has worked on amicus briefs on whistleblower issues, including the United States brief in Lawson versus FMR, Digital Realty Trust versus Summers, and Murray versus UBS. Tom is a graduate of Harvard University and of the University of Virginia School of Law. We also next have Phil Holmes. Sorry, they switched seats on me. Phil Holmes. Mr. Holmes worked in the SEC's Office of the General Counsel since 1998 and is currently a special trial counsel in the Litigation and Administrative Practice Group of the SEC's Office of General Counsel. In addition to representing the SEC in civil and administrative litigation at the trial and appellate levels, Mr. Holmes investigates and prosecutes attorney misconduct cases under SEC Rule of Practice 102E and Part 205 of the SEC's Part 205 Standards of Professional Conduct for Attorneys appearing and practicing before the Commission in the representation of an issuer. Mr. Holmes is a graduate of Dartmouth College and Cornell Law School. We next have Karen Shemp. Ms. Shemp joined the SEC in October 2000 as an attorney in the Office of the General Counsel, representing the SEC in civil and administrative litigation at the trial and appellate levels. Since 2006, she has focused on the SEC's investigation and litigation of misconduct by attorneys who appear or practice before the Commission. She is also actively involved in examining whistleblower issues that involve attorneys. Before joining the SEC, Ms. Shemp was an associate with 2 tax law boutiques in Washington, D.C. She is a graduate of Harvard Law School. And last but not least on our panel, we have Eric Riker. Eric joined the Commission in 2014 and is a special trial counsel in the Litigation and Administrative Practice Group of the SEC's Office of the General Counsel. He investigates and prosecutes attorney misconduct cases also, advises on Attorney Rule 102E issues, and represents the agency on a variety of other offensive, defensive, and amicus matters in district and appellate courts. He is a graduate of Princeton University and Harvard Law School. After graduation, he clerked for Judge Susan Oki-Malaway of the United States District Court for the District of Hawaii. We're going to do our very, very best to keep you awake. We know that we are the last panel of the day, so that will be our goal for today, to keep you awake and interested in the information that we have to share with you. I'd like to thank PLI for inviting us to speak today, and we're going to get moving from here. The first thing that I know that it's probably already been said, but this slide presentation and panel discussion are provided in the author's official capacities as staff in the Commission's Office of the General Counsel, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. So I wanted to make sure that I reiterated that.
Okay, I'm going to go through a roadmap of our presentation. I guess it's appropriate that I give a roadmap, given that my name is Carr, but, you know, that just happened. First, we're going to talk a little bit about Rule 102E statistics, and that's for the actions against attorneys. Obviously, as I'm sure most of you know, possibly all of you, there are also 102E proceedings against accountants and can be against other professionals. Then we'll go through a brief introduction to the types of 102E actions, which includes Rule 102E3, which are follow-ons to enforcement actions, Rule 102E2, which is forthwith suspensions based on either criminal conviction or a bar suspension or disbarment, and the last 102E1, where Office of the General Counsel original investigations and proceedings. We'll have some recent examples of different types of cases that the Commission has brought that have 102E components. Brief discussion of what being suspended means. If you're suspended pursuant to 102E, what does that mean, with a nod to the definitions of appearing and practicing as found in Rule 102F and Part 205. And then a discussion of the interaction of our work with the work of bars, state bars or state courts that have parallel disciplinary proceedings or parallel remedial proceedings with regard to attorneys. And then last, and hopefully we'll have time for it, talk a little bit about the attorney reporting rules for attorneys to report both obligations and abilities to report both internally and then to authorities in the particular circumstances.
Tom, before we get on the road, let's take a little on-ramp that underlies every discussion of Rule 102E, and that is, what is its purpose? The key point that we would like to emphasize is that the Rule 102E is remedial and not punitive. There are many sources where the courts and the SEC have acknowledged that the purpose of Rule 102E is, in fact, remedial. For example, in a Federal Register posting to the 1998 amendment to Rule 102E, courts have recognized that it is appropriate for the SEC to use a remedial rule, such as a Rule 102E, to encourage professionals to adhere to professional standards and minimum standards of competence when they practice before the Commission.
Okay. Going to the Attorney Rule 102E statistics, I always like to pull up a couple quotes about the importance of statistics. Got one from playwright George Bernard Shaw. W. Edwards Deming, who was, among many things, was a noted statistician who perfected the sampling techniques used by the Census Bureau and the Bureau of Labor Statistics. And Bradley Efron, who is the past president of the American Statistical Association, and hope they bring a little bit of lightness to a discussion, because we're about to get into a discussion of statistics. Okay, snapshot of the total 102E. Again, this is for attorneys that have been brought from 1994 to the present. The totals are by type. Going across, it's 1, 2, 3, and then one little Romanet III. The vast majority are what it here appears to be the pinkish red and the green. The former are ones based on bar suspensions or criminal convictions, and the largest one are 102E3s, which are based on commission enforcement proceedings. Small aside, for the 102E13, those are also for violations of federal securities law, but they are brought as administrative proceedings and not as follow-ons to district court proceedings. They are independent administrative proceedings. And here there's a breakdown of the length of suspensions. The substantial majority are permanent or indefinite. There's a large segment that's 5 years, and then the one that are smaller slivers of multicolor are less than 5 years, which are different suspension lengths, ranging from 4 years down to 6 months. Permanent suspensions that aren't E2 are predominantly cases where the attorney agreed to a permanent suspension in a follow-on to an enforcement action.
Tom, what is the outlook for Rule 102E cases going forward?
We are still bringing them, given the need for the remedial purpose under Rule 102E. The Commission continues to institute 102Es. For instance, we had one earlier this month for an attorney named Maza, actually an attorney/accountant, and several others in the last 6 months. Again, this is consistent with our continuing duty to encourage adherence to professional standards when practicing before the Commission and to protect investors.
All right, so some of the most common types of misconduct that we come across, the unauthorized practice of law or facilitating the unauthorized practice of law. Especially a few years ago, there were a spate of general counsels who weren't licensed anywhere because they didn't think they had to be since they weren't in court. So we've had a number of those, but it seems like people have gotten the message that they have to keep their bar license to be GC. Insider trading, false filings with or misrepresentations to the SEC, other crimes, meaning non-securities law crimes. Money laundering, of course, is one of the biggest that comes through. Conversion of investor funds, usually improperly using your escrow or IOLTA account. Fraudulent opinion letters and misrepresentations to investors and offering frauds. And just to, while these are separated out on here, many times, particularly, for example, in the conversion of investor funds, there's more than one type of thing. So somebody will issue fraudulent opinion letters as part of actually being an active participant in an offering fraud and at the same time converting investor funds through their account. So some of these people are go-getters and try to hit as many of these as they can in a single fraud.
So the most common 102E that we have, Tom initially said, was the 102E3s. In that situation, these E3s are part of a commission action, an enforcement action, so the commission has to be involved in the matter. And in this 102E3, the person has to be any finding that a person has violated or aided and abetted the violation of any provisions of the federal securities laws. That's one particular avenue, and the other avenue is whether or not there is a permanent injunction against the person against violating or aiding and abetting the violation of the federal securities laws. Are you up? 102E2, right?
Yeah. All right. Looks like something got out of order, so we'll come back to that. All right. So the next type are 102E2, which we call forthwith suspensions because that's how they're issued. Somebody is forthwith suspended. It can be for being convicted of a crime or losing your license to practice law, either in a suspension or a disbarment. If those things happen, you can be suspended from appearing or practicing before the SEC. And the main point we want to have you all take away is that the commission can suspend under E2 even if the misconduct that got you in trouble with the bar or with the criminal authorities did not have anything to do with your securities law practice.
So now we turn to 102E1, which, if you remember from the statistics, is the smallest number of cases. These, with one exception we'll get to, are original actions by our group in the General Counsel's office. And the first little Roman at I is if you don't possess the qualifications to represent others, but that simply means you have to have a bar license in any state. Unlike the patent bar, we don't have a specific bar exam. There's no other specific qualification other than, as Karen mentioned, you too have to still maintain your license whether you're litigating or not. We do not have our own separate rules of what counts going to Romanet 2 for unethical or improper professional conduct. We look to the laws and rules that the attorney is already subject to, including the relevant state bars where the attorney practices and where they're barred. And we'll talk, as Tom alluded to, a little bit more about interactions with the state bar later in the program. Very briefly, Romanet 3, this is what was mentioned earlier, and these are generally part of a global settlement brought as part of an administrative procedure rather than the original that are the other parts of E1.
I would like to point out when Karen was talking about unauthorized practice of law by general counsels, we're talking about general counsels at like outside firms, not at the SEC. Just a little clarification. Sorry, I couldn't resist. Okay, so now we're going to get into examples of improper professional conduct under Rule 102E1. As Eric was alluding, we don't just go, we know it when we see it, even though we do, but we look to existing rules of conduct which are already applicable to the particular attorneys.
So Ellen McCarthy was an attorney barred, or is an attorney barred in New York, and she was an independent consultant to Manhattan Transfer, and as part of that, she was forbidden from doing other work for Manhattan Transfer for a period of 2 years. Despite that restriction, she did additional work, both related to the initial project. Basically, she helped implement the project and then also did other completely unrelated work. This came to the attention of SEC staff who raised some questions about, how she believes she could do these things notwithstanding the independence requirement. And in responding to that, she took various steps to try to conceal her involvement, including participating in drafting a fictitious backdated contract and giving false or inaccurate testimony. As a result of this, we conducted, I think I was supposed to mention on a prior slide, when we do the E1s, and I'll say it here, our investigations are in essence the same as what an enforcement investigation would be, just focused on our particular areas. So we get a formal order of, a formal order from the commission. We then can issue subpoenas, we can subpoena documents, we can subpoena testimony. It really proceeds, very similarly. So anyway, getting back to after such an investigation into Ms. McCarthy's conduct, we ultimately settled an administrative proceeding to a permanent suspension because the commission found that Ms. McCarthy violated New York Rule of Professional Conduct 8.4D and H, and that's respectively engaging in conduct that is prejudicial to the administration of justice, and then engaging in other conduct adversely adversely reflects on a lawyer's fitness as a lawyer.
Eric, why was it inappropriate for McCarthy to do work implementing the independent consulting report she had a major role in producing?
Because her assignment was clearly limited to preparing the report, and implementing it was a separate undertaking that went against the independence requirement. And the concerns raised by the independence requirement, that a consultant will have an incentive to take it easy on a client to curry favor in the hopes of getting more work, applies even when the work is related to the initial project. Moreover, Ms. McCarthy asked for permission to do the initial work, but started it before the SEC attorney responded, and then continued it after the attorney said no, even though it's related. You can't do that. But it is also worth noting that if McCarthy's only violation had been doing work related to the original project and not doing other work, and more importantly, not trying to conceal her additional work, the remedial relief ordered may have been different.
Okay, next up we have Matthew McMurdo. Matthew McMurdo was special corporate counsel to Vega Biofuels Incorporated and general corporate counsel to Industry Source Consulting. Now, INSO, Industry Source Consulting, was a microcap public company that had gone by multiple former names, including by Vega. And INSO's common stock was quoted under the symbol INSO on OTC Link. Over a 5-year period, McMurdo signed and issued 10 legal opinion letters in which he opined on various annual and quarterly disclosure reports issued by Vega and by INSO. He addressed each letter to OTC Market Groups, Inc. Vega and INSO used these opinion letters to be quoted on OTC markets and to allow broker-dealers to quote the stock of Vega and INSO. However, McMurdo knew or should have known that his opinion letters contained materially false and/or misleading representations. Included among those was misidentifying who prepared the financial statements of Vega and of INSO, including false information provided by Vega and INSO that a CPA had prepared certain of those statements. Also stating that the individuals that actually prepared these financial statements were qualified to do so, and then also falsely stating that neither INSO nor any 5% or more holder of INSO's securities were under investigation by any federal or state regulatory authority for any violation of state or federal securities laws. McMurdo continued to issue and sign these opinion letters despite observing inconsistencies and inaccuracies in various of the Vega and INSO disclosure reports that he admitted made him feel uncomfortable. In its findings, the Commission noted that under Rule 102E1, Roma 2, it may deny to any person the privilege of appearing and practicing before it who is found to be lacking in character or integrity or to have engaged in unethical or improper professional conduct. Here, the Commission found that McMurdo engaged in such conduct by violating the New York Rules of Professional Conduct. He was a lawyer licensed in New York, requiring New York lawyers to provide competent representation to clients, to act with reasonable diligence and promptness in representing a client, and not to engage in conduct that adversely reflects on a lawyer's fitness as a lawyer. As a result, the Commission suspended McMurdo for 1 year, and for those of you who have the slides or can read the slides here, you'll see at the bottom, as on most of these pages, the Commission order. Just aside on this, I would note that similarly, we had, and I think we've probably discussed in past years, an attorney named Chalmer Detling who had been suspended by the state of Georgia for somewhat similar false statements in opinion letters. So it's not something that is totally, it's something that there is some precedent in the rules of professional conduct that states have applied. And with that, I'll turn it over to Eric, I believe.
Okay. Yes. So Elaine Dowling's an attorney in Nevada, and she employed Sean Hackman as a paralegal. Mr. Hackman had already previously been suspended by the Commission under 102E and also disbarred by Nevada. So he was previously an attorney but no longer licensed. Ms. Dowling allowed Mr. Hackman to practice securities law, including making many, many filings with the Commission and contacting the Commission directly on a couple of occasions with little or no supervision. She was permanently suspended by the Commission under 102E1 for violating 3 provisions of the Nevada Rules of Professional Conduct, 5.3, which concerns the obligation to supervise non-lawyer staff, 5.5A, assisting in the unauthorized practice of law, and 8.4C, conduct involving dishonesty, fraud, deceit, or misrepresentation. We also have Harold Gewerder. He, likewise, a Nevada attorney, and before Dowling started her own practice and took Hackman with her, she and Mr. Hackman worked at a firm run by Mr. Gewerder. Same thing happened at Mr. Gewerder's firm. Mr. Hackman was practicing securities law, again, with little or no supervision, and the commission likewise permanently suspended Mr. Gewerder under the same provision and based on the same rules of professional conduct that they did with Ms. Dowling.
Eric, I'm really interested in how you determined that Mr. Hackman exceeded the appropriate bounds of paralegal work.
As we've mentioned before, we don't have our own standards, so we look to the applicable state bar standards, which in this case was Nevada. And this is an area of the law where there's actually quite a bit of variation among the states. In some states, a disbarred attorney is categorically prohibited from working as a paralegal, but in many, including Nevada, it is not per se improper. So we then look to the Nevada case law to see what standard we would have to establish to show that he went beyond the permissible paralegal work into impermissible practice of law. And the commission determined that he exceeded those bounds given the lack of supervision, the number of times various clients referred to him as their lawyer. There were lots of emails, you know, Sean, I know you're my attorney, can you help? Things like that. There were times clients paid him, not the firm, directly for legal work, and other factors that led to the conclusion that he violated the existing Nevada standards.
Thank you.
Next up, we have Mr. Rubin. Mr. Rubin was disbarred in 1995, but despite that, he continued to hold himself out as counsel in communications with the SEC's Divisions of Enforcement and Corporate Finance. He was listed as counsel of record in company filings with the Commission. He filed opinion letters with OTC Markets, where he signed Richard Rubin Esquire and claimed that he was a member in good standing of the Bar of the State of New York. Well, none of that was true. And the Commission gave him a permanent 102E suspension. The settled Commission order noted that he had engaged in the unlicensed practice of law in violation of the New York laws. The Commission also held that he lacked the qualifications to represent others before the Commission, and that he also lacked character and integrity. Mr. Rubin had a sidekick. This is Mr. Kraft. Between 2015 and 2018, Mr. Kraft maintained a professional working relationship with Mr. Rubin. Mr. Rubin authored 14 Rule 144 letters to transfer agents that bore Mr. Kraft's signature. Mr. Rubin also prepared 3 opinion letters for S1 registration statements that Mr. Kraft signed. And Mr. Kraft did not perform any independent research whatsoever or due diligence before signing any of these letters. At the time, Mr. Kraft is a member of the Florida Bar, and the Rule 144 letters opined that certain shares of stock could be sold without being registered with the Commission.
Phil, did Rubin and Kraft have any additional consequences from their actions?
Oh, yes, they did. Both Mr. Rubin and Mr. Kraft pled guilty to criminal securities fraud charges in the Southern District of New York, and both pleas were made after the SEC had suspended them from appearing and practicing. In Mr. Kraft's settled order, he was permanently suspended for violating the Florida bar rules. 4-5.5, which is assisting another in violating regulations of the legal profession. 4-4.1, which is in the course of representing a client making a false statement of material fact or law to a third person. And then the all-present catch-all 4-8.4C, which is conduct involving dishonesty, fraud, deceit, or misrepresentation.
Thank you, Phil.
Okay, next we're going to move on to another common category, misrepresentations to investors and offering fraud. These are going to be largely 102E3s. So, Karen, if we can backtrack a little on, if it's possible, on the slides to get to the
I can try. Let me see.
Yeah. It's like slide 15.
Yeah, I know. It was a ways back.
We're going back to that one. You skipped it.
Technical issues.
Almost there.
I think when we go forward again, we should quiz people before they see it, so we know if they're awake or not.
Yeah, don't hurry to rush that, write that stuff down. We'll go back to it.
There we go.
There we are.
Okay, as I talked earlier, we talked a little bit about 102E3s. Those are the follow-ons, the most number of ones that we do here. What I wanted to talk about is most follow-ons are part of a settlement package with the Division of Enforcement. If a follow-on is considered where that one hasn't been a settlement, OGC determines whether to recommend that the Commission institute an appropriate an administrative proceeding. A non-settled order instituting an E3 proceeding will be immediately temporarily suspend the person for the duration of the litigation. If the respondent doesn't respond to the order within 30 days, the suspension will automatically become permanent, and there's a rule that we have there. If the respondent does reply, the proceeding will generally be handled by an administrative law judge, handled by summary disposition because the merits ruled on cannot be relitigated. There's also a rule on that. And the focus in the summary disposition is on the Stedman factors: egregiousness, recognition of wrongdoing, opportunity for future violations, things like that.
Phil, how does Rule 102E3, Romanet 4, work if the underlying enforcement action was settled?
Rule 102E3, Romanet 4, provides that a person who consented to a permanent injunction without admitting the facts in the complaint shall be presumed for all purposes to have been enjoined by reason of the misconduct alleged in the complaint.
Karen, I think we should be on slide 26.
Getting there.
Yeah.
Thank you.
And you now see why we do not specialize in IT.
Mr. Sue, Mr. Alan Sue, he was involved in a $33 million Ponzi scheme, which had a healthy dose of affinity fraud involving Vietnamese communities in California through a fake church. He held himself out as the fake church's general counsel and allowed this church to do the same. The founder of the church was a criminal, and Mr. Su knew this. He also knew that he provided, at best, minimal legal services to the church. In one event, he was brought on stage at an investor event and introduced as the general counsel, giving investors the false impression that the church was subject to legal oversight. About a year later, Mr. Su left the church, but did not report the ongoing fraud to any law enforcement or investors, despite knowing that, one, the church was not legitimate and existed only to obtain investor funds. The church was run by a convicted felon, and the investor money was used to fund the lavish lifestyles of the church's pastors. All this gave him about $176,000. The results of this situation was there was an injunction, he was enjoined, disgorgement, prejudgment interest, and a penalty. We filed the 102E3. It was not agreed upon, so it was not settled. So we filed it as a temporary suspension with the 30 days with the petition to lift. Mr. Su did not file any opposition, so it automatically became a permanent suspension. Now we have Mr. Patel, Ashmit Patel, who's part of a network of fraudsters that orchestrated numerous pump and dump fraudulent schemes in which the network obtained stock in at least 20 over-the-counter issuers through various entities they controlled, funded promotional campaigns, recommending that the investors buy the stocks, generally using intermediaries to funnel the funds to the promoter, and then sold the stock back into the market activity that they generated. The promotions did not disclose that a group of individuals who paid for the promotions also intended to sell their shares. Mr. Patel obtained millions of shares in at least 5 of the issuers, purportedly in consideration providing legal services to the issuers. He aided and abetted the other co-defendants in perpetrating their schemes by his timely and coordinating selling of the promoted issuer's stock and by wiring a share of the sale proceeds to entities controlled by other defendants. As a result of this activity, Patel netted about $960,000 in ill-gotten gains. Mr. Patel defaulted in the civil action brought by the commission. He pled guilty in the parallel criminal proceedings, guilty to conspiracy to commit securities fraud and manipulative securities fraud. As a result, the commission forthwith suspended him from appearing and practicing before it. And in addition, he was disbarred because of this conviction. Now we have Ms. Fernandez. Ms. Fernandez is a Florida attorney. She solicited investors to invest in several companies in a $196 million Ponzi scheme. In the scheme, she ran a team of over 64 sales agents who solicited investors, and she made materially false, misleading statements to investors regarding the use of those proceeds. She personally solicited and raised approximately $891,000 from 89 investors and received $392,000 in commissions for her efforts. As part of this scheme, she represented in a video posted to her Instagram page entitled Entrepreneur/Lawyer on IG that she was able to grow her investment portfolio to the point where she could leave her job as an attorney. However, this was not the case. In truth, she was receiving commissions from selling securities, and her parents were covering her living expenses living at home. Without conducting any due diligence, she also falsely claimed in a video that she sent to her sales team that the company was not operating a Ponzi scheme and that it does not take money from Peter to pay Paul. Ms. Fernandez consented to a court order that permanently enjoined her from violating the securities laws and a ban on appearing and practicing before the commission. And as Tom said, the orders are down the bottom.
Okay, thank you, Phil. We're now moving on to another area which certainly in the past year seems to have had a little bit of activity. Attorneys who have received 102Es for false filings or misrepresentations. And with that, I turn it over to Karen.
So our first example is Tyler Burnett Wilson. He was the GC, CFO, and secretary of an SEC-registered corporation. He knowingly or recklessly engaged in improper accounting scheme and falsified books and records to improperly recognize revenue. The company raised about $30 million from investors during the relevant period. The outcome is that he was suspended for 5 years as both an attorney and an accountant. And on the accountant piece, he wasn't actually a CPA, but he acted as an accountant because he was the CFO, he reviewed accounting entries, he reviewed a revenue recognition memorandum, and he supervised accounting staff. So while today we're primarily focusing on lawyers, we thought it might be worth taking a second to point out that if you're acting as an accountant, even if you're not a CPA, you might wind up with an accountant suspension, but that's a discussion for a different panel. And then our next example is Elliot Mazza. He was the CEO and CFO of a publicly traded company. What he did was knowingly signed the company's annual filing and an amended annual filing for the same year, both of which were filed with the SEC. The problem with those filings was that he did not disclose that certain individuals had control of more than 5% of the outstanding shares and did not disclose who actually controlled the management of the company, and he provided false assurances to a broker that one of the actually controlling individuals had no agreement or understanding that would prevent them from selling the company's stock. So as a result of all of that, he agreed to a permanent suspension, again, as both an accountant and an attorney, because he was the CFO. I don't think he was a CPA, but I'm not 100% sure. You could look at the order that's referenced down there to get that.
Okay, thank you, Karen. Next, moving on to another area where we've had a number of attorney 102Es in the, frankly, another distressing area, insider trading by attorneys. And with that, I will turn it over first to Eric.
Okay, I'll discuss David Sargent. He had a solo legal practice in Chicago and was formerly on the faculty of a law school in the area. He purchased stock and options in a company after getting material non-public information about a positive upcoming earnings release from a friend and former colleague who worked at the company. He made a profit of over $107,000 based on this material non-public information. As a result, enforcement brought a civil proceeding, and he was subjected to an injunction, disgorgement, penalties, and then there was a follow-on 5-year suspension under 102E3. Now, there also was a parallel criminal case here, and this was actually a somewhat unusual circumstance. He was convicted of insider trading, but at the conclusion of the trial, the judge granted his motion for a judgment of acquittal, saying that there was insufficient evidence to support the jury's finding. The government appealed that to the Seventh Circuit. It's been fully briefed and I'm pretty sure argued, and I would imagine a decision on that will be coming down sometime fairly soon.
Eric, I'm puzzled somewhat about the sequence here. Why did the commission proceed or the staff proceed to ask for a suspension when he could have been acquitted?
That's a good question. Although a criminal conviction often is a basis, under E3, were allowed to suspend an attorney based on a civil judgment and injunction issued against that attorney. The commission could have proceeded based on the civil action, even if there never had been criminal charges at all. And if the acquittal is upheld, it will have no impact on his suspension, which was based on the civil action. And there are a lot of reasons we do this, but one of them is if enforcement is close to finishing their case, the clock may start to run in how much time we have to bring a follow-on proceeding.
Thanks.
Jean Daniel Levoff. Mr. Levoff was a member and then co-chair of Apple's Disclosure Committee. In this role, it gave him access to confidential earnings data before it became public. However, Mr. Levoff couldn't resist basically taking a bite of the apple. He was convicted of trading, using insider information and trading on that information. He was criminally convicted. He forfeited almost $600,000. He was disbarred by the state of California, and he was also permanently suspended by us.
Is there anything else about this case that you're holding back on?
Well, yes, the division brought a parallel civil action against him where summary judgment was granted, and in that, the SEC release noted that part of Mr. Levoff's duties at Apple was that he reviewed and approved Apple's insider trading policy and notified employees of their obligations under such policy each quarter prior to the earnings announcement. In this situation,
You know, on that one, I don't recall the answer. It came from enforcement when they brought the original case, and then we handled the follow-on. So I would have to go back and check on the complaint on that one. But it is a good question. I wish I knew the answer right now.
So in this situation, we brought an E2 based on his conviction because he pled guilty in the criminal charges. This gave the commission full relief, and we were able to get this full relief in the criminal matter first, prior to the civil parallel action. And so in that situation, there's no additional need to do a 102E3.
Okay, and now we're going to get to what does it mean to be suspended under Rule 102E, which is another way of saying the question, you're suspended from appearing and practicing. What does it mean to be appearing and practicing? And to start in on that answer, Karen?
All right, so there are two places to look should you find yourself suspended by the SEC in trying to figure out what that means. The first is Rule 102F. Which says that appearing and practicing before the commission includes transacting any business, as well as preparing any statement, and it goes on basically to list a bunch of examples of things that you can prepare and file with the commission. So that is intentionally written very broadly. In addition, on Part 205, it goes into a little bit more detail where Part 205 applies as to what it means. And it includes the transacting any business, which includes communications in any form. Representing someone in a proceeding, obviously, is appearing and practicing. And then providing advice on the securities laws and advising an issuer that something does or does not need to be included. I'm summarizing here. Obviously, anyone who's in this position should read very carefully the entire portion of 102F and Part 205. But keeping in mind that, again, the key point is it's intentionally defined very broadly. If we do find noncompliance, we can seek a number of remedies. That can include increasing a term of year suspension. It can also include obtaining a federal court order to enforce the commission's suspension order, and that's brought under Section 21E1. There are two examples where we have done that, SEC versus Hackman, the same Hackman that Eric talked about earlier. And then another case, SEC Vinson, which was a Texas lawyer in 2020.
Karen, keeping in mind the remedial nature of Rule 102E, how does noncompliance come to the agency's attention?
Tracy, it comes in a number of different ways. There's one example of a gentleman named William Riley who, in a registration statement that was filed with the commission, that registration statement incorporated a legal opinion that was signed by Mr. Riley that said he was counsel to the registrant in connection with the filing of that registration statement, and that he consented to the use of his opinion as an exhibit to the registration statement and to reference the opinion under the caption, legal opinion. So in that case, Mr. Riley's 3-year suspension became a permanent suspension. So that's one example. Another example is enforcement may reach out because a suspended attorney shows up as counsel for someone in an SEC, in an enforcement investigation, or similarly, somebody from trading and markets or corporation finance may have dealings with someone and find out that they are suspended. And again, transacting any business with the agency is one of the things that you can't do. So we will get phone calls that say, you know, we had this encounter and we'll start looking into it. And then there are also times where we find something because we periodically, proactively look for indications of noncompliance and violations by suspended attorneys. So. All right, so if the remedies of a longer suspension and a federal court order aren't persuasive enough, we can also get disgorgement of any fees that you've received for work that violates the SEC's suspension. Disgorgement was first awarded in accountant 102E cases in the Tabor case back in 2013. It was first applied to attorney cases in Vinson in 2020. Mr. Vinson agreed to disgorge $6,000. It was most recently applied to an attorney in the Hackman case. Yes, the same Hackman. And he was ordered to pay nearly $1 million in disgorgement and prejudgment interest in 2022 by court order.
Thank you, Karen. I am looking at the time that we have. It looks like we are almost at time.
It's 3:05.
Thank you.
Okay.
Just wanted to make sure.
Yep.
Okay. So we're going to talk a little bit about what we've alluded to as the work we do with bars. Not that type of bar, obviously. That's just a bad joke, so you know it came from me. But in terms of working with the state bars, or in many states, if it's regarding attorney conduct issues, we're working with the state courts. And here, we're just basically noting that many of our attorney 102E cases, there's also been a state bar sanction. And one of the first examples we have here is Mr. Guy Jean-Pierre, who forged opinion letters. He had violated Florida Bar Rule 1.2D, counseling a client to engage or assist a client in criminal or fraudulent conduct. He was disbarred by Florida, and he was also subject to a permanent suspension. Another one, if we
There's a question.
don't need it. No, we took that one. Howard Clayman, who facilitated investments in prime bank schemes by acting as a paymaster through his IOLTA account, which is the account, well, you all know what an IOLTA account is. I think you'd use them more than I do. Additional misconduct was noted in the bar's investigation. He violated Minnesota bar rules requiring how to handle client funds, to restore disputed portions of trust accounts. He also violated 8.1B, which is failing to respond to a lawful demand for information. And 8.4C, which is probably the most common one for the attorneys who are subject to 102Es. It's prohibiting lawyers from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. He was disbarred and he was permanently suspended by the SEC. Also, state bar sanctions, we have Adam Tracy, aided and abetted filings that contain material misrepresentations and omissions. And I'd note there that when we got a decision from them, from the, I believe that's Illinois, noted that he had additional misconduct not related to the SEC's action. In other words, we weren't the only entity that had reported misconduct by him. He violated 4.1A, 4.1B, 8.4A, which is their version of the dishonesty, fraud, and deceit. He was barred by consent and subject to a permanent SEC suspension.
Next, we have Fayez Dean, an illegal unregistered sale of securities in a microcap company paired with a pump and dump. The Washington Bar, we did not need to address its rules of professional conduct because it took action reciprocal to the Discipline Committee of the Law Society of British Columbia. But please see the catch-all 8.4B and C prohibits criminal and other conduct involving dishonesty, fraud, deceit, and misrepresentation. He was disbarred and permanently suspended by us.
Phil, was the fact that Mr. Dean was a Canadian lawyer, resided in Canada, present any obstacles to prosecuting him here?
Yes.
Well, are you going to share
Because
them
he
with
lived
us?
in Canada, we had to do the service of process, had to be by the Hague Convention rules. So it was unusual and fun, and the first time I have ever used the Hague Convention rules. Back to Mr. Kraft. As we talked about earlier, he had signed those opinion letters that were written by Mr. Rubin, a disbarred attorney, without performing any independent research. Pursuant to the Florida Bar, we did not need to cite any rules of professional conduct. We did cite Rule 4.5, 4.41, and 4.84. He was disbarred by consent and then permanently suspended by us.
All right. We're at 4:04. Do you want me to do a very brief?
Yes, exceedingly brief.
Okay. See if I can be brief. All right. Attorney reporting, how attorneys can use confidential information sometimes. We want you to look at Part 205. Part 205.3 deals with an issuer as a client, and in particular, B, the title gives it away, duty to report evidence of a material violation. We're not going to go through, it's a lengthy provision, there's a lot of nuances. What we want to highlight is that there is a duty to report evidence of a material violation internally up the chain, and it's not necessarily a one and done. If you don't get a reasonable response, then you have to keep pushing it up the chain. We could spend a whole panel on that. Then the question becomes, well, all right, what if I get retaliated against? There are protections in Part 205, as well as in most state rules of professional conduct. And even the Supreme Court has noted in the Lawson case how important anti-retaliation protection is. And then the question is, all right, well, what if there's not enough internal? Can I report externally? Part 205 says yes, in certain circumstances you can. The key point here is that the client's consent is not necessary. Highly encourage anybody who does represent issuers to look at the 3 types of times where you might be able to report. And the model rules, Tom can go over, I guess, very briefly.
Yes, watch this. Okay.
Yep. follow the same.
Rule 1.6B has model rules and state corresponding rules that permit the reporting of certain violations externally. Depending on the state, sometimes they're limited to crimes, sometimes they're limited to crimes of bodily harm. Occasionally, they will cover conduct that will be likely to result in substantial financial injury. And there are 2 states which, in very limited circumstances, New Jersey and Wisconsin, would actually require external reporting. So you need to look at your state bar rules to know what your obligations or what your abilities are there. And the last thing is Rule 1.13 and state bar, any state bar's equivalent, covers organization as client and obligations to report things up within the organization, and in, again, for different states in limited circumstances, further discussion of when something may be reported out. Those have parallels to R 205.3, up the ladder reporting. Again, I encourage you to check what your particular bar's rules are there because they can vary. And with that, ending with the last adage, knowing what's right doesn't mean much unless you do what's right, which I'm sure everyone here knows because you're here and you've listened to our past hour. Thank you so much for coming. Hopefully it's been somewhat interesting and informative. We really thank you again.
Thank you.
Thank you.
So we will resume at 4:20. For those watching on the web, you will see the Division of Enforcement workshop. For those in person, the enforcement workshop will be in this room. Anyone wishing to see the investment management one can go across the hall to Salon 14, and then accounting will be in Salon 15. We'll see everybody at 4:20. Thank you.
Thank you. So thank you all for joining us for the Enforcement Division Workshop Panel. And I know this is the last event before folks go off, so appreciate you sticking around, and hopefully we'll be able to provide some updates and some priorities for you before you go on to hopefully better things like happy hour. But in the meantime, I'll just introduce myself. I'm Pei Chung. I'm an associate director here in the Home Office in the Enforcement Division. And with me, I have a lot of our unit chiefs and other senior leadership in enforcement. So just a brief introduction. Laura Delaird is sitting next to me. She's the chief of the Cyber and Emerging Technologies Unit. Corey Schuster is the chief of the Asset Management Unit. Joe Sansone is the chief of the Market Abuse Unit. And we have Rebecca Olson, who's the deputy chief of the Public Finance Abuse Unit. Eric Werner, who's the chief of our Complex Financial Instruments Unit, and Jamie Marinaro, who is an associate director in our Fort Worth regional office. And just to start, I will provide our general disclaimer again that all comments today are provided in the panelist's official capacity in the Enforcement Division, but do not necessarily reflect the views of the Commission, commissioners, or staff. And to start, we will go into some of our priorities in the units and in the division as a whole, but I did want to reiterate some of the overarching themes that we've brought here today in terms of the Enforcement Division's priorities that were mentioned on the earlier panel, and we'll get into more detail here. But really, we're looking in terms of the next few years of getting back to basics, which includes a focus on fraud, and in particular, fraud in which there is investor harm. So we will be looking largely at harm to retail investors, and especially vulnerable populations. Financial fraud and disclosure fraud will continue to be areas of attention, with a focus both on company and individual liability in particular. And then we will also be looking towards tailored relief for our remedies. So I'll just spend a few minutes on the area of focus for our fraud investigations. And in this area, as I mentioned, a high priority for us is frauds that target vulnerable populations, retail investors, and in that respect, we're looking with a focus on elderly communities. So just as one example of a recent matter in this space, we have SEC versus Lee and Evergreen Property Developments, a matter we brought in April of this year. And in this matter, our complaint alleged that Ms. Lee had held herself out as an investment advisor as part of a years-long scheme that targeted elderly members of the Korean American community. Many of the victims were also retirees. And then another example of a matter in this space is SEC versus Jonathan Webb, which we brought in March of this year. In this matter, we had charged Mr. Webb with an alleged offering fraud that targeted low-income employees, including some who did not speak English, and also including some who were employees under his supervision of the cemetery where he worked, as we allege in our complaint. So these matters are indicative of some of the things that we will be focused on in terms of investor protection, including, as one of the things we mentioned in the panel earlier this morning, looking to return funds to investors through means such as fair funds. Another space that we'll be very focused on for fraud is market manipulation and microcap fraud. And we'll have a continued focus on this space. A matter recently that we brought in this area is SEC versus Albert Galusin, Peter Jacobs, and John Scuderi. This is from April of this year. And this is a matter which involves, as we allege, a pump and dump by these three individuals in a microcap issuer. As a result of their activity with deceptive promotional campaigns and generating demand, they sold, as we allege, at artificially high prices, generating for themselves $21 million in net trading proceeds. So in a similar space, we will be looking at foreign bad actors, as well as relationship investment scams. And this is an area we've had a focus on over the past couple of years, and including having issued a investor alert, a few different investor alerts on this. So in this area, we've seen a very common pattern, which includes fraudsters often creating a fake online persona, perhaps as an attractive single person or as a successful investor or investment professional. And they make contact with investors using social media, dating apps, WhatsApp, and develop a relationship of trust, after which they introduce an investment opportunity and then prompt the investment, leading to either a fake investment platform to essentially just steal money, or to create a well-timed purchase of stock in a pump and dump. So in this space, some of the examples of matters we've brought recently include SEC versus Onyechonem from December of last year. And in this matter, we had alleged that a Nigerian-based group of individuals had created fake websites impersonating representatives at well-known securities firms, and then used social media to encourage victims to invest in the platform, resulting in losses for those investors. Another example that I'd like to point out, which is actually from the criminal space, but where we see similar activity that we're interested in at the SEC, is a matter called USA versus Cedric out of the Northern District of Illinois, and this is from March of this year. And in this criminal case, this was another group of foreign bad actors alleged to come out of Malaysia and to Taiwan, leading to a ramp and dump scheme similar to a pump and dump. So we have also seen activity in this area and would expect to be focused on this type of activity. And then the final area that I'll mention before I turn it to some of my colleagues are in the area of financial and disclosure fraud. So you will continue to see us policing financial and disclosure fraud by both companies and individuals. And in particular, we will be looking closely at the manipulation of financial performance, including in areas such as inflated performance metrics, disclosures related to impairments, expenses, and losses, and false books and records. And there will be attention focused on scienter-based fraud, as well as holding individuals accountable. So some examples that I'll just mention in this space of representative matters include SEC versus Leibowitz, a matter that we filed in March of this year. And in this complaint, we had alleged that Mr. Leibowitz, who was the company's CFO and a CPA, had lied to auditors and falsified accounting records associated with an artificially inflated cash balance of the company's at the end of a fiscal year. So one of the things I'll mention in this matter that is of note is that we also requested relief in this matter that consists of a CBI, a conduct-based injunction, that is very similar to the SEC's 102E relief that we seek in our administrative proceedings. And then the last matter that I'll mention of note is SEC versus Carcetti, which is from March of this year once again. And in this case, we allege fraud, including 10B charges against 3 company officers for scheming to conceal information about the likelihood of FDA approval of the company's flagship drug. And in this matter, we also had a company settlement in which the company had settled for 17A2 and 3 charges and paid a $2.5 million penalty. And I'll mention here, which is indicative of some of the action that we expect to take, the order for the company settlement mentions the establishment of a fair fund for distribution of the penalty to harmed investors. And so you're likely to see this kind of activity from us as well. So now I'll turn it over to Laura Delaird to talk about some of the priorities and updates in the cyber and emerging technologies space.
Thank you so much, Pei. First, I'm going to start off by providing a little background and context on the CETU. We were originally formed as the cyber unit in 2017. We became the Crypto Assets and Cyber Unit, or CACU, in 2022. And most recently, in February of 2025, we became the Cyber and Emerging Technologies Unit. This unit replaces CACU, and we are comprised of approximately 30 fraud specialists and attorneys located in the home office here in Washington, D.C., and 5 regional offices throughout the country. We're currently focusing on 3 priority areas. First, we have emerging tech-related priorities. Second, we have some cybersecurity compliance-related priorities. And third, we have another set of priorities that we think of as other cyber-related misconduct. We in the unit have an overarching focus on rooting out those seeking to use innovation to harm investors and thereby diminish confidence in new technologies. We chose the term emerging technologies to show that we have not only a broad remit, but an evolving remit, where we focus on the intersection of technology and the securities markets. Emerging tech is something that we all know can change over time, and so we want to be nimble to adapt as new technologies come on the scene. Second, I'm going to give an update on 2 recent litigated matters cross-staffed with our unit. First, in April, the SEC filed a litigated action against Romil Palafox, the founder of PGI Global, alleging that he orchestrated a fraudulent scheme that raised approximately $198 million from investors worldwide and misappropriated more than $57 million of investor funds. We allege in the complaint that Palafox offered and sold PGI Global membership packages, which he claimed guaranteed investors high returns from PGI Global's supposed crypto asset and foreign exchange trading. We allege that he misappropriated more than $57 million in investor funds to buy Lamborghinis, items from luxury retailers, and for other personal expenses. Second, the Commission filed a litigated action in May against Richard T. Kim, the founder and former CEO of Zero Edge Corporation, alleging he committed fraud by misappropriating approximately $3.7 million of investor funds that he raised to build a blockchain-based online casino. The complaint alleges that minutes after the first investors placed their funds in the Zero Edge wallet, Kim began diverting those funds for his personal use. Third, I'm going to spend some time just highlighting a few focus areas in our unit going forward in each of our 3 priority areas. So first, with respect to emerging technology, we're focused on AI-related fraud. Our highest priority when it comes to artificial intelligence is weeding out bad actors using AI or excitement around AI to commit fraud. This can mean use of the technology to commit fraud or material misrepresentations regarding the use or integration of artificial intelligence as part of a business model or as part of an investment strategy. AI can be used to commit fraud in increasingly sophisticated ways, from deepfake generated social engineering scams to AI-powered market manipulation. Staying ahead of these evolving threats is a regulatory challenge, as bad actors exploit AI's capabilities to manipulate trading patterns, spread misinformation, or automate illicit financial activities. To this end, we have an AI fraud specialist in our unit who previously worked in our exams division, and he works with staff in the unit to identify potential fraud to investigate. Our unit also provides consults throughout the Division of Enforcement on AI-related investigations to share our insights. With respect to cybersecurity compliance on this front, we have cybersecurity experts in our unit, including a fraud specialist who focuses on cybersecurity, and they've been looking at these issues for several years and serve as a central hub in enforcement. They play a leading role coordinating with the Division on cybersecurity-related issues, as well as with external law enforcement authorities. There are a few big picture points that I'd like to make with respect to our unit and our approach when it comes to cybersecurity compliance. First, we're keenly aware of the challenges faced by issuers and registered firms when they're victims of cybersecurity incidents. And we aren't looking to second-guess good faith, reasonable decisions. From an enforcement perspective, we investigate with that context in mind, and we take into account all of the facts and surrounding circumstances when considering potential recommendations. If you look back historically on enforcement actions in this space from a big picture perspective, with respect to public issuers, historically, we have been focused on the quality of the disclosure. On balance, we ask, did the issuer provide all material information, not speak in half-truths, or frame as hypothetical harms that had already occurred or were not otherwise disclosed. With respect to registered firms, our focus is on protecting customer client information and proper disposal of that information, that's Regulation SP, protecting identities, that's Regulation SID, and assets, Regulation SCI. We look at the specific requirements under each of our applicable regulations. And a big picture point here is that we work very closely with our examination program on these investigations. They're best positioned to identify what is and is not an issue at the outset. Note, however, that we may step in earlier where we see indications of hacking to engage in insider trading. Finally, with respect to other cyber-related misconduct, one example of a matter involving the type of cyber-related misconduct that we in the unit are focused on is a matter mentioned by Pei, SEC v. Anyachanam, which was cross-staffed with our unit. We're planning to focus on matters like this, where we see indications of bad actors using fake websites or impersonating investment advisors or broker-dealers to commit fraud. And finally, we also have a priority to look at relationship investment scams to the extent they involve a security. For example, we may investigate where we see victims being directed to supposedly trade a digital or crypto asset on a platform. However, it turns out that the trading and the platforms aren't real. In this regard, we also have fraud specialists in our unit who focus on digital asset tracing and assist us in investigations involving crypto asset payments.
Thank you, Laura. And so I'll turn it over to Corey Schuster for some priorities and updates in the asset management space.
Thank you, Pei. It's always a privilege to talk about the asset management unit, our priorities, and most importantly, our talented staff and the great work that they're doing. For those unfamiliar, the asset management unit is a national specialized unit that focuses on identifying and investigating misconduct by investment advisors to retail clients, registered funds, and private funds, as well as related gatekeepers. We have staff members in 10 of the 11 SEC offices, and we pursue our own matters, but also consult on matters across the agency, including within the Division of Enforcement on core matters and non-unit matters. AMU plays a critical role in the Commission's efforts to protect retail investors, to pursue persons breaching their fiduciary duties, and to promote individual accountability, all of which are priorities. To that end, our priorities and other areas of focus also include misappropriation and failure to safeguard assets, misleading strategy disclosures, undisclosed conflicts of interest, fraudulent valuations and the mismarking of assets, undisclosed fees and expenses, prohibited trading practices such as cherry picking, fraudulent allocations, and unauthorized principal transactions, and affiliated and joint transactions. I'd like to highlight a couple of recent actions. First, the Upright Financial Corp matter, which we filed earlier this year. In that matter, the Commission alleges in its amended complaint that David Che and Upright Financial operated Upright Growth Fund, a registered investment company, and breached their fiduciary duties when they violated the disclosed fundamental policy of the fund by investing more than 25% of that fund's assets in one industry. Not only did defendants allegedly violate this fundamental policy, they did so by investing more than 25% of the fund's assets in a single company over multiple years, causing approximately $1.6 million in harm. Che also allegedly hired an accountant for the fund without the required vote by the board and advised the fund without a valid advisory contract. More specifically, as it relates to the 15C process, the Commission alleges that defendants failed to provide or withheld key information to the board, including information reasonably necessary for the board to evaluate the terms of the Upright advisory contract, and also by misleading the board about defendants' past securities law violations and a 2021 settled order with the Commission. Second, I'd like to highlight our litigated matter against Ken Leach. In December, we filed a litigated action against Mr. Leach, a former co-chief investment officer at Western Asset Management Company, alleging that he engaged in an extensive cherry-picking scheme. According to the complaint, Mr. Leach, who was a portfolio manager for a number of Western Asset's investment strategies, allegedly allocated trades with more than $600 million in first-day gains to certain favored portfolios, and allocated trades with more than $600 million in first-day losses to certain disfavored portfolios. Leach also allegedly placed trades in omnibus accounts, but then waited hours, often until near or after the end of the day, of the trading day, to allocate those funds. This delay allegedly gave him the opportunity to observe market movements and see whether the market value of his trades went up or went down, and then to make those allocations. These cases are currently in litigation and pending. Next, I want to address material non-public information and Section 204 Cap A of the Advisors Act. Registered investment advisors come into contact with and frequently are entrusted with large amounts of material non-public information. Advisors Act Section 204 Cap A is meant to guard against the potential abuse of material non-public information. It requires registered investment advisors to establish, maintain, and enforce written policies and procedures reasonably designed, taking into consideration the nature of such investment advisors' business to prevent the misuse of material non-public information. There have been questions about why the Commission recently dismissed an action against Silver Point Capital, which included a claim based on alleged violations of Section 204 Cap A of the Advisors Act. As noted in the litigation release, the decision was an exercise in discretion by the Commission based on the specific facts and circumstances of the Silver Point matter. The dismissal does not reflect the Commission's policy on any other case. 204 Cap A is an important statute to protect market integrity and will remain in the enforcement toolbox. Advisors need to make sure that they tailor their material non-public information policies and procedures to their unique business lines and operations. For example, firms should think about the ways that they are exposed to material non-public information and how those firms can mitigate the risks of exposure across different but potentially overlapping business lines or strategies. Lastly, I want to discuss enforcement pursuing non-scienter violations. These matters are not just limited to violations of Section 2062 of the Advisors Act. AMU and enforcement will continue to look at long-term, persistent problems for non-scienter violations. An example is Rule 20642, more commonly known as the custody rule. The custody rule requires registered investment advisors to safeguard client funds and securities. The rule is designed to protect assets from misappropriation, misuse, or loss, as well as from an advisor's own insolvency or bankruptcy. The rules provide definitions of what constitutes custody and how advisors must comply. Another example is investment advisors or others routinely failing to file required forms with the SEC and not remediating. Filing is not only these firms' legal obligations, but these forms provide the agency and others with critical information to investor protection and oversight, market integrity and transparency, and capital information. It's also important to be accurate and truthful in these disclosures. We recently brought settled charges against a Michigan-based registered investment advisor, Advance Capital, for causing its former client, a previously registered investment company, Advance Capital One, or ACI, to include materially false and misleading information in ACI's application with the Commission to deregister as a registered investment company. The filing failed to disclose the existence of pending claims in certain class actions, which Advance Capital later collected after ACI disbanded. So these are some of our priorities, recent actions, and takeaways. And with that, I will turn it back to Pei.
Thanks, Corey. And now we'll hear from Joe Sansone for updates and priorities in the Market Abuse Unit.
Hello. So as Pei mentioned, I'm Joe Sansone. I'm chief of the Market Abuse Unit. And if you've attended these events before, you know that there's perhaps somewhat of a competition among the units. So when Corey talks about the great staff of the AMU, I feel like I'm obligated to give a shout out to the MAU staff who have done amazing work over the course of the last 15 years or so, helping to protect the U.S. markets. And that really is the focus of the Market Abuse Unit, to root out fraud and deceptive activities in the U.S. securities trading markets. Over the years, we've brought a wide array of cases involving manipulation, both by injecting fake information into the markets, as well as deceptive trading practices like layering and spoofing. We've brought cherry-picking cases similar to the case that Corey discussed. We've brought front-running cases, a practice whereby traders trade in advance of large trades by asset managers to get the impact or the benefit of the impact of those trades, as well as, of course, insider trading cases and hack-to-trade cases. I think all of these cases that we focus on are consistent with some of the themes that Pei talked about in terms of protecting investors, in terms of scienter-based charges, in terms of individual accountability, and also a focus on foreign bad actors. And so I'll talk about a few cases from last year. These are really no way to cover all of the work, but some exemplary cases involve a manipulation case against a Florida-based trader who engaged in a spoofing scheme to manipulate thinly traded stock and made over $380,000 over about a year and a half. A cherry-picking case that involves two different investment advisors at the same firm who independently engaged in a preferential allocation scheme whereby they allocated winning trades to themselves and losing trades to their clients. Again, this is very important a case and very consistent with the theme of protecting investors. In that case, we alleged that one of these investment advisors made over $1 million allocating winning trades to himself, and the other made over $5.3 million over a multi-year period. So the numbers really do add up. Another case from last year was a case against a UK citizen, again, consistent with the focus on foreign bad actors, who engaged in a hack-to-trade scheme whereby he gained access to at least 5 different companies and used information from executives' emails to trade in advance of 14 earnings announcement, making over $3.75 million over a 20-month period. And finally, an insider trading case also involving foreign traders that generated $17 million in illegal profits over an 8-year period. This, like many of these schemes, involved burner cell phones and lots of coded messages whereby the traders referred to their burner phones and SIM cards as shoes and socks. The reason why I mention these cases is because they all involved months, if not years, worth of trading. And the key to detecting these cases and unraveling them was data analysis that our unit does. And I think these cases really show the success of that data-driven approach to investigating cases. And we expect to do the same in the future. Of course, the fact that we focus on these types of long-running schemes does not mean that the SEC will not investigate more isolated incidences of market abuse. This is, I think, very clear from the insider trading cases that we've brought over the past year or so. These cases have focused on a wide array types of events, including M&A events, earnings events, FDA and drug trial announcements, both positive and negative, as well as strategic partnerships and spin-offs. And it's important, I think, to note that when we bring these cases, we really are looking up and down the corporate ladder. These cases include the chairman of public companies, as well as much lower ranking employees. In one case, we sued the chairman of a public company for trading in his relative and friends' accounts to take advantage of information that he knew about an upcoming merger, and made $415,000 for his relative and friend, abusing his position of trust in that company. In another case, a less senior employee who was the director of finance at a pharmaceuticals company traded during blackout periods to take advantage of information that he knew about the expedited treatment by the FDA of a drug application by his company, and made $42,000 by trading on that information. So these cases really do span a remarkable degree of responsibility and sometimes profits, but we think that all of these cases are important. These cases are important not just to protect market integrity, but also because these individuals play an important part in the life of our markets. Namely, they serve on boards of directors, they serve in accounting and auditing functions within companies. And finally, I'll mention another case that involved, sadly, a regulator, an individual who worked at the Federal Reserve Bank of Richmond, who used information that he obtained by being a bank supervisor to trade on at least 2 different earnings announcements of banks that were under his supervision, and made approximately $580,000 trading in these events. So again, these cases are important because they involve individuals who play important roles in our financial markets, whether that be as chairman of companies, in the finance departments of companies, or as regulators. Finally, if I have maybe a couple of minutes, I just want to mention very briefly kind of a trend that we're seeing in the markets, which is that in prior events like this, we've noted that with the increased telework that the pandemic brought, that there was likely an opportunity for people to get hold of material non-public information through proximity to spouses and other people who are working in the same homes. And I think, sadly, we've seen that continue. And over the past year, I can think of at least 3 different cases where this pattern reemerged. And so I won't go into the details of the cases, but I'll just mention one in particular that involved a Texas man who made over $1.7 million trading on information about an upcoming merger that his wife was working on. This, I think, is a particularly noteworthy case because in addition to the SEC case, there was also a parallel criminal case, and this individual was sentenced to 2 years in prison. So I do regard this as a sad development, but hopefully the SEC bringing these cases will shine a light on this problem and cause companies and their employees to safeguard material non-public information, and should be a serious warning to spouses or domestic partners or others who would misuse that information. And I'll turn it back over to Pei. Thanks.
Great. Thanks, Joe. And now we'll hear from Rebecca Olson on the Public Finance Abuse Unit.
Thank you, Pei. It's my pleasure to provide some background and updates on the priorities of the unit. So the Public Finance Abuse Unit is a national specialized unit with members located in the home office here in Washington, D.C., as well as 6 of the regional offices. The very talented and dedicated members are mostly investigative staff attorneys, but we also have 3 very experienced market specialists. Our work generally relates to the $4.2 trillion municipal securities market. So state and local governments issue debt securities referred to as municipal securities or municipal bonds to borrow money and finance a wide variety of public projects important to our everyday lives. These include essential infrastructure and local and regional economic development projects. There are approximately 50,000 state and local issuers of municipal bonds, including states, counties, cities, towns, villages, school districts, and charter schools, just to name a few. Municipal bonds are largely held, over 2/3, by retail investors. Our unit priorities include, consistent with the themes highlighted by Pei and my colleagues on the panel, the protection of these retail investors, as well as the protection of the municipal issuers and their taxpayers. I will briefly highlight a few recent actions in the area of offering and disclosure fraud and municipal advisor misconduct. In April, we filed civil action against 3 individuals for allegedly creating false documents that were provided to investors in 2 municipal bond offerings for one of the largest sports venues of its kind in the United States. In August 2020 and June 2021, an Arizona state entity issued approximately $284 million in municipal bonds for the benefit of a nonprofit company, Legacy Cares, to finance the construction of a multi-sports park and family entertainment center in Mesa, Arizona. Investors were to be paid from revenues generated by the sports complex. Investors were given financial projections for revenue that was multiple times the amount needed to cover the payment on the bonds. However, we allege the defendants fabricated or altered the documents forming the basis for those revenue projections, including letters of intent and contracts with sports clubs, leagues, and other entities who were going to use the sports complex. The sports complex opened in January 2022 with far fewer events and much lower attendance, and generated tens of millions less in revenue than expected under the false projections. The bonds defaulted in October of 2022. The nonprofit Legacy Cares subsequently filed for bankruptcy, and according to the bankruptcy filings, investors recouped less than $2.5 million of the $284 million they had invested. This case is an important example of our commitment to protect both retail investors from fraud in the municipal securities market, as well as municipal issuers. In this case, it was the nonprofit borrower of the municipal bond proceeds, not the issuer that engaged in the alleged fraudulent activity. In the municipal advisor space, I wanted to mention 3 recent actions, just to briefly highlight what we're doing in this area. Notably, all 3 of these actions relate to the charter school sector of the municipal securities market. We settled 2 actions last August and November, respectively, each with a firm and an individual who engaged in unregistered municipal advisory activity. One order found a firm and its partner both failed to register as a municipal advisor and failed to disclose material facts about the firm's registration status to 4 charter school clients and 6 municipal bond offerings. The second order also found a firm and one of its partners failed to register as a municipal advisor and provided municipal advisory services to 8 Minnesota charter schools in connection with 8 bond offerings. These cases are important because the Commission regulates municipal advisors to protect municipal entities, including charter schools, from potential abuses such as undisclosed conflicts of interest, advice rendered without adequate training or qualifications, and placing their own interests ahead of their client interests, all of which could cause harm to a charter school, including but not limited to increasing the financing costs. In addition to the enforcement proceedings, to help raise awareness regarding unregistered municipal advisory activity in this sector, we also partnered with our colleagues in the Office of Municipal Securities to put out an informational bulletin on what charter schools should know know about municipal advisor regulation that's available on the Muni Office's homepage. The third matter was an October settled action against a registered municipal advisor and one of its principals for failure to timely and fully disclose material conflicts of interest to charter schools and the firm for violating its fiduciary duty. According to the Commission order from September 2017 to at least April 2022, the firm and its managing director provided advice to certain charter schools on the issuance of muni bonds totaling over $500 million. In each of these instances, an affiliate of the firm, a registered investment advisor, purchased either all or a substantial portion of the bonds, and in most instances, that affiliate also acted as a compensated bondholder representative. The affiliate relationship created the material conflict of interest that was not timely disclosed to the charter school clients until several days or sometimes weeks after they began providing advice on the bond issuance. When conflict disclosure was provided, it was inadequate. It did not describe the nature, implications, or consequences of the conflict or how the firm plans to manage them. Again, this matter underscores the importance of the municipal advisor registration regime to protect municipal investors from conflicted advice. And with that, I will turn it back to Pei.
Thank you, Rebecca. And now I'll turn it to Eric Werner to talk about the Complex Financial Instruments Unit.
Thanks, Pei, and I appreciate the opportunity to be here and to be on this panel and to be a part of the, I would say, reasonably friendly competition between the specialized units. But in the fairly short time that I have been unit chief, it has become readily apparent to me that I did inherit the best of the units. And I want to tip my cap to all of the CFI staff in the home office and across 5 regional offices for being so welcoming and for getting me up to speed on their docket of incredible investigations. So thank you all out there if you're watching. So CFI is focused on the proactive identification and investigation of potential securities law violations arising from the creation, rating, sale, use, and valuation of complex financial instruments, including security-based swaps, mortgage-backed securities, asset-backed securities, structured and exchange-traded products, as well as derivatives and other complex products and trading practices. If the investment has an acronym, there's a good chance that it falls under CFI's purview. RILAs, ETFs, ETNs, CFDs, CLOs, CDOs, you get the picture. That is what CFI is looking at. So the unit seeks to maximize efficiency by using tailored investigative techniques and quantitative analytics with the goal of obtaining meaningful remedies that hold entities and individuals accountable. The thing about CFI is that it strives for, and what may differentiate CFI from the other units, is that it strives for early engagement in its investigations. The unit is looking for the right results as quickly and efficiently as possible. And some of the tools that the unit employs to achieve that are things like reverse proffers, the request for counsel presentations, and the request for white papers early in its investigations. The unit and its staff wants to figure out, A, what we don't know that we might learn about that will impact how we go forward in our investigation, but also to let defense counsel and those who we are investigating understand what we're looking at and why we're looking at it. That early engagement has brought to completion many investigations, probably months, if not years, before they otherwise would have had we followed the normal course of getting some documents, maybe getting a formal order, getting testimony, going through documents again, back and forth like that. We want to go forward as quickly and efficiently as possible. The unit is looking for and rewards meaningful cooperation. I think you'll hear a little bit more about that when Jamie comes up next. But the unit itself is willing to and often engages in creative resolutions in wrapping up its investigations. Just because certain facts exist and have been handled a certain way in some investigations and enforcement actions doesn't necessarily mean that that's what the unit has to do with the facts in front of us right there. So we engage with defense counsel and want to understand not just what happened, but how we can be impactful through enforcement actions with the marketplace. The unit monitors new, novel, and developing product areas and focuses on cases, initiatives, and resolutions that have a high impact on the market and industry practices. What may be surprising, given CFI's focus on complex products, is that over half of the CFI docket involves retail customers, aka Main Street investors. Billions and billions of dollars of complex financial instruments are offered and sold to Main Street investors every single year. A good example of how this comes through CFI's work, it can be seen in enforcement action that the unit filed against First Horizon Advisors in September 2024 that involved violations of the compliance obligations of Regulation Best Interest relating to the recommendation of structured notes to retail customers. The settled order found that First Horizon, a broker-dealer, failed to maintain and enforce policies and procedures reasonably designed to achieve compliance with Regulation Best Interest. The settled order found that a group of registered reps who joined First Horizon through a merger did not have accurate customer information necessary to review structured note recommendations for compliance with Reg BI, and did not have access to the firm's exception reporting site to review structured note transactions that were flagged as non-compliant. Finally, the order found that the firm approved structured note recommendations without all documentation required by its Reg BI policies and procedures. I think this action highlights not just the importance of having appropriate policies and procedures in place, but making sure they are consistently enforced throughout the firm. Another action, recent action worth noting, was filed by the unit in January of this year against BMO Capital Markets Corp. For its failure to supervise employees who sold $3 billion worth of mortgage-backed bonds using metrics that were misleading and that did not accurately describe the collateral underlying the bonds. The settled order found that BMO representatives structured mixed collateral bonds backed by pools of residential mortgages using a small sliver of higher interest mortgages in a way that caused the systems of third-party data providers to generate inaccurate information about the bond's overall composition. BMO and its staff and its employees then sent those misleading metrics out to customers, even though they knew or should have known that the metrics were misleading. The order also found that BMO did not have a process for reviewing the type of information that firm representatives shared with customers about the bonds, or have a process for reviewing bond structures against marketing communications. BMO agreed to settle the action by paying over $21 million in disgorgement and prejudgment interest and the payment of a $19 million civil penalty. Those funds, the Commission established a fair fund and returned those funds back to injured investors. So CFI right now, I think as you look at the markets and part of, I think, the value of the Complex Financial Instruments unit is trying to be proactive and understand not just what the risks are to investors, but what products are being rolled out and could present new risks that we don't quite understand. And this is where some of the specialists in the unit come to bear, reading through news articles and interfacing with the marketplace. Obviously, retail investors will continue to be of primary importance for the unit, which dovetails with the priorities that the Division of Examinations rolled out in its priority list for 2025. The exam priorities list included a focus on Reg BI, with a particular focus on products that are complex, illiquid, or present higher risk to investors, including structured products. Exams also put out a risk alert in 2024 dealing with security-based swaps dealers. The risk alert highlighted several observations from examinations that took place in 2022 and 2023 and noted deficiencies in business conduct standards, record keeping, and reporting. CFI will communicate with exams and keep an eye out for adherence to relevant securities-based swap dealer rules. A few other areas of focus for the unit going forward into 2025, the collateralized loan obligation market, which is nearly $1 trillion. News articles are indicating that default rates have been increasing over the last few months. So something that we want to keep an eye on for and make sure that the market understands and accurate information is being disclosed to investors. The private credit market, another $1 trillion market. Investors who are looking for an asset market class, but recent reporting has questioned the strength of the assets underlying those products. Commercial mortgage-backed security market, over or nearing $1 trillion market itself there. Recent reporting indicates an increase in troubled CMBS loans as well. So just areas that are not potentially ripe for investigation, but where the unit wants to keep its eyes open for and make sure that we are understanding and assessing relevant risks to investors. And with that, I will turn it back to Pei.
Great, thank you, Eric. And finally, we're going to hear from Jamie Marinaro, who's going to give us some updates and thoughts on process and remedies.
Good afternoon. I know it's been a long day. Thank you for sticking with us. I want to talk briefly about process and remedies going forward. Transparency is going to be very important to the commissioners and to the Division of Enforcement going forward. Access to the investigative file from the defendant's perspective or respondent's perspective. In 2008, Chairman Atkins wrote an article advocating that prospective defendants have greater access to the SEC's investigative file. In his views in that article, the sharing of information promotes the goal of fact-finding, which is paramount to due process and to the administration of justice. I would expect more common practice throughout the Commission of conducting reverse proffers and sharing key evidence, both favorable and unfavorable evidence, to allow defense counsel to understand what this key evidence is and any legal charges that are being considered by the staff. This will allow for a more substantive and meaningful response through the Wells submission process. There may be documents or evidence that we will be unable to share throughout this process based on countervailing law enforcement and privacy concerns or due to legal restrictions. The Wells submission process is where the staff lays out allegations and evidence so defense counsel can appropriately respond to the Wells notice. I would expect going forward that senior leadership will take meetings from defendants, whether that be at the associate director level, the deputy director level, or even the director level. While working on Commissioner Ueda's staff over the past 2 years, I've heard a lot of complaints from defense counsel that commissioners may not be reviewing Wells submissions. I can say Commissioner Ueda reads Wells submissions, Commissioner Peirce reads Wells submissions, and based on writings by Chairman Atkins and based on Commissioner Gallagher's statement this morning, it's very clear that Chairman Atkins will read Wells submissions. He believes, Chairman Atkins that is, believes that these submissions are extremely important in telling the other side of a story and in making a determination of whether the recommendation being made is appropriate. I would anticipate that even where there are settled actions, that the commissioners will continue to scrutinize these Wells submissions to ensure that there are actual violations of the law and that the settlement is not merely a result of trying to cut short an investigation or to make something go away. I think each and every one of the commissioners want to make sure that the settlement or litigated action is in fact the right answer. With regards to cooperation, remediation, and self-reporting, I just want to highlight Chairman Atkins' law review article that he wrote with Brad Bondi. Chairman Atkins made clear in this article that he does not believe that any cooperation credit should be given to prospective defendants, particularly corporations, for waiving attorney-client privilege and work product protections. In his view, giving credit for waiver is equivalent to punishing those who do not waive the privileges. Decisions on whether to waive should not be rooted in believing that this will result in any additional cooperation credit. Remediation and self-reporting will continue to be important considerations for the staff, not only on whether to bring an action, but also related to what remedies are requested in the settlement. I would expect more public declinations and decisions not to pursue enforcement actions where there is self-reporting and complete remediation. I'd like to talk a little bit about remedies. We've seen a move to more settlements being in front of Article 3 judges as opposed to in front of administrative proceedings. This has been a shift post-Jarkissi. Each of the commissioners and the chairman are thinking carefully about what Jarkissi means for our administrative proceedings. Just recently, Chairman Atkins announced that Commissioner Crenshaw will assist him in looking at the SEC's administrative law framework and procedure. And Commissioner Ueda spoke yesterday about his views on administrative proceedings and what those should look like post-Jarkissi. In addition to the article written by Chairman Atkins and Brad Bondi, there is a 2006 statement on penalties that I think will continue to be very important as we look into the next few years. The two most significant factors in determining whether there should be a corporate penalty are, one, the presence or absence of a direct benefit to the corporation as a result of the violation, and two, the degree to which the penalty will further harm shareholders. Penalties against corporations, in Chairman Atkins' view and in Commissioner Ueda's view, can harm shareholders. When the Commission obtains penalties from a corporation, there is always one group of shareholders that must pay. The Commission is taking from one group of shareholders to recompense another. Large corporate penalties are paid by the corporation's current shareholders and result in adverse consequences to the company through depletion of assets. If and when disgorgement is difficult to calculate and where shareholders ultimately benefited, corporate penalties may be appropriate to reverse the ill-gotten gains. However, corporations do not act, individuals do, and Chairman Atkins has previously questioned whether corporate penalties are an effective means of deterrence. If wrongdoers have little concern for the corporation when they commit fraud, it is doubtful, in his view, that their behavior will be altered by the threat of a corporate penalty on the company they are seeking to victimize. When not a public issuer case, we will look to the tier penalty analysis, especially in an administrative proceeding, or the tier penalty analysis or the amount of pecuniary gain if settled in front of an Article 3 court. And in the last couple of minutes, I just want to talk about bars and suspensions, including CBIs. Officer and director bars going forward will be more thoughtfully applied when you have an officer or a director who committed the violations and or an individual who is seeking to be an officer or a director in the future. I think that you'll see officer and director bars being used. Associational bars and suspensions, including through CBIs, are all supposed to be remedial and not punitive, and I think you'll see that thought process going forward as we seek to apply them in specific cases. Other than suspensions, which are 12 months or less, these are intended to be permanent. Qualified or time-limited bars, which can be negotiated in a settlement, give the defendant a right to reapply after a certain amount of time. Historically, the readmission of individuals was only granted in extraordinary circumstances. The Commission recently stated in Denha that it is in the public interest to allow barred individuals to re-enter the industry if their individual circumstances demonstrate rehabilitation and increased risk controls that prevent recidivism, and stated that the Commission will no longer use the extraordinary circumstances test in evaluating reentry applications. The Commission has recently granted reentry applications and reinstatements, including for associational bars, penny stock bars, and for accountants barred under 102E. In the Commissioner's view, when there is a right to reapply, that is a negotiated right as part of a settlement. The defendants or respondents should have that right to reapply, and it shouldn't act as a permanent bar with no right to reapply. When I was working for Commissioner Ueda, when he was the acting chairman, I asked the staff to start looking at a process for reapplications and readmissions, and I understand from Sam Walden's speech earlier this morning, that there's new guidance on sec.gov as to how to go about submitting applications to reapply, and I would expect that those are continued to be looked at and granted where appropriate. Thanks, Pei.
Thank you, Jamie. And we are at 5:20, so I wanted to thank the panel, thank PLI for hosting us here, and thank you all for making it to the end of the conference. So thank you very much.
Just a quick thank you to all of our speakers for the past 2 days who participated. It really means a lot, as well as to our attendees who stuck with us. Be sure to sign out if you want your credits when you leave today. Thank you.